Well, 14-day district court, state of Michigan is now back in session. We are on today's
You may be seated. Court does call the case, People versus Victor Bullard.
Ashley Longy for the people. Assistant Public Defender Natalie Pate with on behalf of Mr. Victor Bullard, who stands to my right. Please state your name for record, sir.
Victor Bullard.
Thank you, sir. All right. Date and time set for trial. Are we ready to proceed?
People are ready to proceed. We would move for sequestration. I'll note for the record, my officer in charge is sitting at the table with me, but I only have one anticipated witness who is currently on the program.
All right. Court would grant the motion to sequester. Are there any potential witnesses for the defense other than the defendant?
No, Your Honor.
All right, very good. That is satisfied. You may go ahead.
Thank you, Your Honor. With defense's consent, I'd also waive opening at this time.
Any objection?
No objection, Your Honor, and defense would also be waiving opening at this time.
All right, fantastic. Thank you.
Ajane Bullard.
All right.
She stepped out for just a moment, Your Honor.
Say she stepped out.
Restroom, Your Honor.
Got it.
Yeah.
Got it.
Yes, both for me.
Got it. Please come forward and be sworn.
See, raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
See, state and spell your first and last name for the record, please.
AJANAEBULLARD.
And that's on Janae Bullard? Yes, thank you. May inquire.
Ajane, do you have a nickname you go by?
Yes.
What's that?
Asia.
Okay. Is it okay if I call you Asia?
Yeah.
Asia, we are making a recording, so when we say things like, they don't really come through on the recording, so we may ask you just to confirm if your answer is yes or no, okay? Asia, how old are you?
17.
And how old were you on May the 12th, 2024?
15.
Where do you live?
4695 Ashford.
Do you know what township that's in?
Pittsfield.
And what county? Okay. Your Honor, would the court take judicial notice that Pittsfield Township is in Washtenaw County?
Yes, court will take that judicial notice.
Thank you. Do you know somebody by the name of Victor Bullard?
Yeah.
Who's that?
My dad.
And do you see your dad in the courtroom today?
Yeah.
Can you tell me where he's sitting and what he's wearing?
Wearing a gray suit.
And where is he sitting?
He's sitting right there.
Your Honor, may the record reflect witness identify the defendant.
That objection record shall so reflect.
Asia, on May 12th, 2024, were you at your house?
Yeah.
And what was going on that day when you got up?
So it started out normal. We do chores every Sunday.
That was a Sunday?
Yeah.
All right. What happened when you were doing your chores?
So my chores is clean the bathroom. That's what I did. And so my dad was gonna leave to go to his mom's
Why was he going to his mom's on that day?
because it was Mother's Day.
And when your dad was going to leave, what happened?
We got into an argument because I had asked my TV back because he was going to be gone for more than a day. So I had asked for that.
Had your TV been taken away?
Yeah.
What TV was this?
My TV.
Where, it's in your room? Who bought it?
My mom.
Why did you want your TV back?
Because I had had it for like months and months and months.
What did you want to do with it that day?
We were just gonna be alone, so like I wanted him to do
Who's we?
me and my siblings.
Where was your mom?
She was doing errands.
Does she live at that house too? Was she there when your dad was getting ready to go to his mom's house?
No.
Do you know where she was at that time? What happened after you asked for your TV back?
It's, escalated.
What do you mean it escalated?
We started arguing because we didn't agree on the reasoning why I got it taken.
And who is we? You started arguing. What happened next?
He was downstairs and I was upstairs and we were like arguing and he ran upstairs and it was like halfway up the stairs and he was yelling at me and
What was he saying?
it was just like we were just arguing about the reason why I just didn't have it.
What happened as you was going up and down the stairs?
He just looked mad and he looked angry.
What happened next?
Then he went back down the stairs and then he started back up the stairs. And then he came all the way up the stairs this time, like where I was. And then he just started yelling at my face
Where were you when that was happening?
right up in my room.
You have your own room?
Yeah.
It's on the second floor?
Yeah.
So he got in your face. What happened next?
I had like he was like so close to me, like he was like a couple inches away, and I was scared because I could feel him spitting in my face. And he was way taller than me, he's bigger than me, and I knew he had a gun on him. And
You knew he what?
he had a gun on him.
Okay.
Um,
Where was the gun?
and
In his pants? What happened after he got in your face yelling at you outside of your room?
he told me to go to my room, and so
Did you?
yeah, I quickly turned because I was scared. Because you know, it wasn't like the first time like he had gotten that like that.
So when you went in your room, what happened?
Then he quickly chased after me, and he grabbed me and he scratched my neck.
Where did he grab you?
He grabbed my arm. Both of them.
What happened next?
I said, "Why are you trying to hurt me?" And then he left.
Did you end up calling the police?
Yeah.
And Your Honor, at this time, I'd like to admit into evidence what I'm going to mark as People's Exhibit 1, which is the 911 call. I believe it will be stipulated.
That is correct, Your Honor. I did talk to Ms. Lonnie.
All right.
Right.
Exhibit 1, the 911 call is admitted.
Permission to play for the court?
Yes.
Washington on 911, where is your emergency?
Hi, my name is Asia Bullard, and I'm at 4695 Ash Court. I'm calling because my dad put his hands on me, and he was yelling at me.
Okay, what's the address?
4695 Ash.
Is that ASH?
Yeah.
Okay, and you're in Pittsfield?
Yeah.
Okay, how old are you?
I'm 15.
When did this happen?
So it's just now.
What's his name?
Victor Lawyers.
How do you spell the last name?
Bullard.
Spell the name.
I think he's like 54.
Okay. And what kind of vehicle do you live in?
He left it.
What color? And what was your name?
Asia Bullard.
What's your phone number, Asia?
734-596-1646.
Okay. So you said he hit you? What did he do exactly?
He grabbed my arm, scratched me, but I didn't.
This is about work argument.
Yeah,
Okay. Do you live there with him?
yeah,
Okay. Then you live there with anybody else?
yeah, that's my previous vision.
Are they home?
My mom was someone taking us to the airport and my other sibling at home, he said he's an adult. So he
Okay. Okay. All right. Any weapons used or involved?
He had a gun in his hair, like,
Did he have an alcohol though? Is it still on him?
I think so.
Is it an holster?
I'm not sure.
Okay, when you say he had it in his pants, did it like in his pocket, was it clipped on
I think it was like in his hand, my hand.
or? Okay. Okay. All right. Do you need any medical attention?
No.
Was he drinking or under the influence of any narcotics are you aware of? Okay. All right, let someone come over and talk to you, okay? If he comes back or if there's any other issues before we get there, call us back, all right?
Okay.
All right, thank you.
All right, bye.
Bye-bye.
Asia, you mentioned that some of your siblings were home when this happened. Is that right?
Yeah.
Did you have a chance to review a video that one of your siblings made?
Yeah.
And that video, Your Honor, for this time, I'd ask permission to enter People's Exhibit 2, which is the video from the sibling. I believe it will be entered by stipulation as well.
That is correct, Your Honor.
All right. Exhibit 2 is admitted.
And Asia, when you reviewed this video, it didn't show anything, correct? But what did it have on it that was relevant to what happened that day?
The audio of the incident.
The audio of it? Okay. You have permission to do,
Yes.
sorry, it clipped the beginning a little bit. I'm gonna go back. Apologize. Asia, did the police come to your house on that day? Did you talk to them?
Yeah.
Did they take any pictures of you? What did they take pictures of, if you remember?
They took a picture of my scratch and with my door.
Why did they take a picture of the door? Had it been broken before? A little bit? And Your Honor, permission to approach the witness and the bench with what's been marked as Exhibit 3.
Is there going to be any objection to Exhibit 3?
No,
It's
Your
it's
Honor.
multiple pages. There are 3 pages for Exhibit 3.
Your Honor, at this time, I am going to object to part of Exhibit 3 that does have multiple photos. I do not believe a foundation has been laid.
Well, before you go on with that, there are 3 pages. Are you objecting to all 3 pages or?
No, Your Honor, I would not be objecting to the first 3 photographs that are shown in this exhibit.
Okay,
So the
I haven't
first-
seen it, so.
Yes. The first page and a half, I would have no objection to. The last page and a half, I would, Your Honor.
It's not making much sense to me. How many photos are on each page?
2, Your Honor. And I object to the first or the last 3 photos.
So I have a total of 6 photos.
Correct, Your Honor.
First 3 photos you have no objection to.
Correct.
The last three photos, you do have an objection to. And the basis for your objection is,
Lack of foundation. I believe that this may be rectified if these were two separate exhibits. They do have photographs of two separate things.
response.
Your Honor, the witness has stated that her door got more broken in this incident. Part of People's Proposed Exhibit 3 is photographs of the door taken by Pittsfield upon their response. I believe that if there are questions about how broken the door was, if it was broken at a later time, at an earlier time, those can be ample grounds for cross-examination, but I do believe the foundation is sufficient for the admission.
The basis for the objection.
The basis for the objection, Your Honor, is that the last three photographs or photos of the door and the testimony from the witness was that the door definitely was broken before. And I do not recall any
Well,
testimony.
that wouldn't go to admissibility, it would go to the weight to be given to the testimony. So objections overruled, exhibit is admitted.
Okay, here. Permission to approach still?
Yes.
Thank you. Copy for the first one. Asia, do you see People's Exhibit 3 in front of you? What do you recognize that first picture on Exhibit 3 to be, the top one? That's the scratch on your neck? Who caused that scratch? Did you scratch yourself to do that? How about the second picture? Can we go to the next page, page 2 of Exhibit 3? The top picture, what do you recognize that to be? Same scratch, of course. And the second photograph on page 2? How do you know that's your door? How was it broken before this incident?
It was like, there's like a little, it was like a little dented, but it's not bigger.
How did it get more broken?
My dad pushed.
Is that when he pushed in and went in your room?
Yeah.
And let's go to the last page. What do you see in the top picture there? How do you know that's your door? Do you recognize that?
Yeah.
When your dad pushed into your room, was he able to open the door all the way?
No.
How come?
There was something.
Is that in any of the pictures on page 3?
Yeah.
What's behind the door that was in the way? And that last picture that also shows the broken door?
Yeah.
Okay, Asia, you can stop looking at those now if you don't want to look at them anymore. Asia, how did you feel when your dad grabbed your arms and scratched your neck? Was he giving you any commands or any orders that you were disobeying at that time? Let me ask a better question. Was he disciplining you?
Yeah.
How?
He was not, I was, talking back.
He was mad that you were talking back, so he broke in your room and yelled at you and grabbed your arms and scratched you?
Yeah.
Was he, after this happened, did he stay? Where did he go?
He left.
He left his mom's house. And when you were at your house and the police came, was your mom there at any point?
No.
She came later. Asia, did you do this to yourself, the scratch mark? Do you have a moment, Your Honor?
Yeah.
I'll pass the witness, Your Honor.
Cross-examination.
Hi.
My name is Natalie and I'm an attorney for Mr. Bullard. So I have some questions to ask you. And I know this, I used to hate it when people would call me Miss Pate, still kind of do. Would you prefer for me to call you Miss Bullard or Ajane or Asia? Asia, okay, thank you. You feel free to call me Natalie. So I just have a few questions to ask you to follow up on your testimony. And if at any point my questions are either unclear or I'm mumbling, feel free to interrupt me and tell me to either rephrase, re-ask, whatever the case may be. So I'll turn right to the day of May 12th, 2024. You testified that you were 15 at the time of this incident?
Yeah.
And you and your dad before this day previously had some disagreements about some of his rules, correct?
Yeah.
You didn't like some of his rules surrounding when you could or couldn't use your TV?
Yeah.
And you didn't like some of his rules about when you could or couldn't go out and see your friends, right?
Yeah.
And you feel that sometimes your dad's a bit hard on you?
Yeah.
And then turning to the incident, you told the police that this interaction with your dad began that day in a verbal argument, right?
Yeah.
About his rules regarding that specific TV?
Yeah.
And you were mad that he wouldn't let you continue to have it in your room? And you did tell the police when they arrived that your dad did not threaten you at any time during this argument, correct?
I don't know.
And you told.
What was your answer to that? You don't know?
Wait, can you re-ask that?
You told the police that your dad did not threaten you at any time during this argument, correct? You told the police that your dad tried to grab you, correct?
Yes, he did.
And you told the police that your 3 siblings were present during this incident, correct?
Yeah.
But none of them saw anything?
No. And they're.
And you were the person who called the police that day, correct?
Yeah.
And that was at the encouragement of your older brother?
Yeah, he said it to do if I felt unsafe in my house.
That what?
He told me to do if I felt unsafe in my house.
But your dad had already left the house that day, correct?
Yes.
How old is your older brother at the time?
23.
Does he live there?
No.
Was he there?
Yes, he came after my sister showed the video.
After what?
He came after my sister showed me the video, and I called him because I was scared.
So he wasn't, so the first call you made was not to 911?
No,
The first call you made was to whom?
my brother.
And that was after he had received information, you believe, from someone else? Your sister?
What do you mean?
Well, one of your siblings sent the video that we saw. I think it's Exhibit 2, right?
Yeah, he didn't see that till he got there.
Okay, so prior to him, so your brother appeared after you called.
He was there while I was calling them,
What? While you were calling who?
the police.
Okay, but you called him first,
Yeah,
and that's why he came over.
yeah,
Okay, go ahead, Ms. P.
And your dad had already left the house at that time, correct?
yeah,
And when the police arrived, you declined medical attention, correct?
yeah,
And you knew that you could possibly get your dad in trouble by calling the police that day, correct?
yeah,
And you were pretty upset with him that day?
yeah.
And so now I have a couple of little odd questions. You typically do your nails, correct?
Yeah.
And you often wear them pretty long, correct?
Yeah,
Including fake nails or acrylics.
yeah,
And you often style your own hair as well?
yeah.
And then I have a couple follow-up questions about your testimony. So are you aware that your dad is a valid CPL holder? And you testified that he grabbed your arms, correct?
Yeah.
You did not testify that at any point he grabbed your neck, correct?
Yeah.
And you also testified that this door definitely was broken or damaged in some way before this incident, correct?
Yeah.
You're not listed on the title to the house, correct?
Yeah.
If you know, who is on the title to this house?
My dad.
So the owner of the door would be your father, correct? The door is not your personal property, correct?
No.
Okay. No further questions. Thank you. Thank you, Your Honor.
Did you have any follow-up? I said, thank you. The TV was in your room?
Yeah.
How, and at some point, it gets removed from your room.
Yeah.
How long before May 12th was it removed from your room?
A lot of months.
Pardon?
It was months.
Months?
I think it was close to a year.
A year? So why did it get removed from your room?
Because I had it on past 12.
Because you had it on past 12?
Yeah.
So was it a rule in your house that you weren't supposed to be watching it after midnight?
It was more like, it just like, so my TV goes off by itself.
Pardon?
My TV goes off by itself after like a couple hours of inactivity. And he got said that it would like run while sleeping for a little bit. And
Okay.
so he said not have on past 12 and then he,
So young lady, let me ask you this. Was there a rule in your house that you weren't supposed to have the TV on after 12?
yeah,
Okay. And at some point, it was on after 12. Regardless of the reason, it was on after 12.
Yeah.
And so from that, the TV got removed from your room.
Yeah.
Okay. And was that removed from your room by your dad?
yeah,
Okay. In this, let me ask you this. So you knew what your dad's position on that was, right?
yeah.
Without telling me what you said, did you go to your mother about that?
Yeah.
Did your mother put the TV back in?
No, she didn't have access to get it.
Okay. So this day, May 12th, a year, I guess, after the TV's been removed or whatever, what were you and your dad specifically fighting about?
Like what do you mean?
Well, something caused the argument between the two of you. What was the cause of the argument?
Because he was leaving and I had asked my TV dad.
Okay, so hold on. Those are sort of two things. Were you upset that he was leaving?
No,
Okay, were you upset at that point that you didn't have your TV?
yeah, and the reason that he was saying, because he kept adding on reasons like all the time. Like, it wasn't like the original reason that he took it.
There was no reason for what?
Like he like was saying the reason that he took it was a different reason than what he said originally, and that's what we were arguing about. That's why.
Okay, so just help me understand this. At some point, the TV gets removed from your room because it's on after midnight. Then at some point, I'm going to assume that this May 12th date was not the first time that you asked for your TV back.
Yeah.
And if I'm understanding you correctly, the times that you would ask, your dad would give you different reasons as to why the TV didn't come back in.
Yeah.
Okay. And when he would give you these other reasons as to why you couldn't have the TV, was that upsetting to you?
Yeah.
Okay. Just as a side note, was that the only TV in the house?
No.
So then this day you want the TV back, and what's your dad's response to that?
He said, no.
Okay. And I'm going to assume you didn't like that answer. Is that correct?
Yeah.
Okay. And so when your dad said no, what did you then do?
I asked why.
Okay. And then he responded back to your why, right? What did he say?
He said, because like I was like hanging out with my friend. It wasn't supposed to be.
Okay. So when you asked why, he said, and tell me if I'm wrong, because I'm trying to understand what you're telling me. He said it was also because you were hanging out with somebody that he did not want you hanging out with.
Yeah.
Was that? Don't give me a last name. Who was your friend?
He was just my friend.
Okay, I get that. Who was your friend? Name.
His name is Wade.
Okay, so,
We just went to the park.
pardon?
We just went to the park.
Was there a reason your dad didn't like this friend?
No.
Well, hold on. Let me rephrase that. Why do you think your dad didn't like that friend?
I think he didn't like it because he's a guy, but that's my little sister, he's no guy, so.
Okay, hold on a second. Hold on a second. So at the time you're 15 and your dad has told you not to hang out with this young man.
Yes. After.
Well, hold on. He had told you not to do that, right?
After the fact,
After what fact?
after doing out with him.
Okay. Okay. So at some point you're hanging out with this young man, right? Then your dad says, I don't want you hanging out with him. It's a yes.
Yeah.
And when your dad said that, how'd that make you feel?
They make me feel really included.
It didn't make you feel any way?
It just like, I mean, it felt like unfair.
Oh, okay. So it was unfair. So when he said now I'm going back to May 12th. So when he, being your father, said because you were hanging out with this person, what was your feeling?
I just felt like it was unfair because he let my sister do stuff like that and like hang out.
How old is your sister?
She was, I think she was like 11 at the time.
Okay. So she was 11 at the time and she was hanging around boys.
Yeah.
Okay, but you felt it was unfair that your dad wasn't letting you hang around boys.
Yeah.
So after your dad told you not to hang out with this boy, did you hang out with him? You didn't?
Not after that.
Not after that?
Not after the police got called and stuff.
Okay, hold on a second. Let's back up. At some point, your dad tells you not to hang out with this young man.
Yeah.
Okay. After that point, but before this May 12th day, did you hang out with that young man? Do you recall the date your dad told you not to hang out with that young man?
No, I don't.
But it was before May 12th?
Yeah.
Okay. So between the time of that and the incident on May 12th, where you called the police. Did you hang out with that young man?
Again,
Yeah. So when your dad told you not to hang out with him, you stopped.
yeah.
Did you tell your dad that on that date? On the May 12th, when he said it was because you were hanging out with this guy?
Um, yeah, I think so.
What do you mean you think so?
Cause I think I said like, I hadn't hung out with him.
What was your dad's, if you said that, what was your dad's response to
He
that?
said that's the minute, so that's fine. He said he wants to talk about it when he got back from his mom's.
So he said he wanted to talk about it after that?
Yeah, after he got back.
What?
After he got back from his mom's, he said he was talking to me about it later.
Okay, so at the point he tells you about this young man on the May 12th, at some point, he then tells you, basically, I'm going someplace, but we will talk about it later.
Yeah.
Did that upset you? Okay, so I hear, when I listen to the video, I hear, no, that's you yelling back at your dad, right?
Yeah.
What were you yelling back at him about?
I was asking for my TV because basically I was paying a subscription. And I was just going for like,
You were what?
I was paying for a subscription for my Xbox and it was going for like a long time. I haven't had my TV in a while. And so I was upset that I was also paying money and I couldn't even
So were you working at the time?
know.
Okay. So you had a subscription. Were you paying it?
Yeah.
From where?
I was like, I just asked my mom for money
Okay, so, all right.
or like went and worked like by doing like little side hustles, like babysitting. So my money was very like, I didn't like have a lot of things.
Right, but got it. I won't get into that. So at some point, your dad's leaving, you're there are words being exchanged. Where are you when this argument takes place? Is your room upstairs or on? Okay, so where are you guys downstairs when it first happens?
No, I was in my room.
Pardon?
I was in my room and he was like going up and down the stairs, getting ready to go to the mom's.
Okay,
But I like stayed in my room the whole time.
you did not.
I stayed in my room the whole time besides when I went to the hallway.
Okay. When you went to the hallway, you and your dad are yelling at each other?
Yeah, he was like on the stairs and then we went down the stairs and then he ran up the stairs halfway because our stairs like.
Okay, so when he went downstairs, what do you think caused him to come back upstairs?
Maybe didn't like something he heard and that made him
Okay, he didn't like what he heard. So what was he hearing?
just arguing about,
What were you saying, young lady?
I don't remember exactly.
Okay, let me ask you this. You don't remember specifically what you were saying?
Yeah.
Were you saying things that maybe your dad thought were disrespectful?
I don't think necessarily.
Okay. Were you saying things to your dad that you knew would get his attention?
I think I was saying what I felt and how in my truth.
Okay. But you also knew, correct me if I'm wrong, you can tell me I'm wrong. You knew that as you were saying those things about how you felt in your truth, you knew that was not gonna sit well with your dad.
Yeah, he doesn't like anyone that disagrees with him.
So at the time that you're saying those things, you knew that was gonna get a reaction.
Not like that.
Well, didn't ask that. You knew that was going to get a reaction.
Somewhat.
And that's when he came back upstairs.
I didn't do it for reaction, I did it for.
I didn't ask you why you did it. I'm saying you knew it was going to get a reaction of some type, whether what your motivation was, you knew it was going to get some reaction, right? And then at that point, that's when he came back upstairs. Okay. So how did he arrive at your door?
So after he went upstairs, he went back down and then he started back up again, all the way to my door.
Okay, so when he went back down and then you say he darted back up, did you say anything at that point?
Yeah,
What did you say?
when he was at my door.
No, no,
Or when,
something caused him to come back up. Did you say something and then he came back up?
we were just continuing arguing. So.
What were you saying during that argument?
I don't remember. Like,
You don't remember.
specific.
You can remember everything he said, but you can't remember what you were saying?
No, I just remember like in general what it was about.
And what was it about that you were telling him?
I was just like, why can't my TV back? It's been a long time and that I don't hang out with that guy anymore. And it's unfair that you let my little sister that's younger than me, and I'm about to turn 16 in like a few weeks, and like, she can do what I can't.
But those are all things you said before, right?
Yeah, I'm just like, it was like a continuing argument.
Okay, were you yelling?
I was like talking normally at first, and then
At the point, okay, let me be specific. At the point he went back downstairs before he, as you say, darted back up, were you yelling?
I don't think,
You don't think you were yelling?
I think maybe like slightly raised, but I don't think.
Slightly raised, but not yelling. Okay. And then he got back up the stairs and he's at your door.
Yeah.
So when you're at your door, or you're in your room at that point.
I was, when he came up the stairs, I was in the hallway.
Okay. So he comes up the stairway, you're in the hallway. So when he comes up the stairway, there's a landing, I presume, or the hallway,
Yeah.
right? When he gets to that landing, where are you?
I'm in front of my door.
You're in front of your door.
Yeah.
Okay. And I'm presuming that the two of you are still engaged or talking or yelling at each other.
Yeah.
Right?
Yeah.
Then at some point, you what, go in your room?
He had to let me go to my room.
What?
He had to let me go to my room.
He told you to go to your room.
Yeah, like right in front of my face.
Pardon?
When he was like right in front of my face.
He told you to go to your room.
Yeah, and I turned.
At the point he tells you to go to your room, had he laid a hand on you?
No, but he looked like he was going.
Didn't ask that. He hadn't laid a hand on you. When your father told you to go to your room, did you go right to your room?
Yeah, I turned really quick and I went to my room. I didn't touch him or anything. I was too scared, so.
So when he told you to go into your room, you went into your room. What's the next thing you did at that point?
So I went to my room and then he chased in right after me. And I tried to close the door because he like, it just scared me. And,
Did you get the door shut? Did you get the door shut?
no, not fully. My door didn't latch closed, so.
So young lady, I'm trying to figure out. I'm looking at. I want to show you, and council, I'm referring her to page 3 of exhibit 3. I want to show, oh, you got it? Okay, you got one in front of you. Look at page 3. Right? I see a latch missing.
Yeah.
You see that?
Yeah.
So if you're, again, I'm going based on what you're telling me. If your dad is at the door, you're trying to close the door, but it doesn't close. How'd that latch get damaged?
I had my sibling had done it a while ago.
Okay, so the latch isn't in the door.
Yeah.
Okay, so looking at that, tell me what damage your dad did to the door, I'll call it, on that day.
It's like the big, like, in
The big indent.
Yeah.
What big indent?
like the part where the door is like broken, like on the, like actually.
Point at it for me. Oh, on the front of the actual door. So the latch, he didn't break.
Yeah.
And council, she's pointing to, I guess it would be page 2. The circle.
Four, Your Honor.
Pardon?
Photograph 4 of exhibit.
Yeah, I guess we can call it that. And so it's that little crevice in the door. How do you think he did that? He's obviously on the other side, right? So how do you think he did that?
Well, because I was on the other side and when I shot, when it shot with my body weight and he
So let me get this right. He's on one side of the door, may have some part of his body on the front part of that door, because it's what's called a hollow core door. So he's on that one side. You're actually pushing on the back side of that door.
Yeah.
So it's not like he kicked the door. He's just against the door.
Yeah, he's pushing it like his whole.
So wouldn't you agree that both of you caused the damage? Because hang on, and here's the reason I'm asking. If you're not pushing on the one side of the door, but he's just pushing on the side he's on, according to you, that damage doesn't happen, right? Because he's just able to come right in.
I mean, like what do you mean?
The only way that door gets damaged on that side or at all is because there are two forces pushing on that door. Your dad from the outside and you from the inside, right? So it's not like he came up to the door, he kicked it, or it was locked and he kicked it to get in or anything along those lines.
No.
Okay. So he gets into, so at some point, does he get into the room?
Yeah.
At the point that he gets into the room, what's happening at that point? Are you still yelling at him? Or are you guys yelling at each other, I should say?
Well, I was, he like grabbed me. You know, I said, why are you trying to hurt me? Because he was obviously like he was trying to do something. And
What do you mean he was trying to do something?
like, I feel like he was trying to hurt me.
Really?
Yeah.
So let me ask you this. I'm looking at your dad and I looked at you walk up. Young lady, if your dad really wanted to hurt you, he could have hurt you. Right?
Yeah,
That's not what happened. Right?
what do you think?
I think you know what I mean. If your dad really wanted to hurt you, he could have hurt you.
Yeah,
And that didn't happen.
I mean, it did hurt. He looked like he was like trying to stop.
What?
It looked like he was trying to do something. It looked like he just like couldn't control himself.
What do you think he was trying to do?
I think that he was trying to like, grab me and like do something, but I didn't let him. So I tried to.
Why were you yelling at your dad?
Because he was yelling at me first.
When he told you to go into your room, how'd that make you feel?
I was scared, so I just did it. And I didn't say anything. I just tried to move it.
But how'd you feel when he told you that? Hmm?
Like I don't know.
Let me ask you this. Are you the oldest daughter?
Yeah, perhaps.
Yeah. And because kids think this way. Did you think maybe your dad or maybe your parents both were showing your younger sister a little bit more favoritism than you? Yeah. And that hurts, doesn't it? Yeah, it does. And sometimes you kind of want to let them know that, right?
Yeah.
I mean, you want to let them know that I feel like I'm not being treated fairly.
Yeah.
You and your dad fight a lot.
Yeah, we argued.
Yeah. Um, you're 15 at the time, right?
Yeah.
Your sister's 11. Yeah. You seem like a pretty bright young lady.
Yeah.
Whether it be right or wrong, can you think of any reason why your dad might be a little bit more suspect or careful about boys you're hanging out with as opposed to your sister?
Maybe because they're older.
Mm, and what's that mean?
I don't know.
Yes, you do. That's okay. You don't have to say it. You know, right?
It was just my friend.
I get that. That's what you're telling your dad, right?
But she was also hanging out.
Hold on a second. That's what you're telling your dad.
Yeah.
When you would tell your dad that, and I'm not only a judge, I'm a dad too. So when you're telling your dad that, do you think your dad believes you?
Hmm?
That he's just a friend?
Um,
No, hold on. I'm not saying what you think. I'm saying when you tell your dad that, do you think your dad believes that?
I don't know.
You don't know? Do you think he's a little bit suspicious about that?
Yeah.
Yeah. Probably mad about that too.
And my sister hangs out with guys that are 3 or 4. So it's like,
It's not fair. Right?
yeah.
Yeah. Hard question, young lady. Well, let me ask this one before I ask the really hard one. Why do you think you and your dad argue?
Because I'm a lot like my mom.
You think it's because you're like your mom? You don't think you argue because you might be like him a little bit? No? Out of all the things that are unfair as you see them, out of all of that, do you think your dad does any of this because he hates you?
No,
Yeah. Why do you think he does it?
I think there's some resentment.
Of you?
Yeah.
Oh, so your dad has resentment of a 15-year-old. Tell me how that works.
I think that he has it at my mom.
Pardon?
I think it's about my mom. And I'm a lot like her. And just always treating me like.
So you think he's taking out whatever his feelings may be for your mom on you? Really?
Yeah.
Let me ask you this, young lady. In looking back on it, looking at it that day, do you think your dad was trying to hurt you?
Yeah,
You do?
yeah.
Let me ask it this way. Do you think on that date he was physically trying to hurt you?
I don't think.
Or, hang on. Was he physically trying, do you think he was physically trying to hurt you? Or maybe doing things that hurt your feelings?
I think that he was trying to hurt me.
Physically hurt you?
I think that's where it got, but yeah. It's not that way.
Young lady, when the whole thing started with the TV that day, you two were just going at it, right? And then it kind of just was taking off from there between the two of you, right?
Yeah.
Because sometimes that's what dads and daughters do, right? Yeah. Okay. Any questions based on the court's question?
Yes, Your Honor.
Go ahead.
Keisha, I want to ask you a little bit of context about your home and your parents. I know some of these questions are really personal and uncomfortable, and I'm sorry. Do your mom and your dad stay in the same bedroom?
No.
They have their own rooms?
Yeah.
Does your dad keep his room locked? Where was your TV when it got taken away?
Yeah.
Have your mom and your dad stayed in separate rooms for a long time?
Yeah.
Years? Do you hate your dad? How do you feel about him?
I love him, just disagree a lot.
Nothing further.
You have no questions, do you, Ms. Fay?
No, Your Honor.
Thank you.
Do a motion appropriate though, Your Honor.
Pardon?
Oh, sorry, Your Honor. Never mind. Strike that as record.
You may step down. Okay, yes, please. Thank you. Any additional witnesses or the people?
No, Your Honor. People rest.
And Your Honor, I do have a brief motion for directed verdict as to both counts, specifically as to count 2, viewed in light most favorable to the non-moving party. The people have not introduced sufficient evidence for a reasonable fact finder to find my client guilty of the count of malicious destruction of personal property. Witness did testify that the property in question, the door, was not for personal property. Therefore, frankly, the elements have not been met, and I would ask the courts to find a directed finding of not guilty as to count 2. As to count 1, I also would posit to the court that the people have not found or laid out sufficient evidence for the trier of fact to return a verdict guilty beyond a reasonable doubt. As to count 1, as to my client, Mr. Bullard, and would ask the court to also find a directed verdict as to count 1.
You know, to count 2, I don't know if it never got communicated, we were not intending on pursuing count 2. That was because it was joint property between the defendant as well as his wife, Ms. Bullard. That was no longer going to be pursued. I apologize that it didn't get amended on the
That
information.
I don't think was communicated.
I apologize.
All right.
So that one I'm not pursuing, so that is completely valid and a good directed verdict motion, and I will concede that. As to count 2, I think with the testimony given, light most favorable to the people, a reasonable fact finder could conclude that we have met the burden, and leave it there.
As to count 2, I will grant basically by stipulation as to count 2, the malicious destruction of property. The court, in viewing the defendant's motion, could reserve its ruling, but rather than reserve its ruling is to count 1, the child abuse. In the evidence look in most favorable to the non-moving party, that being the state of Michigan. The court disagrees with defense and does conclude that a reasonable fact finder could conclude, if the witness is believed, that the defendant would be guilty of child abuse in the 4th degree, and so therefore will deny the defendant's motion. Prior to closing, the court's going to take about a 5-minute recess, and I'll come back. We'll have closing.
All right. 14A District Court of the County of Washington, State of Michigan, is now back in session. The Honorable.
You may be seated. We're back on the record in the case of People versus Victor Bullard. Closing.
Assistant Public Defender Natalie Pickett on behalf of Mr. Bullard, who is present.
I don't think I formally asked you, are there any witnesses or defense?
No, Your Honor, I did discuss this again with my client, and he did, and I advised him of his absence to testify on his own behalf or to remain silent. And at this time, I will not be calling him or anyone else as a witness.
Very good. Closing arguments.
Your Honor, viewing the evidence in light most favorable to the people, excuse me, the people do believe we've sustained our burden and ask for a verdict on single count of child abuse. Otherwise, I will rest on the proofs. Thank you, Your Honor.
Closing.
Thank you, Your Honor. We're here today because of a father setting some ground rules for his teenage children and trying to enforce them. We've all here been teenagers before, myself not too long ago, if dare I say it, and we've all had arguments with our
You're
parents.
saying that's in the,
Pardon me, Your
you're
Honor?
saying that because why? You want to
I have
compare that to when I was last a teenager?
probably.
Never mind, Miss Fay, go on.
And so, as Your Honor was also a teenager not too long ago, maybe even at the same time, but I do not know that. I've had arguments with my parents over rules they've set over the years. I believe many people, it's a common human experience. We've heard the testimony today that Ms. Bullard wanted her TV back, and my client wasn't going to give it back for whatever reasons. I'm not going to comment on anyone's parenting, whether or not a teenager has a right to a TV, whether they do not, whether they have a right to go to their friends or not. My client was just setting some ground rules for minor children that they happen to disagree with. They did have a verbal argument. And
I will agree that they did have a verbal argument that day regarding the rules. However, my client never intentionally laid his hands on Ms. Bullard in any way. We did hear the testimony, and Ms. Bullard testified to the fact that Mr. Bullard grabbed her arms. I am not stating that that happened or did not. What I will say is that she did not at any point testify that Mr. Bullard touched her neck in any way. She did not testify that he grabbed her neck, that he tried to grab her neck, that he touched it, even in passing. There was no testimony or evidence presented that he purposely or intentionally touched her neck or caused that scratch on her neck. Candidly, because we did see a photo of a scratch on Ms. Bullard's neck, I will acquiesce that she had one on that day, and that picture was taken by the police. We don't know how we got it, or how she got it. Candidly, I don't know how grabbing the arms could lead to that scratch on the neck. My client is not guilty of this offense of child abuse in the 4th degree. He is the parent or guardian of Ms. Asia Bullard. He did have fair custody of her that day. He did not knowing intentionally harm her, injure her, or put her in a position at which she could be harmed. They did have a verbal argument. She was angry about that. When she talked to her older brother later that day, as Ms. Bullard testified, he encouraged her to call the police, which is what she did. When the police arrived, she declined medical attention, and Mr. Bullard was not there at that time. We don't know what investigation the police did to get his side of the story. That was not presented today. I am asking the court to return a verdict of not guilty, as people have failed to meet their burden that my client intentionally harmed Ms. Bullard in any way or caused that injury to her neck. Thank you, Your Honor.
And just briefly, in rebuttal, one thing, I do think that Ms. Asia did state that the defendant scratched her as seen in Exhibit 3, and I do ask the court to return the verdict of guilty. Thank you.
In this case, and I will refer to her as Asia because that's how she wanted me to be referred to. I listened very closely to her testimony in this case. Surprisingly, well, not, I won't say surprising. She was very candid in her answers. I'm not sure entirely, also, as I'm looking at her and listening to her testify. I feel bad for her. And I feel bad for her because, quite frankly, I think I haven't heard from Mr. Bullard, or I haven't heard from Mom either. But I think both of them are failing her. And I say that because I think it's an interesting thing about kids. All they want to do is be loved. That's really all they want. And I think she's, frankly, as I understand this circumstance, being forced into a circumstance, regrettably, to choose sides, and she doesn't know why. Some of the unfairness that she talks about is that there's that unfairness of some young man who is just a friend, and I can only imagine what that's all about. Probably not necessarily the reality from either perspective, but dads sometimes react that way with their daughters. Young lady, one thing that you're going to have to kind of get used to regarding anyone that you bring into your life is, and I'm sure it's going to happen, same thing with Mom. You're going to see them. They're going to see them. They're going to make an immediate assessment. And then that's where it is. They're going to have to either prove themselves worthy or not. It's just like. But on this day, and I asked some very specific questions of Asia, and I do appreciate her honest answers, and appreciate at the end that she didn't hate her father. There are probably things that are going on in that household, things in the world she doesn't quite understand. She's only 16, so the only world she experiences is what's around her. Sometimes also, the argument that parents and kids are having isn't really about what it is. That sometimes happens with all human beings. It's probably about something much deeper. But as you listen to Asia, she was talking. Dad says X. She wants something else to happen. They begin yelling at each other. And as they begin yelling at each other, it begins to just sort of escalate. Asia said it best herself. When I asked, do you think your dad was trying to hurt you? And she said that he wasn't, that they were yelling at each other. But the one thing that she then pointed out was it got to where it got to. Don't think when he got to that doorway, it almost becomes this showdown at the door with both sides not wanting the other to win or leave with the upper hand. Sometimes. And you have a child that is trying to say something, but they're screaming, yelling, doing whatever. Because I guess the big people in the room, one has to sort of step back, kind of realize, or kind of try to figure out what it's all about. Dad said something that was interesting, but that wasn't satisfactory to Asia, especially about the boy and about everything else. That he was going to come back, he was going to see his mother, he was going to come back, and he was going to talk to her. On the surface, that seemed kind of reasonable. And I guess if one were second guessing, maybe there should have been a great pause and saying, maybe I need to talk with you now instead of going, because maybe that's what my child needs. I'm not going to sit there and second guess it. There. But sometimes that's what has to happen. I also don't think, well, Asia did what she did. I don't think really Asia relished the fact of having to sit here and try to testify against her dad. I don't think she liked it. I don't think she should, where one can help but be there in that circumstance. I'll say it may be inappropriate. Mom and Dad, you got to do better. You just have to do better. You have a wonderful, beautiful daughter that was up here testifying, and the two of you have to do better. She should never think, either because it's true or either because it's something placed in her head, that the reason Dad is so hard on me is because I'm like Mom. First of all, I've never seen a child that is just one parent. Never seen it in my life, and doubt I ever will. They're part of both of you. And both of you need to acknowledge that she has those parts. Part of that yelling going back and forth between daughter and dad was because they probably are a lot more alike than they want to even acknowledge at times. She was going to try to give as good as she was trying to give, and that was just going to go. And then it was a point at which who's going to win or try to win. You guys have to do better. If it's true that Dad treats her a certain way because you're like Mom, well, that's something Dad has to get over and realize that's his little girl regardless. If that's not the case, but something being planted because of the dysfunctional dynamic that may be going on in that home, planted in her head by Mom, then Mom, you have to let that go. You two don't have to like each other, but you got to love that little girl. Both of you. Proved this charge of child abuse 4th degree, and I'll just skip to the elements. Clearly had custody or control. But the defendant knowingly or intentionally committed an act that under the circumstances posed an unreasonable risk of harm to the child, or did something in a reckless fashion that caused that to the child. I don't believe that people have sustained their burden of showing that by any stretch of the imagination. I don't believe that, based upon the testimony before me, that the defendant's conduct was by any means reckless. And by her own testimony, Asia admitted that the acts in and of themselves were intentional in terms of what was going on. Now, to the extent also that one might believe that they were intentional acts. The concept of parental discipline, that parents are certainly allowed to discipline their children within reasonable limits. Given the circumstances as described by Asia, the force on the door, I noticed that while there may have been a mark to the neck, I'm not thoroughly convinced that came from the actions of Dan, certainly not any intentional act. The one thing that was missing, which would have seemed to have been there had he been in just this rage of anger, would have certainly been marks to her arms. I have no proof of that because she's very clear that he grabbed her arm. And if that was his first grab, there certainly would have been marks, bruises, something there when the police arrived. Given all of the circumstances and the totality of these circumstances, it's not up to the defendant to prove that his acts were reasonable, but more for the people to show that his acts were not reasonable. The people have not met their burden in that respect regarding the actions of the defendant on that day, ultimately ending up at the door. Asia's pushing on one side, Dad's pushing on another side of the door. I think that there might be differences in that, but it certainly wasn't shown to the court that this was not an exercise in a certain respect of parental discipline with no intent by her own statement that this defendant was intending to harm. And so for those reasons, the court would find that the people have not sustained a burden, find the defendant not guilty of California child abuse in the fourth degree.
Thank you, Your Honor.
Thank you.
Thank you.
Asia, do me a favor. Take care of yourself, young lady. Got a lot going for you. Okay? Take care. For a standing brief recess, we'll get set up for the PE.
All right. All right. Report to the District Court for County of Washington, State of Michigan is now back in session. The Honorable Judge Simpsons.
You may be seated. Yep, both sides. Let's call the cases. Court calls the cases of the people versus Christy Couch, Myron Couch, Devin Gates, and Jermond Matthews. Counsel, state your appearances.
Good afternoon, I'm Raymond Cook for the people.
Good afternoon, Michael Norman, on behalf of Myron Couch.
David I. Goldstein appearing on behalf of Christy Couch.
Good afternoon, Your Honor, Sam Bernstein with and on behalf of Mr. Gates.
Afternoon, Your Honor. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Jermond Matthews.
Thank you. All right. I think we had concluded with our last witness and the people were still on their primary case.
That's correct, Your Honor. People are for prison before training.
All right. Yes, I am ready.
People call the text sergeant tomorrow. And Your Honor, just for the record, I do have my two witnesses that my other than my OIC sequestered out in the hallway. I have told them not to discuss the case.
Understood.
Laura? Yes, thank you.
Please come forward to be sworn.
Take a seat, raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. I did. See, state, spell your first and last name for the record.
My name is Ryan Morrow, RyanMorro.
You may inquire.
Thank you. Good afternoon, Detective Sergeant. How are you?
Good.
Detective Sergeant, how are you employed?
I'm employed by the Michigan State Police.
And in what capacity are you employed with Michigan State Police?
Detective Sergeant.
How long have you been a Detective Sergeant?
Detective Sergeant now approximately 7 years.
Any previous law enforcement experience?
No, sir.
Were you employed with Michigan State Police on or about, well, just say January of this year for the entire month?
Yes, sir.
And were you employed in the same capacity then?
I was.
Going to January 4th of this year, were you assisting with an investigation related to a home invasion on that day?
I was.
In what capacity were you assisting with that investigation on that day?
I was assisting with various roles, mainly talking to the
Did you ever have an occasion to go to 19973 Rogue, Rogge Street in Detroit?
I did.
Why were you there?
There was an execution of the search warrant at that residence.
And as part of the execution of that search warrant, did you detain any individuals?
I helped identify the individuals that were at the residence during the time of the search warrant.
Do you see any of the individuals that you detained or that you identified on that day in the courtroom here today? Who do you see?
The gentleman to your right there in the green, Mr. Matthews.
Your Honor, may the record reflect that the witness has identified defendant Jermond Matthews?
Without objection, record so reflect.
When you made contact with Mr. Matthews, what did you do?
Identified him, and then he was transported to the 2nd District State Police Headquarters for an interview.
What was he wearing at the time that you made contact with him?
If it was like a black shirt.
Long sleeve, short sleeve?
Do
Do you remember what pants he was wearing, if any?
No.
Was there anything about his clothing that you remarked or found interesting?
During the interview, while talking to him, I observed what I believe to be drywall dust on his left bicep.
Did you observe that dust anywhere else on his person?
Just like mainly over his shirt. Didn't notice it anywhere else.
Okay. How else, did you assist at all with the actual execution, the search of the house, other than assisting with the identification?
No.
Going forward to the next day on January, well, this would be 2 days, on January 6th, did you ever have an occasion to go to a house on Biddle Street?
I did.
And in what capacity did you go to that house?
The execution of another search warrant in the same case.
And at that time, did you make contact with any persons of interest?
Not at that time.
Did you ever have contact with any of the residents of that household?
I did subsequently at the Michigan State Police Rights Post.
And do you remember what address on Biddle Street that was that you executed the search warrant?
I have to refresh my memory in my notes.
And did you write a report regarding this incident? And if you viewed that report, would that help refresh your recollection? Your Honor, may I approach the witness with his report to refresh his recollection?
Yes.
I'm approaching you with what's been seen as Michigan State Police Incident number 12-66-25 Supplemental Report 90. Please read that and let me know when you're done.
9345 Middle Street.
So going back, is your recollection refreshed?
Yes.
And so what is the address?
9345 Middle Street.
Thank you. And did you say that you had contact with any of the individuals that lived at that address?
I had contact with several of the occupants that were unrelated to the case.
Did you have contact with anyone that you see in the courtroom today?
Yes.
Who did you have contact with?
I had contact with Myron Couch, the gentleman in the vest to your left, and Christy Couch sitting there in the white outfit.
Your Honor, the record will reflect this witness has identified defendants Myron and Christy Couch as well.
Without objection, record shall so reflect.
Thank you. Where did you make contact with Myron and Christy Couch?
I spoke with them at the Brighton State Police Post.
And when you spoke with them, did you advise them of any rights?
I did.
What rights did you advise them of?
I advised them of their Miranda rights, which I read from my state issued Miranda card.
And beginning with, well, I'll ask it this way. Did you interview them separately or together? Beginning with Myron Couch, did he indicate that he understood his rights?
He did.
Did he waive his rights?
Yes.
So he agreed to speak with you after being advised of his rights?
Correct.
Did you ask him any questions related to the incident that occurred on January 4th?
I asked him to explain to me what he had done or what, starting from when he got up on January 4th, throughout the entire day.
And what did he tell you that he was doing that day?
He told me that he woke up around 6 a.m. and left his house by 7 a.m. Driving a rented U-Haul. He was driving to go meet a gentleman on the east side of Detroit regarding a payment over a dog. Gentleman by the name of Rock. After he went, he initially stated that he did not meet that person, and then he drove to Ypsilanti to meet his brother, on Biddle, on Bridge Street, his brother Harold. He didn't end up meeting with Harold, and then he went out to his mother-in-law's farm, out near Willis, to go check on a horse. After, go ahead, sorry.
Sorry. Did that story change at any time?
It did.
Your Honor, at this point, I'm going to interpose an objection. This is a post Pinkerton statement. It is not admissible to my client.
Correct.
And Your Honor, I understand. I'm asking the court only to consider the testimony of this defendant as against this defendant, where it's admission of a party opponent, not against the other 3 defendants.
Satisfied, Your Honor. Thank you.
Understood. Go ahead.
Thank you. Did Myron's story ever change as he was telling it to you?
It did.
How did it evolve?
We had gotten to talking, and I asked him about who Jermon Matthews was, and even showed him a picture of Jermon Matthews, and he said that Jermon Matthews was the gentleman that he was going to meet by the name of street name of Rock, and that he actually did meet him and another individual on the east side of Detroit, picking them up and driving them back into Washington County.
And did he ever explain anything about his family relationship?
In terms of,
Did he ever explain how he was related with the named victim Jamil on this case?
yeah, so his cousin Malik owned the house in Willis, and he had subsequently gone to prison and given the house or allowed Jamil to stay at it.
And when you say the house, is that the house located at 10060 Willow Road?
Yes.
Okay. Did he explain anything about any debts?
He explained that Malik owed him for payment on some marijuana.
Did he say how much Malik owed?
16,000, approximately $15,000.
Okay. At any point, did Myron tell you that he was at that house on 10060 Willow Road?
He did not.
Okay. Did he explain what he was doing after the time of roughly 8:30 that morning?
I don't think he did. Probably he said he went home after all that.
Did he indicate ever driving a U-Haul?
Yes.
And what did he say about that U-Haul?
He said that he was driving the U-Haul when he left his residence on Biddle Street that morning at approximately 7 a.m.
Did he explain why he had a U-Haul?
Well, he explained why he had the U-Haul.
And I believe he said that according to him, he met Mr. Matthews, and he said there was another individual. Did he identify that individual?
He did not.
Did he describe that individual at all as far as characteristics? And you said you interviewed Christy Couch as well, is that correct?
Correct.
And just for the record, as with Mr. Couch's testimony, I'm going to be asking some questions of this witness regarding Christy Couch. I would ask the court to consider that only as against Christy Couch.
Okay.
Did you read Miss Couch her rights?
Yes,
And did she indicate that she understood those rights?
he did.
Did she waive those rights?
She did.
And she agreed to speak with you?
She did.
Did you ask her about what happened on the 4th, January 4th?
Yes, I did.
And what did she explain she was doing on the 4th?
She explained that she had gotten up and was going to go drive for a food delivery. DoorDash, Uber Eats, I don't remember one of those two services.
Did she say when she started doing that work that day?
She did, yes.
When was that? Or when did she say that was?
I believe it was around, she had left the house. I'd have to take a look at my report and see exactly what time it was. I apologize.
Your Honor, may I approach the witness?
You may.
I'm handing you the same report that I previously handed you. If you can please read that silently to yourself and let me know when you're done. Did that refresh your recollection?
Yes,
So when did she tell you that she had started her deliveries that morning? Started her job?
approximately 8:30.
Okay. And how long did she say that she was out doing these deliveries?
Until approximately around 11,
What happened at 11?
that she had went back to her residence.
And did she tell you who else was at that residence?
Yes,
Who did she claim was at that residence with her?
she, when that Myron, had come back to the residence as well as,
Did she ever mention anything about a U-Haul?
yes,
Did she say, or what did she tell you about a U-Haul?
she had rented a U-Haul, for Myron.
Did she say when she rented that U-Haul?
On the third,
So that would have been the day before?
correct,
Did she say why she rented that U-Haul?
for him to help his sister move.
Did she ever tell you how she knew Jermond Matthews?
I believe she said that they, her, Jermond and, Myron had some type of sexual relationship.
At any point, did you ever have, or in the course of this investigation, did you ever have a contact with an individual by name of, Devin Gates?
Briefly, yes.
In what capacity did you have contact with that individual?
It was during an execution of a search warrant.
And when was that?
That would have been, again, I have to remember.
Just 1 second, please. Come back to that. You had contact with Mr. Gates, is that correct?
Very, very briefly.
And in what capacity do you have contact with him?
It was during the execution of a search warrant.
And do you see that individual in the courtroom today?
I did.
Can you please point him and identify him by an article of clothing that he's wearing?
Gentlemen, you're right there, in
And there's two individuals in white shirts. Is it the one with or without a jacket? Your Honor, if the record can reflect this witness has identified defendant Devin Gates.
Record show shall reflect without objection.
Did you ever speak with Mr. Gates about the incident on January 4th? Okay. One second, please, Your Honor. No further questions for this witness. Thank you.
Cross-examination, Mr. Norman.
Good afternoon. You interviewed, or you talked to Mr. Couch on January 6th at the Michigan State Police Brighton Post.
Correct.
And was that interview recorded?
It was.
All right. And would you agree that the recording of that interview is going to be more accurate potentially than your memory?
I would say that my memory and the interview that's recorded are probably one and the same.
All right. So if the recording reflects that, for instance, Mr. Couch did not tell you he drove a U-Haul downtown, would you disagree with the recording?
Say that again.
If the recording reflected that Mr. Couch didn't tell you that he drove a U-Haul downtown to meet someone, would that?
I wouldn't disagree with the recording. No.
Okay, so you'd agree the
But I don't
recording,
think all
all
of them the same.
right, but you'd agree the recording is the most accurate evidence of the conversation, what was said.
Sure.
All right. Now, Mr. Couch denied ever being at the home where the home invasion occurred when you spoke to him, correct?
Correct.
And he told you that he was going to a farm in the Willis area.
Correct.
And did you ever make any attempt to determine whose farm that was?
He said it was his mother.
All right. And did you ever do any investigation regarding that?
I believe that there was others that were involved with the case that investigated that portion.
Did you personally talk to the mother-in-law? Same question regarding his sister. Someone mentioned something about moving. Did you ever speak to Mr. Couch's sister? All right. And you had a chance to see Mr. Couch when you interviewed him physically. And if I told you he was 5'7", would you have any reason to disagree with me?
I wasn't looking for size or anything like that.
Okay. All right. But You can't disagree as to what his height may or may not be.
I would guess.
Okay.
Mr. Goldstein,
I have no questions, Your Honor.
Mr. Bernstein,
I have no questions or anything.
Mr. Thank you. Younger and slimmer, you could have gotten right through there, but no, never mind. I just thought.
Good afternoon, Detective Sergeant Morrow. All right. So, you understood the events of the alleged break-in were January 4th, is that right?
Can you be more specific?
The reason you're here to testify is based on a home invasion, is that correct?
Right.
Okay. And that's what you've been talking about all this time, is that correct? That you've been understanding was January 4th of 2025, is that correct?
Right.
Okay. Do you remember the time at which these events were alleged to have occurred?
No, I wasn't present for the initial investigation.
Did you speak to anyone who would have told you the time at which this would have occurred?
Yes, I was briefed by other detectives on the time of the investigation.
And your understanding of that time was what?
Sometime in the morning of January,
Anything more specific than that? Any particular hours?
early morning.
Nobody told you anything more specific than that? Don't recall. Okay, all right. So, did you have a chance to actually go out to the area where the incident is alleged to have occurred?
Also,
Are you familiar with that area at all?
they have an hour before.
Okay. Now, you did testify that you had a chance to speak with Mr. Matthews, is that correct? That gentleman sitting in the green? Now, where were you when you spoke to him?
We were at the second district state police headquarters at second and law.
Okay, and did you have a chance to come and speak to him?
Yes.
Okay, so you had a chance to walk him in the room yourself?
Right.
You stood beside him,
I believe it was me and another trooper, yes.
but you stood beside him, right? How tall are you?
Approximately 6 foot.
Is he shorter than you? You don't remember? Okay, so you have no idea how tall he is in relationship to you? And you don't even know if he's shorter than you? Okay, all right. So you testified that, so what date was this that you had a chance to see him?
That was on
I'm sorry?
January 4th.
January 4th, okay. Now you testified that as you were speaking with him, you had a chance to see what you believed was drywall on his bicep, is that correct?
Drywall dust. Right.
Drywall dust. Did you collect this drywall dust?
I believe the clothes were collected by another trooper.
Okay. Now, do you have a report to present to the court that verifies that this was drywall dust?
I
Do you know if this, whatever it was on this bicep, was sent out to a lab? You don't know, you don't have any idea about that?
Yes.
Now, describe what you saw. Was it white dust?
Right.
Fine powder like?
Yes.
And do you know of any other items that could be similar to that? For example, flour,
Maybe, potentially.
powdered sugar.
I mean, that wasn't.
Powdered sugar similar to what you saw?
I don't know.
You don't know? But you could speculate here under oath that you thought it was drywall, right?
It appeared consistent with what was here.
But it also appeared consistent with flour. You would say no. All right. So why don't you tell us the difference between flour and drywall dust?
It's quite visibly different.
Oh, go ahead and tell us. Explain it to us. Break it down. Oh,
The lab would have to,
so you're not a dust expert. You need a lab, but you're going to sit here and tell us that there's some.
from my understanding of the situation, and based on what I saw, I believe it was possible that it was driving.
So you're speculating. Is that right?
I think it's asked and answered. I mean, go ahead.
You don't know what it was, do you?
I can't say for 100% certainty.
All right. All right. So you testified that you did not go to the scene. Is that correct? Did not go to the scene at all?
Right.
Did you speak directly with any of the complaining witnesses?
No.
Any redirection?
No, Your Honor, thank you.
All right, thank you, sir. And call your next witness.
Detective Sergeant Clark.
Sir, please come forward and be sworn.
Great, take a seat, raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Name, spell your first and last name for the record, please.
Christopher Clark, CHRISTOPHER, Clark, CLARK.
May I inquire?
Thank you. Good afternoon, Detective Sergeant. How are you? Detective Sergeant, how are you employed?
Michigan State Police.
In what capacity are you employed?
I work as a detective sergeant,
How long have you worked as a detective sergeant with Michigan State Police?
about 5 years.
Any previous law enforcement experience?
Prior to the state police, no.
Did you always work as a detective sergeant? Do you have any other roles that you filled in Michigan State Police?
I had other roles I filled over the course of 11 years.
So 11 total years of law enforcement experience, am I understanding that correctly?
Yes.
And Detective Sergeant Clark, were you ever dispatched reference home invasion at 10060 Willow Road?
10060.
Correct. Yes. Were you ever, okay. And that was reference incident that happened on January 4th, is that correct?
Yes.
In what capacity did you assist with that investigation?
As a investigator, more specifically, one filling detective duties, coordinating a larger investigative effort than something more minor than just having, presence complaints and driving traffic. That's right.
Okay. And I'll start sort of at the beginning. What work did you do when you were initially dispatched on this case?
The first thing to do was summon an ethics tech
Okay.
and speak to the troopers that were out there at the scene and give them instruction as to how I wanted them to preserve the residents until I got there. Spoke about whether or not search warrant would be needed or consent. Some of the specifics, like things of that nature.
At any point in the course of your investigation, did you go to a 19973 Rogue Street, again, that's ROGGE, in Detroit?
Yes,
Why were you there?
that was the residence for Javon.
And at the time that you went there, what was your reason for being there?
We were executing a search warrant.
When you executed that search warrant, did you see or seize any items of evidentiary value?
So
What did you find?
there were firearms that were seized from residents. There was a holster. There was a ski mask. There was an article of clothing. There was a cellular phone.
When you say a ski mask, can you describe that in a bit more detail? What color was it?
I can't say for sure that I recall.
Do you remember what the face structure of it was like, as far as how much of the face it would allow to be seen?
No, I can't picture it in my mind right now.
Do you remember where the firearms were located?
Two were located upstairs and one was located outside in the garage.
Did you have contact with any individuals at that house or at that address?
Yes.
Who did you have contact with?
I had contact with, if I'm not mispronouncing it, Lisa Matthews, your mom's mother. I had contact with a man named Tori Jackson. And there was a minor there whose name is escaping me right now.
Okay. When you spoke with Charlisa Matthews and Tori Jackson, what did you talk about with them?
Asking them, I believe, if I remember correctly, about a timeline for Javon for that day, and then also for what was the phone number that they had programmed for him in their phones.
And were you able to view their phones directly?
Yeah, with the permission, yes.
And what phone number did they have listed for Jermond Matthews?
I don't have that memorized, I'm sorry.
You wrote a report on that incident?
Yes.
And if you saw the report, would that refresh your recollection?
Yes.
You're on permission to approach the witness to refresh his recollection. Thank you.
Just scroll to the correct page.
And you, Michigan State Police Report 12-66-25 Supplemental Report 2. You can please read that to yourself and let me know when you're done.
Thank you.
Is your recollection refreshed?
Yes.
And so what phone number was linked to Jermond Matthews?
759-9382. That's a good one.
Okay. Did you ever do any further investigation into that phone number?
I also queried that phone number in a program called Cash App.
And what is that program?
It's like a digital currency exchange. It's what would be considered like open source information, stuff you need a special account to do. And when I queried the phone number in Cash App, it returned with the account of Jermond Matthews, had a male depicting his physical likeness associated with the account.
And when we say Jermond Matthews, do you see the individual in the courtroom today?
Yes.
Can you please point to him and identify him by an article of clothing that he's wearing?
The gentleman seated my left wearing the green shirt.
The record may reflect that this witness has identified defendant Jermond Matthews.
Record shall so reflect.
Thank you. Detective Sergeant, did you ever get a search warrant for that phone number?
For phone records
Yes.
associated with it, yes, yes it did.
All right. And do you remember which provider that was through?
No, there's too many involved.
Were there any other phone numbers of interest that you found related to this case?
Several, yes.
And specifically, I guess we'll go with defendant Myron Couch. Were you ever able to identify a phone number that you believe to be linked to Myron Couch?
Yes.
How did you uncover that phone number? What investigation led to that phone number?
While I was present at the search warrant for his residence, I spoke to.
For his, meaning Mr. Couch's residence?
Yes, Your Honor.
Okay, all right, I just wanted to make sure.
And spoke to his daughter, Maya. She showed me the phone number that she had saved in her phone for Myron and that same phone number, I know I would speak to Myron at that phone number at least once later on.
And do you remember what that phone number was?
No, I'm sorry, I don't. Okay. Just one of those.
We'll come back to that in just a minute. Did you ever find a phone number that was linked to Christy Couch?
Yes, as I explained briefly, through similar manner. And these numbers would also later be linked to physical devices.
Okay. Did you ever find a phone number of defendant Devin Gates?
Yes.
How did your investigation lead to that phone number?
So I associated two phone numbers for Devin Gates. So we have the transition of phone numbers happening on January 4th in the evening hours. So if you're talking about phone number you would have had around the time of the crime versus around the time later on that evening after the crime, that's probably just knowledge or two numbers of later.
So you identified two different numbers that you believe were linked to Devin Gates.
Depending on a period of time.
Okay.
Yeah.
How did you get those numbers?
So I'll try and be as concise about this as I can. Looking in phone records for Jermond Matthews, we can look at a particular, using a program called Cast Fizz, we can look and see who are kind of the top callers for that day, or kind of what's the phone frequency that day in comparison to how it would be in other days. Are there people being contacted more on this day than are typically contacted against other days? And there were phone numbers, that were of interest that were, higher contact with Jermon Matthews' Vice. From there, the records were sought, and there, based off of some location activities, there was a phone number that continued to be of interest. As far as the subscriber records associated with that number in particular, it came back to a D-Rock or Derek Gates at an address on Cardone Street, I think. When I queried that address, ops by address in Lean, that resulted with the name of one of the people being associated with that address in Lean as being with Devin Gates. And when I made contact with a probation agent about persons known to Devin Gates, there was a female with whom he had a child in common that was the top caller for this number, which would further lead me to believe that it was in fact a phone number being used by Devin Gates. And then also the what's called a hot tower, which is the tower that's being most commonly used, can be used to suggest where a person might be living or having a lot of contacts because that tower is having so much activity. And hot tower for those records was also over a address associated with them. So through a combination of reasons as to how I developed the number and grew suspect that it was associated with Devin Gates.
And I believe I asked before and you said you didn't know. I just want to confirm, do you remember what phone number you associated with Myron Couch?
I'm sorry, I don't have the phone numbers memorized. There's too many in play.
Right. Did you prepare an affidavit for a search warrant reference these phone numbers?
Several.
Right.
Yeah.
And if you saw part of that, would that refresh your recollection?
Yes.
May I approach the witness? Refresh. Please read that silently and let me know when you're done. Is your recollection refreshing?
Yes.
Do you remember now what number is associated with that you found to be associated with Myron Couch?
280, 14, 28.
280, 14.
Sorry. It's a 734 number. 734. I'm just trying to remember all these numbers. 734. 280. 14, 28, I believe.
Do you remember what number you associated with Christy Couch?
Sorry, I have the phone numbers. I would have to see them.
May I approach again, Your Honor, to refresh your recollection? Thank you. And in the same document, can you please read and let me know when you're done?
Unless you needed counsel, why don't you just leave that up there and have it turn it over? We'll go a lot faster. All right.
Will do. Thank you, Your Honor.
Unless there's an objection.
We'll let him get a steps objection. Just kidding.
What'd you say?
So we'll let him get a steps and I'll just.
I do need to burn some calories. I wouldn't mind. So from your investigation, what number did you find to be associated with Christy Couch?
May I read it directly?
I have no objection.
Thank you. Go ahead.
734-635-0410.
635-0410 was the last four you said?
Correct.
Right. And similar question, what number did you find associated with Mr. Gates?
You gonna have any objection if he reads it?
No objection.
All right, go ahead, sir.
That's going to be 313-459-8863.
And then last but not least, Mr. Matthews.
Be 759-9382.
See, Judge, I was gonna object, see how good.
Yeah, but he already testified to that, so it doesn't really matter whether you're objective or not.
I believe you indicated Mr. Mr. Gates, you said it had a second phone number. Were you able to identify what that number was?
Yes, I don't know if I have that in front of me. That number would come into play in locating Mr. Gates after the crime would have occurred, and that would have been really the scope of its relevance.
We'll move on from that one for now. Did you get a search warrant for cell data records for those numbers that you just listed?
Yes.
And I am going to hold up and show you what's been marked as People's Proposed Exhibit number 12. Do you recognize this device that I'm holding?
Yes, we show here.
All right. And have you seen this before testifying today?
Yes.
Do you know what's on this device?
Phone records of the numbers that we spoke of.
And the records that were contained within, are they fair and accurate records as to what you received following that search or those search warrants for these phone numbers?
Yes.
And did they contain a certificate of authenticity along with them?
Yes.
Your Honor, people would move to admit what's been marked as People's Proposed Exhibit 12 into evidence.
Any objection or what there?
Your Honor, I can only agree with regard to the portion of the records that relate to my client. I can't have no position with regard to the other records.
The same position, I would not object for purposes of the exam.
Likewise, Your Honor.
No objection for purposes of exam.
Exhibit 12 is admitted.
Thank you. And Detective Sergeant Clark, when you reviewed those records, did those records, for the numbers that you saw, did they have a name associated with them from the telephone agency?
You're talking about subscriber information?
Yes. And the names that were associated with each number that you searched, did they match your suspicions?
It confirmed my suspicions that they were associated with, yes.
So essentially the phone numbers that you searched, for example, the one ending in 1428 that you believed was associated with Myron Couch, was that supported by the data you got back from the search warrant?
Yes.
Okay. And is that true of all 4 of those numbers that you listed?
We talked about with Devin Gates how that was the name was slightly off, and there was a address being used that was a prior address for him and may not necessarily been occurring, and just kind of the investigation that was done. So the name is now like a 1-for-1, like Christopher Clark on subscriber records for Mr. Gates for that period that we're talking about.
Okay. Do you remember what name was associated with Mr. Gates?
D-Rock Gates, D-E-R-O-C-K, Gates, and an address Cardone, if I was pronouncing it.
Other than the name in the records, was there any other information provided in that subscriber information that connected the records you got from the search warrant to these defendants?
Say the question one more time.
Sure, I'll simplify it perhaps. Did it provide an address for the names associated with the subscribers?
Yes.
And those addresses, did they match the addresses that you found registered to these defendants?
I don't recall. I haven't studied the subscriber records.
Okay. Moving on from phones for just a second, did you ever identify any vehicles registered to any of these defendants?
Yes.
Specifically for Christy Couch, what vehicles, if any, did you find were registered to her?
Blue SUV Hyundai.
When you say blue, is that light blue, dark blue, medium? What shade of blue?
Dark blue.
Dark blue, okay. Do you know, were you able to find a license plate number for that?
Yes, I wouldn't have it.
Okay.
Yes.
And when you were investigating these defendants, I'm not going to ask you to put it on the record, but did you obtain a driver's license number for Miss Couch?
Yes.
Okay. Would you be able to write that number down and provide that to the court? I just don't want to read it off since I know this is public.
Yeah,
I believe Your Honor asked at the last hearing where there was the driver's license number on the U-Haul receipt. The court wanted to hear testimony linking the driver's license number on that receipt to defendant Christy Couch. I was attempting to provide that link here.
okay. I thought we had gotten past that.
If the court doesn't need to hear, then I can move on.
Well,
Okay.
yeah, I was done with that last time.
Okay, understood. Were you able to find any registered addresses for any of these defendants?
Yes.
What address was registered to Christie Couch?
That was the address in Romulus on, Middle Street.
Do you remember the number?
Nah, I don't remember exactly, no.
Your Honor, may I approach?
Yes,
For exam purposes, if he wants to leave him, I don't know.
thank you.
Was that 9345 Biddle Street?
Yes,
And is that the same address for Myron Couch?
yes.
Were you able to get an address for Jermond Matthews?
It's on Road Street, Detroit.
And was that the 19963, the number that was, you heard previously?
Yes.
One moment, please, Your Honor. No further questions for this witness. Thank you.
All right, thank you. Mr. Norman.
I have no questions.
Commissioner.
I have no questions, Your Honor.
Oh, this could almost be something that never happens. Mr.
Oh, you know what?
Knew we were gonna get there. Got all the way down there and then no. No. Go ahead, Chris.
Thank you, Your Honor. Good afternoon, Detective Sergeant Clark. All right, just have a few questions. Now, you testified that you were able to execute a search warrant at Roche Street. Is that correct?
Yes.
Okay. You testified to finding firearms there. Is that right?
Yes.
Some upstairs
Yes.
and one in the garage?
Yes.
Okay. Were you able to determine how long those firearms had been there?
You speak up for me just a little bit, I'm sorry.
Were you able to determine how long those firearms had been at the residence?
No.
No. How about in the garage? Were you able to determine how long the firearm had been in the garage?
No.
Okay. If they had been there several days, you wouldn't know that.
As I said, you can't determine how long they've been there.
That was a specific question. If they'd been there a month, you wouldn't know that, right?
I have no way of knowing how long they've been.
So that's, no, I wouldn't know. Would that be a fair answer to the question?
Yes.
Okay, thank you. All right. Were you at the scene on Willow?
Yes.
Okay. Were you able to see the different addresses there? Different homes? Okay, well, let's back it up. How is that neighborhood laid out? Is it apartment buildings or houses?
It's residential homes.
So houses?
Yes.
Okay. Do you have an objection to saying houses instead of residential homes?
No.
Okay. So when I ask you, it's houses.
Well, it just, I think he was just referring to it a different way. So let's get to the next question, please.
Well, yeah, and I couldn't be clear. I asked him a specific question.
I understand that, Mr. Brown, but
Okay, so I don't want to argue later that he was saying something different than what I was saying. Thank you. All right, so residential homes. How many residential homes? All right, well, the block that the house in question was located, how many residential homes are in that block?
I don't know.
Don't know. Do you have a general idea of, was it more than 2 or 3?
I didn't study the block. I just was responding to the scene.
You didn't study the block? Okay. So are you aware that there were other houses there at all on that block?
Yes.
Okay. And how are you aware of that?
In the course of responding to the scene and just by being there and looking around, I can see other homes.
Okay. So that doesn't count as studying the block though, right?
No, I can't answer your question about how many homes are on the block.
Okay. But you did see other homes.
Yes.
Okay. Don't know how many other homes, but you did see others.
sustained.
All right. Do you know if any of those other residential addresses were in 3 to 5 feet of the house in question?
None of them were that close.
Okay. Did you see any mailboxes as you were going through the residential area?
The house in question, the scene has a mailbox on it. All the other mailboxes.
You don't remember seeing any, so you did see a mailbox for the house in question,
Yes.
but you don't recall seeing any other mailboxes?
There's that I don't remember.
Yeah. So is that a fair summation by me that you don't recall seeing the other mailboxes?
Right.
Okay. Did you talk to Mr. Matthews directly?
I believe I did, no.
Okay. Did you have a chance to see him during the course of this investigation?
I can't remember if I had.
Okay. Thank you. I don't have any further questions at this time.
Any redirect? Sir, you may step down. Thank you. Please come forward to be sworn.
You raise your right hand. You solemnly swear to affirm the testimony you're about to give you the truth, the whole truth, and nothing but the truth, so help you God. See, state spell your first and last name for the record, please.
Ricky, R-I-D-D-I, V-E-L-I-N-S-K.
May inquire.
Thank you. Good afternoon, ma'am. How are you? Thank you. Ma'am, how are you employed? In what capacity are you employed by Michigan State Police? And how long have you been an intelligence analyst for Michigan State Police? And can you describe what your work is as an intelligence analyst?
Basically, on a day-to-day basis, I get requests from detectives about further development needs, and I do this by conducting research.
What sort of records and research do you do typically?
Phone analysis, location analysis, link charts, guidelines, just case by case.
Did you ever assist with an investigation related to Michigan State Police Report 12-66-25? In what capacity did you assist with that investigation?
I did phone analysis as well as location analysis for other locations and LPR.
When you say those phone records, what phone records are you referring to? And do you know how those records were obtained? Okay. I'll think of the way to phrase this. When you're analyzing a phone, what information can you find out about that phone based on the records that you received in this case?
Your Honor, can we ask the witnesses to raise your voice a little bit?
Yeah, can you? If you can.
So call camera. Caller number, call number, as well as cell site and sector.
And when you say cell site and sector, what does that mean?
So site is when your device connects to the network, and that will provide what people know as a cell tower. So typically, cell site and cell tower interchangeably. Sector is the direction of the cell site and tower.
And how many sectors are on a cell site if there is a quantifiable number?
Is -6, typically they have 3, as few as 2 or unidirectional.
And so when you see these records and it gives you a sector, how does that translate into a location?
So it isn't necessarily the exact location, but it gives you directional cell site.
And does it tell you how far from the cell site that device is? When you see this data and you get a sector, is that something that evolves over time, or is that a phone that connects to a specific tower and that's just there?
It's connecting to a specific tower at that time was given.
Okay. How does the phone determine which tower to connect to?
It uses the best, all of the best quality that provides the strongest, most stable connection.
And what sort of characteristics would make a tower the best tower, highest quality tower for a cell phone to connect to?
That's dependent on geographic area. So there's things that could potentially get in the way of creating a good signal. But typically it depends on how many devices are connecting to that cell site and which one. It's not necessarily the closest to the one with the strongest connection.
Does distance to a cell tower affect connection? Typically, does a device connect to the closest tower, or does it connect to one further away?
Typically.
Okay. Did you analyze the records in this case? All right. And from your analysis, or what program or software do you use to analyze those records? And can you describe that software to the court?
Software that's used by federal, private.
What specifically does that software let you do?
It allows us to do input all sites within the database and then also upload the records to compare to sites.
What sort of records can you compare cell data to?
Yeah, we talked about, so I have records from whether it be like a pipe reader. There's that.
Let's talk about the license plate reader. Where do you get those records from? And is that something that you have access to? Did you access any flock information related to this case? Did you provide or create a summary of the cell data that you analyzed on this case? And I'm going, if I may approach, Your Honor.
Yes.
Putting in front of you, it's been marked as People's Proposed Exhibit number 13. I have a copy for the court as well, if the court would like it now.
Any objection?
Not for the purposes of the hearing.
All right, go ahead.
Ms. Zielinski, do you recognize this document in front of you? And what is this document? And have you seen this document before today? Is it a fair and accurate reflection of the data that you observed? Your Honor, people will move to it. It's been marked as People's Proposed Exhibit number 13 into evidence.
Any objection or voir dire?
None, Your Honor.
None, Your Honor.
All right, exhibit 13 submitted.
Thank you. So, Ms. Zielinski, starting with the first page here, can you describe to the court what this first page is telling us?
This first page is the provider associated to the phone number.
And going on to the second page, it looks like there is a box here labeled legend, and then there's some symbols inside of it. Can you describe what those, it looks like right angles with arcs are? So that little shaded part indicates the cell is somewhere within those two arms, essentially.
Yeah. Essentially, it could, it's not necessarily exact, but it's the angle that it's being used.
Okay,
So it's not an indicated area, but it's an actual.
gotcha. And it looks like there's a red pin. What does that pin indicate? And is that information, how did you receive that information? And then, and it looks like there's a bottom right box there with some additional labels. What are those labeling?
Ryder, I have not understood a single word she has said.
Is it because you couldn't hear her or because her language was?
Because I can't hear her.
Okay, thank you. All right.
You have to remember, Your Honor, 2 of the 4 defense counsels are quite elderly, so.
And yeah, got it. Okay. All right, if you could speak up, and if it sounds, I don't think she's not trying to speak up. I think it's just her normal tone. We do have hearing assisted equipment, which will actually clarify it greatly. I use it sometimes to soft-spoken witnesses. So would you?
If I need it, if we continue and I need it, I'll
Okay.
appreciate it.
Mr. Brown, you need it? No. Okay. All right, go ahead.
I couldn't pick up Miss Lottie. She's not here.
Exactly.
I'm honored to be picked on by Mr. Goldstein. So, ma'am, I believe you were describing what's in the bottom right locations. If you can just describe what those represent for your present, or not presentation, but for your exhibit.
Other locations which include Jeremiah Matthews, residence, as well as Cottage residence. Cell site location and license plate.
Moving on to P3, it looks like this is a map and then there's a date stamp and some numbers. Beginning with the date and time, what does that date and time frame represent?
The date and time frame is the date of the date that the incident occurred, and we're looking at from 6:30 a.m. to 6:59 a.m.
So that's the range of the data set that you looked at for this specific page. Is that accurate? Okay. And then on the left-hand side, it looks like there's some numbers as well as some timestamps on those. What are those numbers representative of?
Making a call to that specific number. So with the arrow, it's showing a call number and a calling number.
And the one on the left is the one that called, the one on the right, am I understanding that correctly? And the number to the left of the phone number, is that the time that the call was made or attempted to be made? Okay. Looking at the right-hand side, that actual map part, beginning in the bottom left, it looks like there is a blue pin that you put on that map. What is that pin? Okay. And to the right of that pin, there appears to be what you marked as something for the Verizon phone. Is that accurate? What does that mark indicate?
That mark indicates that phone connected at that cell site at 6:30.
And that's 6:30. Is that the 6:30? And I'm guessing that's 2 seconds. That's indicated by the arrow leading to the little box. And that number appears to be bolded. What's the significance of bolding that number?
I think it's when it's a voice call. The unbolded would be
What sort of data or other messages or other things might lead to a non-bolded call or a non-bolded number on this? Yeah. So you said that phone calls are represented in bold, voice phone calls. Is that correct? What all could be represented in non-bold? Okay. And is that something that a user has to manually try and make a connection for that to happen? Or is that something that just happens automatically? How does that get there? Okay. Going up towards the top right, then it looks like there's a couple more arcs as well as a pin. Can you describe what those arcs are?
Device ending in 9382 and device ending in 8863. With the phone call at 6:30 from device ending in 628. We have a second phone call that happens at 6:59, and that device is now located near the locations of 8863 and 9382.
Okay. So based off of the cell data, it looks like the phone ending in 1428 goes from that southwest area up to the northeast area. Am I understanding that correctly? Okay. Moving on to the next page. Looks like there's a similar date and timestamp at the top left of this one. Is that representative of the same thing, or that's just the data range that you used for this map? Okay. And looking at these, or looking at the map on the right-hand side, what is this map an area of?
This is the map and area of residence.
And is that the blue pin sort of in the top middle section? All right. And it looks like there's the red pins, I believe you indicated previously, were the GPS tether data. Is that correct? All right. What calls were registered around this time?
So we have a last outgoing call at 7 a.m. 32932. Locations begin moving south around 7:06. The distance that is shown with the towers to the right and left. 709. Corroborating the other location as well. We have last registered activity for the network from 9382 at 7:14.
And when you say that's the last registered network activity, what does that mean?
That means the device went off the network.
Do you know if or when that device returned and connected again? When was that? Is that AM or PM of the same day? And you say last outgoing activity for the phone number ending in 8863. It looks like it makes a call. Am I understanding that correctly? Do you know, was that the last activity of the day? How long was it receiving calls or utilizing that same tower? What happened at 4:10? So between 7 o'clock and 4:10 that afternoon, well, was that the same day? So between 7 o'clock and 4:10 of that afternoon, there was no outgoing messages from the phone number ending in 8863. Going to the next page. Looking at the left-hand side here, what is this a map of?
The other locations are just north of the event. We have them starting at 7:45 a.m. So we have phone calls at 7:56 from 0410 to 1428.
And it looks like there's some yellow dots on there. I believe you said that those were cell sites or cell towers. Am I remembering that correctly? And it looks like you have a pin on there for 10006 Willow Road. Am I understanding that part correctly? I'm going to just flip to the next page at this point. On this one, it looks like there's some pictures of some vehicles. What are those pictures?
Bike or seat couch. You could utilize that first license plate reader, which is the most southwestern LBR. Then it moves north, and at 8:32:05, you have the U-Haul, followed by registered vehicle for the couch at 8:48. And then at 9:40, you have a vehicle utilizing another LPR.
And when you say LPR, that's related to the flock cameras that you referenced earlier? Okay. Looks like there's also some phone calls on the east side of this map, right above where it says Romulus. Am I understanding that correctly? How many calls were made at that time at that location? Between whom, or between which numbers? Moving on to the next page. Looks like where you say first outgoing activity, is that the call that you referenced earlier from the number ending in 8863? Right. And looking on your map, at what time does the tether location indicate that the tether device returned to Matthew's address? And the call was at 4:10? And it looks like you say first re-registration. Is that what you were talking about earlier when you said the device reconnected to the network? And that was also at 4:10? Looking finally at this last page, it looks like there's some data tables and some highlights. What are these data tables?
When the device re-registers in the network. So your 8863, that continues to receive incoming calls, nothing outgoing until 4:10. And then on your right, 9382 disconnects from the network, which you can see there's no IMEI connected. And it reconnects again.
Looking at that first table, the 88631, it looks like there's some, I'll go specifically to the incident at 11 and 34 seconds in the morning. It says outgoing voice. What does that mean?
So that means that when it shows the 999, that is going to voicemail.
So does that mean that the phone received a call and went to voicemail, or the phone tried to call someone and it went to voicemail?
Received a call and it went to voicemail.
Okay. So even though it says outgoing, it's someone tried to call that phone. Am I understanding that correctly? Gotcha. And what does the highlighting represent?
The first call.
Okay. Looking at the bottom right, it says in the 9382, that bottom right one says distance to tower. What does that mean?
That's piece of data that's happening. Self-directors. Basically, what they utilize in order to, I guess, to evaluate how they're thinking as a writer, if they're able to generate quick, quick signals to other devices. So it's a measurement for them.
Does that provide accurate locational data? How accurate?
That one can be more accurate than call detail record.
And looking down at the highlighted portion, well, just above the highlighted portion, it looks like we have data between 706 and 709. It looks like there's 4 data points. Am I understanding that correctly? And then there's one at 714 and then not another one until 410. Is that accurate? Okay. One moment, please, Your Honor. Thank you.
All right, Mr. Norman.
So, just for clarification, typically cell towers are broken up into 120-degree segments. And you would agree that although the most common situation is for a phone to connect to the closest tower, things such as buildings, mountains, terrain, other issues, the amount of traffic on a specific tower may cause your phone to connect to a different tower, correct? And that's not an unusual thing, correct? Okay. And aside from being able to tell from the data that we have here that somebody's phone is within this 120-degree angle, you can't tell the distance from the tower. You can't tell any specific address. And you don't know if it's the closest tower or not. So for instance, if we look at page 3, oh, I'm sorry, and these are different carriers. You mentioned that some are Verizon, some are T-Mobile, and some are AT&T. Would all those carriers use the same towers necessarily? Okay. So each carrier may use different towers. Okay. If we look at page 3, for instance, this I believe would be, if we look at just the black angle, at 6:30, there's a phone call somewhere in that vicinity to the left of that angle, correct? And then at 6:59, there is another phone call, 6:59 and 48 seconds. Looks to be about 30 miles away. Also just in that angle from that phone. And based on the map, could that phone have been in Hazel Park? Well, the reality is you're not able to say where it is, right? Just within that angle somewhere. Correct. All right. Do you know how many cell phone towers are between the tower that was connected to at 6:30 and the tower that was connected to at 6:59? Okay. The page is not numbered, so we count. The page with the 3 green boxes on it doesn't have a number on it, I'm sorry.
It's the one after 4, right?
5, I guess that'd be.
Yeah, it doesn't have a number. I just wanna, because I don't think neither does the next one. I'm so sorry. I just want to make sure the record reflects it accurately.
And yeah, so I guess it would be, we're gonna call it page 5. Again, there is a black angle on there, I guess near Sumter Ace Hardware. And that again would just be indicating that the phone is somewhere within that angle, but with no specific address or distance. You didn't have anything to do with the investigation of the actual home invasion that occurred. Sorry, bad question. Did you ever physically go to the location where the alleged home invasion occurred? Okay. And you don't have any idea how long people were alleged to be in that home? Okay.
Mr. Goldstein.
I'm going to assume, unless you tell me I'm wrong, that these pages do not contain all the information that you reviewed in this case. Is that okay? You had an opportunity to very carefully go through all the information given you and pick out the location, pick out the information you felt was relevant, right? You had an opportunity to look through all the phone records. And you are the one who made the decision what was important and what was. And would I be correct in assuming that there were a lot of, for example, phone calls associated with 635-0410 that you didn't think had anything to do with this case, so you did not include them in here?
I based it off instant time and locations.
So if you saw something that you thought was important, it's contained in this document.
Based on time and location.
Yes. Okay. And if you didn't think it was important, you wouldn't have put it in this document. Okay. Because I'm assuming that there were other phone calls made on 635-0410 that you did not include in here, correct? You don't remember? I'm sorry? I understand. So you don't remember. So you think it's possible that these were the only calls made on that phone that morning?
I don't know, looking at the record.
And do you still have, I don't mean with you today, but do you still have those records in your possession? You do. Okay. All right. I'm going to ask you to turn to page, I believe it's 5. In the lower left-hand corner. Well, before I get there, let me stop a second. When you were looking at these records, would they have told you whether a call was actually connected or not? And would they also tell you how long the call lasted? Okay. Now you didn't put that information in these documents, did you? Okay. So, for example, on page 5, it's the one that has 3 boxes, right? Okay, in the lower left, it says that there was a call made from 635-0410 to 280-1428, correct? Okay, and we don't know whether that call actually connected or not, do we? From looking at this document.
I put connected calls.
I'm sorry?
I put connected calls.
You did, so you would not have put that down there if it had not connected? Okay, but we don't know how long the call lasted. Okay. In the picture, or whatever you want to call it above, it says 75639 and gives points at what looks like a cell tower, right?
You're looking at the furthest left one?
Yeah. You got in a little box, it says 75639. 756. Okay? And then there's a line that points toward what I assume is a cell tower. Okay. So that would indicate that at 75639, that call was connecting through that particular cell tower. 14 seconds later, you have another box. I'm sorry, just read that. the number called 280-1428 was at what you got marked as the location of the towers being Sumter Ace Hardware. Is that correct? Okay. And that call connected at 7:56:53. Can you tell whether the 635-0410 phone was moving during that time? Okay. And can you tell me what about the location of that phone at that cell tower next to where it says Oakville? Where does that relate to? Well, you felt that call had some significance, right? Okay, how close to the incident? Well, near could be in some people's minds 10 feet, in some people's minds 10 miles. So my question is, how far?
Yeah, I'll look at the other something area.
Okay, so the answer, don't be afraid to say you don't know if you can't answer the question. You don't know, do you? How far? And can you tell me whether that, I may have asked this, I'm sorry. Was that phone moving during that call? You don't know. Okay. And the other phone, the phone that was connected at the other end, where it says 7:56:53, that was also not at the location. Is that true? Okay. Well, you got it up by what you're pointing to a tower where it says Sumter Ace Hardware. So you don't know the exact location of that phone. Okay. And you don't know whether that phone was moving or not. Okay. Now go to the box on the right. There was a call back from 280-1428 to the 635, correct? And the 635-0410 at 8:25:04, which is approximately a half an hour later, was in the same location, or it was reading, I'm sorry, they're reading the same tower, correct? Okay. But the other phone, the 1428, was not at the same was not reading at the same tower, was it? Okay. It had moved further away from the Willow Road address. Turn to the next page. In the large box, lower left-hand corner, you show 9:40, a call from 635-0410 to 734-280-1428. Correct? Okay, and did that call connect?
It connected, but I don't know the duration.
Okay, but then there's another call from 280-1428 back to 635, and it still says 9:40. So would that suggest that that first phone call was a very, very short duration? And again, you don't know how long the second phone call lasted. Now, you also have on this document two pictures of a dark vehicle. I'm going to ignore the white vehicle for now, okay? One picture is taken at 8:30:31 and shows a location. And 2 minutes and 17 seconds later, it shows another location further north. Would you agree with that? Okay. Was the first location at 8:30:31, where was that in relation to the Willow Road address? And the vehicle was moving away from it. So the vehicle was moving away from that location. And do you agree, ma'am, that you don't know who was driving the vehicle at that time? Okay. On the right-hand side, you show also a picture of what looks like the same dark vehicle. For sake of discussion, we'll say it's the same one. And that was at 9:40:40. Correct? So that was approximately a little over an hour later. Right? And where was the vehicle at that point? Middle Road address? Now, to the left, there are two other boxes. One's got a dark, like a blue border, and one has a red or pink border. Do those show phone calls? Or what exactly do those show? But from looking at this document, we can't say that those are phone calls, can we? Might they have been times that the vehicle, well, no. Let me withdraw that. In general, the records you looked at don't tell us what the contents of the phone call. Is that true? And they also don't say who made the call. You only know what number the call is connected to, but not who made the call. Nothing further here.
All right. Mr. Bergson.
I have no questions, Your Honor. Thank you.
Mr. Brown.
Good afternoon, Mr. Linsky. So, according to the key, the red pin indicates the tether that you associate with Mr. Germond Matthews. Is that correct? Now, I've heard you use the language that these are not exact locations. You also said in the of. Now, in the let's take page 4. There, in the center of that map there.
Said page 4.
Yeah, yes, okay. Page 4. But I'll wait for you. Let me know when you're there. Okay, all right. So in the center of that map there are several of the red pins. Is that correct? And what that is intended to indicate is direction. Is that right? So let's take the top red pin. That says El Randazzo Vegetable Market. You see that one there? Now, indicate that he's in the market. It just indicates that he's in the area of the market at that time. Okay. Now, when you say area of, how closely does that narrow things down?
Did have all that involved. I wasn't referring to area of, that I was referring to the cell sites.
I'm sorry, to cell sites?
To the cell site, all records.
Okay, so pins themselves can't tell us where they were within 5 feet of any given point, or even 10 or 20 feet, can that?
I can't speak what the house renovations did that.
Okay, very good. So what you're saying is that the pins more or less give us direction. They don't give us exact location. Not sure. Okay, so to sum it up, and if I'm not being fair, just by looking at the pins on the map, you can't tell us where exactly he would have been, inside of a location or outside of a location, can you?
Without knowing how they, how house rent work and knowing what they're needed to know, I can't speak that.
Okay. Thank you very much.
That's any redirect.
Thank you. Ms. Zelinski, the concentration of cell towers, does that change depending on the environment? Is it likely to be more cell towers or less cell towers in urban areas? What about rural areas? And then just to clarify, on page 6 of Exhibit 13, the one with the flock camera images, there's 3 images with what appears to be a dark Hyundai. Is that the same vehicle in all 3 pictures? All right. And is that the vehicle that had the license plate registered to Christie Couch? All right. No further questions. Thank you.
Any questions based upon the redirect?
No, Your Honor.
Go.
No, Your Honor.
None, Your Honor.
All right, very good. Thank you, ma'am. You may step down.
We do have a motion when appropriate.
Any witnesses for the defense?
No, Your Honor.
No, Your Honor. No, Your Honor.
None, Your Honor.
All right. Yes.
Your Honor, as to defendants Myron Couch, Jermaine, and Devin, who was moved from Monaco on the information as charged, related to defendant Christie Couch, the people would move to amend the complaint and add account or amend the information to add account to armed robbery, and then move to bind over on the amended complaint, reserved for major argument for rebuttal.
Your Honor, in regards to Myron Couch, that's important, not bind over. I don't think the prosecutor met his probable cause burden in this case. There's been nothing that places Mr. Couch at the address of his home invasion. The testimony here in this court was that the people involved were 6 feet tall. If the court could take judicial notice, having seen Myron come in and out, that he's nowhere near 6 feet. There is nothing that connects him to the home invasion, and also the alleged victim in this case is Myron's cousin. And I would believe that if he were in the home, he could have been identified by the victims in this case. There hasn't been any indication that any of the items that were worn by the people in the alleged home invasion were found with Mr. Couch or connected to him in any way. He is not on any video at the U-Haul place, on any of the block cameras. There's been no testimony that the shirts that they were seen by brothers had anything to do with this crime. I believe the testimony was that they were wearing vest and black, used red headphones. There was an allegation that someone was bitten by a dog. Mr. Couch certainly did not have any dog bite injuries. And the victim in this case said they would be able to identify the person if they saw them again. And again, it was Mr. Couch's cousin. So given the fact that all we have is speculation, based on the phone record, Mr. Couch is somewhere in Washington County, and apparently moving around of 6:30 a.m. and I think according to this ends at 4. That's all we know. That doesn't place him at the scene, doesn't place him committing any crime. So that's court not buying this case.
Mr. Goldsmith.
Before we talk about what the evidence against my client shows, let's talk about what it doesn't show. It clearly doesn't show that she was present at the time of this robbery. The 2 eyewitnesses testified that the people that came into the house that day were black males. My client is obviously not a black male. So I think we can eliminate that part of the argument. And I don't think Mr. Cook was planning on arguing that she was there anyway. I just wanted to get that on the record. So what does the proof show against my client? It shows that on the night before the incident, she rented a U-Haul van. Okay. There's nothing that I've been able to find in my many, many years of experience as a criminal lawyer that says that renting a U-Haul van is against the law. She made it very clear in her comments to the detective who questioned her. She rented the van because her husband was going to help his sister move. Nothing illegal in that either. I guess what the people are going to have to argue in order to convince this court to bind my client over is that she was part of some conspiracy to commit this armed robbery. And you know what this evidence, there's no evidence of in this record, Your Honor, that my client was part of any conspiracy. There's no indication that there was any discussion, that she had any knowledge. Instead, they present some pictures of her driving, not at the location, at different times, and phone calls between her and her husband. And again, I say very distinctly, there's no law that says that a phone call between a husband and a wife is against the law. So what do we have? We have, she rents a van, and there was a video showing her doing that. There's no dispute she rented it. It's her signature. It's her name on the contract. But then later, she's not ever seen driving the van. You have pictures of her driving her car, presumably. Now, I'm making an argument. There's no testimony that she was driving the dark vehicle at the time. A Hyundai, I think it was. But it was her vehicle. So the court could find, by probable cause standard, she was driving it, but not at that location. So where is the evidence that my client had any knowledge that anybody, and I'm not going to say Mr. Couch because I'm not going to point the finger at him. Where does she have any knowledge that anybody was going to commit a robbery the next day at the Willow Road address? And the answer is none. There is no evidence whatsoever. They're hoping that you're going to make a leap of faith from her renting the van the night before to her being somehow participating in what happened the next morning.
Mr. Bernstein.
Your Honor, the tie-in between Mr. Gates and anything else going on here is truly exceedingly weak. There has been nothing that shows that Mr. Gates has any connections to these people or to the complainants. There was no physical evidence uncovered during any search, either at the Biddle home, his home, Matthew's home, or in a U-Haul. There's no eyewitnesses. In fact, I don't think that what the detective sergeant testified to in regards to the phone number was an exact tie-in to my client, Mr. Gates. He said it belongs to someone named D-Rock Gates, and D-Rock Gates was not tied to Devin Gates. Even if the phone number, we take the leap of faith, is associated with Mr. Gates, phones are not people. Phones are not people. And Ms. Zelensky testified in her last question to Mr. Goldstein's last question, that a phone call made, we don't know who made that call. I mean, she's absolutely right. Phones are not people, and not one shred of any evidence that's been presented here ties Mr. Gates to anything else going on here. The lack of connection is stunning. The lack of investigation into Mr. Gates is stunning, and I would ask that the court not bind him over on any of the charges, Your Honor.
Thank you. So, Your Honor, the charges against Mr. Matthews are evasion, robbery, 2 counts of unlawful imprisonment. As the prosecution has presented its case, sometime in January 4th, individuals wearing masks entered into a home without permission, went to the second floor, eventually that's where they ended up. Had an individual, the homeowner, on the floor where they alleged to beat him and pushed him down, grabbed another individual who had come out of a room, pushed her down on the floor too, and then asked them repeatedly, where's the money? And then there's allegations that there was chainsawing, look for money. Based on the information from the tether agent, my client's tether was seen in the area. Now, initially, he tells us that it is of a high degree of specificity, within 3 to 5 feet You could tell where that tether was located, where that became somewhat problematic. During the course of the time period for which this was allegedly occurred, the tether kept popping up at different addresses. He explained that that was either Google's fault or there were mailboxes that were involved. But at any rate, because later he brings more information indicating that they had some different kind of method. Still, there's nothing that accurately or at least consistently places my client inside of the home. Now, we just heard from Ms. Zelinsky. She also indicated that they could say the tether was in the area of, but they cannot say whether it was actually in the home or not. And I guess once the tether agent was questioned, he then tried to say, well, sure, this information definitely shows that he was in the home, but he talked about mailboxes and how things were bouncing out mailboxes. And again, once you look at that information, you're going to see that within the course of time, this incident was supposed to have occurred, that tether pops up at addresses all up and down the street, different neighborhoods, all within the course of time which this was supposed to have been occurring. So the next thing you have to look at what the complaining witness says about the people who were in there. And I believe that that was touched upon earlier by Brother Counsel. He was very specific. Hopefully I'm not taking up too much of your time, Judge. He was very specific. He said, I got all day. Me too.
You don't need to use it, but go ahead. I got all day.
He said the people were tall. They were tall, and that was something great. And I asked about that. I asked him about that very specific. He said the people were tall. He said he's 6'1". They weren't as tall as he was, but they were close to him. That was something very specific. He said. Now, we get the police officer suddenly, with all their training about looking at people and sizing them up, he can't tell you how tall they are. But the court can take judicial notice that my client, is about 5'7". That's not tall. Then the next we get, oh, well, he had some powder on his bicep. Oh, and I'm just certain that that was, some from the sawing. It was the plaster from the sawing. When questioned, well, I can't be sure. Asked if it was sent out to the lab. And no, it wasn't. Can't distinguish it from flour or powdered sugar. I know the court got a little impatient because I stressed that. But the importance of this is they have to try to put my client into the home in order to have a home invasion, in order to have an armed robbery, in order to have the imprisonment. It's important for me to point out to the court, to the court, that the evidence that they're using is speculative at best. That he's in the.
Realize I have no testimony that any walls were cut.
Well,
I have a chainsaw.
Yeah, they said they
no testimony of.
Okay, well,
so
in case
that's why I became impatient.
Oh, okay. Well, I didn't realize. I didn't realize that's what you were thinking.
I know you never realize what I'm thinking. Go ahead.
Yeah, that's some say that's a good thing. But anyway, so the point is they have to put him inside the house for him to be responsible for a home invasion and for the things that he's charged with here. And I think that the testimony as presented, at best, is wishy-washy. It doesn't meet even the probable cause standard where they've shown that it's more likely than not that he was in the home because they're inconsistent. They can't, they start out with 3 to 5 feet. Oh, no, that's not true. It's the mailboxes. And as the one detective I was able to get out of him, again, the court was a little impatient with the home thing. But that's important to show that since we're making a record, we want to know that we're talking about the same things. Down the line, if someone's looking at the record, they have to know that we're talking about the same things. The houses are not close, they're not within 3 to 5 feet. So I would ask that the court not bind over because it is not clear that my client can be placed inside the residence where these things occurs. It is not clear from the complaining witness's description of the people who assailed him that my client fits that description.
Before you begin with your closing, court's gonna take about 15 minutes. And I'll hear.
All rise. All rise. 14A District Court for County of Washington, State of Michigan is now back in session.
You may be seated.
Not that, okay,
Yeah, I know where yours is.
I did call him yesterday.
That's right.
Called.
I did. Did it.
Here we are back on the record in the cases of the People versus Couch, Gates, and Matthews. Closing. Yes, sir.
Your Honor, in this case, the people would agree that there is not a definitive statement from the victims as to these defendants being the individuals that perpetrated this robbery. But I believe that when the court considers all the evidence taken together, the court can find by probable cause basis that these are the individuals who are alleged to have committed these offenses. Beginning with defendant Matthews, we know that he was there at the time that this robbery occurred based on his tether. And while opposing counsel argues the tether can't place him exactly there, the court has the map showing the GPS location that the tether was in the house. The court also heard testimony from the victims that one of these robbers had a tether on him. So I believe by at least a probable cause standard, the fact that we have an individual on a tether where this defendant's tether shows he is doing this robbery, that leads us to believe that he is the one participating in this robbery, and that helped facilitate this. We know that Myron Couch was with Matthews based off of his own admission during his interview with Detective Sergeant Morrow. He tied himself with Matthews and said he was with him. We also have the cell phone record showing that he is near the area of the venue a little bit before and after the offense, consistent with the GPS tether data of Matthews. Specifically at 7:56:53, and this is on page 5 of Exhibit 13, the court can see that that black arc shows Myron's phone in the same area as the
Which page?
Page 5, the tri-picture one. The court can see Myron's phone receives a call at 7:56:53 that appears to be consistent in the rough area that the GPS tether indicates Matthews going towards the address. There is also the evidence that Christy Couch rented the U-Haul that was the suspect vehicle in this offense. And the court can see from the flock images, especially on the next page, showing her vehicle traveling directly behind about 33 seconds after the U-Haul is leaving the scene at 8:32. It's also evidence that she was aware of and helped facilitate this based off of the.
How does that get me there?
So, Your Honor, the fact that she rented the U-Haul and her vehicle is traveling with the U-Haul, I believe goes towards knowledge or her working with that U-Haul. Considering her earlier claim, I believe that she stated to Detective Sergeant Morrow was that she rented it so that way Myron could help the sister move. I believe this goes against that. She's traveling with it after leaving from this incident. I also believe that the court should consider the Cabela's footage where she purchases 3 identical camo shirts, and the victim testified that at least one of the individuals was wearing a similar shirt, and those were purchased the day before the offense. I believe the court can.
I go to my house, I got 3 camo shirts. I don't know what that does for me.
So, Your Honor, I believe that it shows that typically, or let me rephrase this. When we consider that she bought clothing that appeared to be consistent with some of the clothing worn by the individuals that perpetrated this offense the very next day, she rented the U-Haul that was near that address and was leaving that address the next day. I believe that that can show that she helped facilitate this and helped prepare for what was going to be this robbery providing a vehicle, providing clothing, and then also following behind and remaining in communication with Myron Couch beforehand and afterwards. And we can see from Matthews' tethers that he goes to the Couch's address afterwards as well. So I believe all of those things, when taken together, provide at least probable cause to believe that Christy Couch.
Do I have Christy Couch's phone data in the area?
So we have on the page 5, again, we can see that she made an outgoing call a little bit south of the area. We don't have an exact number, as I believe Ms. Zielinski testified, we're not going to have an exact location, but we do have that 7:56 call before the incident occurred of she is somewhere south of the venue where it occurred. And why I think that's important is if the court recalls her statement to Detective Sergeant Morrow that Detective Sergeant Morrow testified to, she claimed to him that she had left her house and begun door dashing, I believe it was 8:30 to 9 o'clock that morning, when her cell phone shows that that was not the case. And I believe that also casts doubt on her statement. She rented the U-Haul for the purpose of facilitating this move with Myron's sister.
But I don't have her at the address.
Correct, Your Honor, and I will agree, she is not directly at the address, but our theory is that she helped plan and precipitate this by providing the U-Haul, providing the clothing, and working with it, if not necessarily at the venue. I believe that she was still aiding and abetting and is liable under that theory.
How close do you put her to that address?
Your Honor, I don't know if I can give an answer to that. I believe that the testimony is that we can't give an actual location based off the cell data. But if we consider the flock data, we can see her, we know that she was to the south of the address at some point close to 8 o'clock that morning. Then looking at.
I know that her vehicle's.
Correct.
I don't know that she's.
And I'll perhaps rephrase it. We know that her cell phone was to the south of the area at 7:56:39 that morning, and we have the camera showing her vehicle leaving that area at 8:30, traveling up with the U-Haul, and then eventually heading back to the Couch's residence, I believe reaching there about, it looks like 8:40 is when the tether from Matthews shows it, and we have camera and calls from about 9:40, so an hour later. So I believe that the evidence taken together shows that she is working with this robbery, if not necessarily physically present at the venue herself. And then finally, for Defendant Gates, I believe there's probable cause to believe that he helped with these events. And for that, I would direct the court to the cell phone records for Gates's phone as well, where we can see he was with, or his cell phone was near Defendant Matthews' location. And the last outgoing activity is 9 seconds after 7 o'clock is that last, or sorry, 1 second after 7 o'clock is that last call. 6 minutes later, we see Matthews' tether going down. And it's not until about 1 minute after Matthews' tether returns that evening at 4:10 that we have an outgoing call from Gates's phone. Now the court can see from, well, strike that. There's reason to believe that Gates was with Matthews because we have the prior activity that's suddenly
with Matthews.
I'm sorry, I didn't hear the court.
What puts him with Matthews?
So, Your Honor, the fact that his phone ceases activity as soon as Matthews leaves and then resumes activity as soon as Matthews begins leads to a belief that the phone was left at the house while he went with Matthews to precipitate this robbery. And I would again remind the court that there were
Not his phone at the house.
Yes, Your Honor.
So there's no activity from his phone.
There was no outgoing activity, I believe was the testimony. I believe there was still incoming and the phone was receiving.
Okay. So I'm supposed to assume that he left the phone because where his phone is inconvenient for the people's theory.
Not necessarily because it's inconvenient, but I believe that there.
Everybody else, though, I'm to assume they're with their phone, except him.
And Your Honor, I believe that there's evidence to support that because we can see at 7:14 as Matthews in the people's position as Gates as well are traveling down. We know Matthews at least is traveling based off of the tether data. his phone disconnects at 7:14, so it shows an effort to remove oneself's phone from the network. And if defendant Gates was with defendant Matthews, as the people are putting forward, that makes sense that they are acting in concert. And
That's double speak. Everybody else, just answer me this. Everybody else, with the exception of Mr. Matthews, who had his own little radar thingy, everybody else, I'm to assume that where their phone is where they are, right?
roughly, yes.
Except Mr. Gates. Because I'm supposed to assume Mr. Gates is somewhere other than where his phone is.
I believe the short answer is yes, Your Honor.
So how does that work?
Because, Your Honor, when you consider the types of activity for the other defense, we have those outgoing calls that shows activity being made from that phone. Whereas Gates' phone, there's only that incoming that shows that there.
So if Gates took a nap and doesn't answer his phone, I'm to assume he's with the robber.
Not just based off that, Your Honor. I believe that the court can find that also based off the testimony that there were these 4 individuals that were in the house. So we know there's multiple individuals.
Okay.
We know
I got 4 supposedly African-American males in this building. I only have 3 here.
Correct, Your
So
Honor.
that doesn't help me, does it?
I believe it shows that it is possible for him to have been there. And the fact that it's at Matthews's house.
I got more than just possible. That's not. The reality is, I have nothing that puts Mr. Gates there. That's speculation.
I would agree that there's only circumstantial evidence, and while it's not as strong as the other
evidence, I have nothing that puts Gates there except speculation. Because it might be one thing to assume that the person is with their phone. I have to speculate that Mr. Gates left his phone someplace and was just traveling without his phone in order to put it there. Don't I?
I believe, yes, the court would have to make that assumption. But I believe, Your Honor, when compared to the alternative being that he just didn't have any activity until Matthew shows up and then he has activity, I believe that's also.
But I gotta put him there.
Understood, Your Honor.
Okay, go ahead.
Ultimately, as I stated, this is, I believe, a case of identity where I did not hear much argument about the facts as far as what happened during the robbery being in dispute, but rather that these individuals were ones that did it. I believe that we have good evidence showing that defendant Matthews was there based off of his tether, based off of the statement that an individual wearing a tether was there. Believe that there's ample evidence to, at least by a probable cause standard, find that Myron Couch was there based off his relation to the family member and the belief that he owed money. These individuals come in asking, where's the money? It's clearly a monetary goal originally, as well as his statement that he's with Matthews, I believe is probable cause to believe that Myron was there and committed this offense. I believe there's probable cause for Christy Couch to have helped in the commission of that offense, and under the aiding and abetting theory, providing the tools to commit this, at very least the U-Haul and the shirts, that goes towards that. And we have already
But one would have to knowingly do that, correct?
Yes. And then we had the discussion regarding Mr. Gates, and so I don't believe we need to rehash that discussion. But for those reasons, I would ask to
don't want to. But hey, let's go back to Mrs. Couch. Tell me everything that puts her there or says she was aiding and abetting.
So beginning sort of chronologically, we have her assisting with the purchase of the clothing at Cabela's, the 3 identical pieces of camo shirts. The victim one of the victims identified at least one of these robbers to have been wearing similar identical clothing. We then have her renting the U-Haul that was used during the commission of this offense. We then have her vehicle following that U-Haul. We know she was in communication with Myron, who, as I've already argued, we have reason to believe was there.
Her husband.
Yes. And then afterwards, we see them again traveling away from the location in close proximity to one another. We have her statement.
How do we have them in close proximity?
So on the flock cameras, we see the U-Haul as well as Christie's vehicle. And
Hold on, you said though, we see them traveling away.
And I should be more clear, Your Honor, I do.
Yeah, you really should, because I don't have we anything. So we see who? What do we see? What are you telling the court?
We see the vehicle that Christie Couch rented being the U-Haul, and the vehicle that Christie Couch is the registered owner of, driving away from the venue shortly after the 911 call was placed. We also have Christie Couch's phone near the venue to the south.
With the evidence you've given me, isn't it equally as plausible? Because he admitted that Mr. Couch is in the white van.
Yes.
That the other defendant, Mr. Matthews, is in her car.
That is a possibility, Your Honor. I believe that's a question for the trier of fact.
Okay. Go ahead.
Your Honor, I believe I've made all of my points. I have no further argument. Thank you.
Any additional response from Mr. Couches, Mr. Norman?
Your Honor, I would just, there was not any testimony linking Mr. Couch. I don't even think that anyone was able to testify that the van that was in the driveway at the home that was seen, no one could ever make the connection that it was the same van that was running by this.
Oh, I think they did.
They did not. When asked whether they could see any identifying markings or anything from that vehicle, all the testimony was no.
Okay.
And again, Mr. Couch was not identified.
Except he puts himself in the van. But anyway.
Very briefly, Mr. Cook said several times that there was evidence of my client purchasing, quote unquote, the camo. There was no such evidence. With the video showing her at the U-Haul place clearly was identified by a witness as being my client. Nobody identified her in the video. That's a sort of a wishful hope by Mr. Cook. Second of all, nobody said that was the same camo. They said it was similar, not the same design, similar. And number three, when I asked the witness with regard to the pictures of the flock pictures of the van, how close were those, or where were those in relation to where the incident took place, she couldn't answer. We only have his argument that they were leaving that location. There was never any testimonies to that.
Mr. Bernstein, any additional?
No, Your Honor, thank you.
Mr. Brown.
Well, Your Honor, when the weapons that were allegedly the firearms were never attached to this case in any significant way, the prosecution asked the witness if I had anything of evidentiary value. I would say that the firearms are not of evidentiary value, and that they haven't been associated with this incident at all. I just wanted to put that out there.
All right. Court's gonna stand in brief recess.
All right. All right. 14A District Court for County One, State of Michigan is now back in session.
You may be seated. We need, back on the record in the cases of the people of the state of Michigan versus Matthew Gates, Couch and Couch. All counsel and defendants are present. Court, listen very carefully to argument reviewed the evidence submitted at the first hearing, as well as reviewed the evidence today. On the, just want to check one thing, folks. In the case of the People versus Matthews, the court would find that there's certainly, mainly because of the defendant's tether, that there sufficient evidence to believe, based upon the testimony of the victims in the case, about the armed robbery and the home invasion, as well as their unlawful imprisonment, that the defendant, Mr. Matthews, was indeed present at that event, that he participated in that event, and there is at least enough probable cause to bind the defendant over as charged on all 4 counts, and the court would indeed bind him over on those 4 counts. As to then defendant Myron Couch, what is also clear to the court is there's enough evidence that ties him to the location, as well as his own statement that ties him to the location or with Mr. Matthews. And the court would find, based upon that, as well as other evidence, that there is sufficient evidence to believe that the defendant, Mr. Couch, committed these offenses, and the people have sustained their burden and bind the defendant over on all 4 counts in his case. The case of Christy Couch, this is one that the court, quite frankly, is much debating. She's charged with 1 offense of retail fraud in the 2nd degree. I would ask Mr. Cook, you said you wanted it amended. Were you trying to add an additional count of armed robbery, or were you indicating that in lieu of the home invasion that she be charged with armed robbery?
The people are going to add a second or count 2 in addition to the originally charged count.
Part of the concern that the court has with this case is I really don't have Miss Christy Couch there at the location. What I do have is, which may be sufficient enough, or at least create an issue of fact, is I have a vehicle that she rented and returned, as well as a vehicle registered to her in the proximity. What I don't have, and admittedly, is the defendant herself there. But I have those 2 things, and maybe that becomes a factual question. The court hasn't put much credence, quite frankly, in there was some testimony about camo dress, her purchase of that. The court doesn't put much credence in, no matter when it occurred. Just because of where it was purchased and the type of item that was purchased, and the individual from Cabela's own statement that they sell a lot of it. So for those reasons, and I will admit reluctantly, I am going to bind the defendant over to stand trial on count 1. The court is declining, given the insufficiency of evidence for her participation. I don't believe that there's been anything that puts her in there, in that home, nor anything that indicates that she would have had knowledge of what ultimately transpired in that home. And so for those reasons, the court will bind the defendant over only on the charge count of count one. I'm declining to add count two. With respect to Mr. Gates, now listen to the first testimony or the first day of testimony in the case. And I laughed. There was a thought in my mind as to why Mr. Gates was here, that we didn't have, nothing had been submitted to me at that time, but I would have figured that in the continuation of the proceedings that there would be evidence regarding Mr. Gates. I'm greatly disappointed, quite frankly. I don't know how the people would proceed on theories in case after case, and in this case, where the location of people, which is supposed to signify their participation, and may or may not, is defined by the location of their cell phone that puts them in the vicinity of something that has transpired. See it all the time in cases. In this case, what this court is supposed to do is say, you were someplace near somebody. We then have your cell phone, but it's elsewhere, but you must be somewhere else. I don't even know how that, I don't even understand that. I can't. It doesn't make any sense. I quite frankly believe, and you will rarely ever hear me say this, I don't think Mr. Gates should have been here over these 2 days. I don't think he should have been facing any of this unless the people would come forth with more sufficient evidence of somebody's participation, at least minimally in a crime. Therefore, as to all 4 of his counts, this court is going to decline to bind the defendant over to stay in trial, and the charges against this defendant are dismissed. Mr. Norman, as to the arraignment of your client.
Your Honor, my client's 49 years old. There's no, sorry.
As to the arraignment, you waive formal reading. Your client stands mute. All right, defendant having waived formal reading, standing mute, court will enter not guilty plea. Mr. Goldstein, as to
Your Honor, we acknowledge receipt of the copy of the information. My client stands mute. Yes, I'm not guilty plea be entered.
defendant having waived formal reading, standing mute, court will enter a not guilty plea. Mr. Brown. As to your client, Matthews.
And we acknowledge receipt of information. My client will enter a plea of not guilty.
Defendant having waived formal reading, pleading not guilty, court will enter that not guilty plea. Pre-trial in these matters will be set.
September 11th, 2025 at 1:30 with Judge Simpsons.
September 11th, 2025, 1:30, Judge Slay. Bond in each case will continue. Ms. Linda.
Good morning, Your Honor. Ally Zend on behalf of the people.
You may be seated. Ms. Linda.
Good morning, Your Honor. Ally Zend on behalf of the people. Your Honor, the people would waive any potential conflict between this honorable court and the office of the public defender. While the people don't believe such a conflict exists, the people make this waiver in avoidance of all doubt.
Good morning, Your Honor. Lauren Brown, Deputy Chief Public Defender. Your Honor, we likewise do not believe that there is any conflict in this honorable court hearing these matters. If a conflict were to arise, we'd waive such conflict so that this honorable court could hear these matters.
Thank you. The court, for its part, also does not believe there's a conflict either in the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent. Michigan versus Seth Priester.
It's the Richard McDuffie on this case in Copeland.
Okay, yes. He's on this. And. Okay. Got it.
Good morning, Your Honor. Wendy Barnwell, P42505, on behalf of Mr. Seth Priester.
Good morning, Seth Priester.
I'm gonna go and start again.
What happened?
Are they okay back there? Okay, go ahead. And Mr. Priester, can you state your name again, please, sir?
Your Honor, Seth Priester.
Thank you. All right, what are we doing?
If we could call the co-defendant case, Ms. Constantino wants to approach.
Sorry, Judge. I know. First case, I'm causing havoc already. Judge, my case is DeBossier Henning. He's in custody.
Got that? You got that one?
Yes.
Why do I have?
My voice.
Coming from somebody that I need to mute over there. I believe Mr. I'm looking for the co-defendant case.
This is the way to start.
Sorry, Judge.
Got it?
No.
Court also, where is he? Is he in
He's in custody.
with
Yes.
them?
Yes. And if the
You
court,
want me to call it without him coming out? Can we please? Because Miss Constantino has asked,
sorry.
irrespective of what we were actually doing today, could we have Mr. Hennings? Thank you, sir.
Judge, would the court mind if we approach in the interim, just to keep things going?
Oh, it's too late for keeping things going. But, oh, yeah, come on. Okay, record should reflect you had an extensive bench conference in this case. Can you state your name, please?
DeBossier Henning.
And in this matter, I will adjourn the probable cause conference to July 31st, 2025 at 9 a.m. And hopefully the issues of everything will be worked out. I will allow Miss Barnwell to appear via Zoom, but you'll still need to file the form. Okay. Bond on each of these cases will continue. Thank you.
Thank you, Judge.
That's the reason.
Got it.
Wondering why.
Got it. Okay.
Court does call the case of the People versus Marcus Claiborne.
And then on behalf of the people, Your Honor.
Good morning, Your Honor. Tina Saxon on behalf of Mr. Claiborne, who's approaching.
Your name, sir? Marcus Claiborne. Thank you. You're requesting an adjournment.
Yes, Your Honor.
During the matter, probable cause conference will be adjourned August 7th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Court does. Mr.
Goodell, you need to move so that.
Oh,
sorry. Thank you.
Short court calls the case People versus Sean Billou, Billadu.
And Edward Lucas on behalf of Sean Billadu.
Your name?
Sean Billadu?
All right. You're requesting an adjournment on this?
Yeah, I think we are close in with negotiations. I'm asking for at least a week or two.
August 7th, 2025, 9 a.m. Bond continued. Thank you.
Thank you, Aaron.
Court does call the case of People versus Gregory Bell. Really?
Andrew Bannister for the people. Kyle Bedell on behalf of Mr. Bell, who's approaching the podium. Mr. Bell, please introduce yourself to the court.
Good morning, Your Honor. Gregory Bell.
Your Honor, today's the date and time set for probable cause conference. The people did extend an offer. Mr. Bell would like some time to think about that and as well to complete the proper form.
August 7th, 2025, 9 a.m. Bond continued.
Thank you, Judge. And I'll come back to you.
Court calls case People versus Anthony Alfaro. Yes.
Good morning, Your Honor. Zach Bonham on behalf of the defendant.
You're gonna need to.
Oh, I'm sorry. I forgot he was.
Yeah. Your name, sir?
Anthony Alfaro, yes.
All right.
Good morning.
Good morning. Yeah. All right. What are we doing in this case?
Your Honor, we've had a conversation with the prosecutor's office. They've extended an offer, and I need some time to review that with my client. So we'd ask that we reset this to another date, and then after that, I'd like to address bond if I could.
Is it the order that was submitted to the court?
It was the proposed order, Your Honor.
All right, I'll have to hear your argument on that. Pardon? Got it. All right, so you need an adjournment of this?
Yes, Your Honor.
Probable cause conference will be adjourned to, you want the 31st or the 7th since he's in custody?
I would take the 31st, Your Honor.
July 31st, 2025, 9 a.m. As to bond.
Thank you, Your Honor. My client's been in custody for over 30 days now. He had an outstanding warrant on a vehicle for a misdemeanor registration that's been resolved as a civil infraction at this point as of June 24th. He doesn't have any prior convictions for violent offenses. He had a strong work history of over 5 years as a manager at Los Amigos in Ann Arbor. He's most likely lost that employment now due to his detainment. His family needs his financial assistance. He has a very strong family relationship in the area. He's retained our office to represent him in this matter. Since he's been in custody, he's been enrolled in AA classes. He's working in the jail's kitchen. So we're asking that he be released on a bond. I would ask for a PR bond. I know the prosecutor's office in the proposed order I provided you, they would be requesting home confinement. I won't speak on her behalf, but that's something I know the prosecutor's office is asking for. If that's something that would persuade the court to allow him to be released, so be it. And any other conditions that the court would impose. If it was home confinement, we would just ask that he have the ability to travel for work purposes, school, medical appointments, etc.
Response.
Thank you, Your Honor. I did have a chance to speak with counsel as well and express my concerns on this case. As the court knows, the bond violation is the second case involving the OWI and some other issues. I don't have an issue with him being released to home confinement. I would request some form of alcohol testing, whether that's a sober link or scram tether, due to those circumstances and alcohol kind of being a theme throughout some of these cases.
So you're saying the drunk driving was a violation of his bond?
The case in its entirety was the violation. It occurred after his arraignment on the prior case.
That didn't answer my question.
I'm sorry, can you?
The 15th District Court case is the violation. For which one came first?
The 14D case came first, 25.
Thank you. That's what I need. All right. Anything else on this?
No, Your Honor.
All right. I will grant the release on this. I'll give him a $15,000 personal recognizance bond. Defendant, prior to release, will be placed on a home confinement tether, as well as, what was the alleged BAC in his drunk driving case? You can finish these.
Yeah.
She's not here today. That will be, well, let me do it this way. The GPS tether will be a home confinement tether, and you don't know the BAC.
Unfortunately, Your Honor, can I pull this up?
We'll just put him on a sober length then. Testing device. All right. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Court does call the case, People versus Carlos Self.
Andrew Vance for the people. Kyle Brittle on behalf of, but not with Carlos Self. You understand that there is a violation. I have not been able to contact him. I do have a good number, but I've just not been able to reach him. Asking for a show cause at this time.
Well, he's showing up, the violation report is he's showing up with cocaine now in his system. So a bench warrant will issue for defendant's failure to appear until we get him no bond.
Understood.
That will issue immediately.
Understood. What's the dollar amount, Your Honor?
Pardon?
What's the dollar amount?
No bond.
Oh, no bond. Oh, thank you. Understood.
So that would be a 0. Court does call the case, Other People versus Robert Galit.
Hey, here, Richard, we for the people on both nights.
Alex Warren Green on behalf of Ms. Gallant in the matter ending 5713.
Good morning, Your Honor. Jake Kilwall, Judge, I'm on 5612.
Robert Gallant, also known as May.
Thank you. All right, what are we doing?
Judge, we're working on a possible resolution in this matter. We've spoken to my client. We're asking for a 2-week adjournment.
I would join that request, Your Honor. I'm completing a green sheet right now.
One of these doesn't have a green form, I think. Mr. Kilowog. Probable cause conference will be adjourned to July 31st. Will that be enough time for you guys to get done what you've done?
I believe so, Your Honor.
July 31st, 2025, 9 a.m. Bound continue.
Thank you, Judge.
Thank you, Your Honor.
Court calls case People versus Michael Ware, 2 cases.
Thank you, Richard.
Edward Lucas on behalf of Michael Ware.
Stephanie Cannon on behalf of Mr. Ware as well, Your Honor.
I'm an 863. And I just talked to him on the phone. I understand he's late. I'd be asking if the court could pass it.
And I would ask as well, Your Honor.
Where is he?
He said he was 10 minutes away, and that was about 5 minutes ago.
Call it up. Well, then, call it up in 5 minutes. We better be here. Now he's getting a warrant.
Thank you, Your Honor.
Court calls case Other People versus Tubbs.
If you Richard, for the people.
See, and I didn't call it like I normally call it.
Morning, Your Honor. If I'm the only one here on 1038. Judge, I was.
Your name, sir?
Oh, I'm sorry.
Is that how you say it, really? Okay, all right.
Judge, I saw Shaquille last night at jail. I told him I had just been appointed. It's my understanding Ken Overwater is trying to get this young man into a recovery court with Judge Kuhnke. We're working on that. I explained to him I would be asking for a 2-week adjournment.
You said he's in recovery court, or they're trying to get him
It's
in?
my understanding he was initially denied several months ago. They're retrying him, so it's going to take a little bit of time.
Hearing no objection, I'll adjourn this to August 7th, 2025, 9 a.m. Bound continue.
Thanks,
Thank you. Court calls case People versus Riel Boyd.
Ready, Your Honor.
Haley Zinn on behalf of the people, Your Honor.
Jay Columbia, Ms. Riel Boyd.
Riel Boyd.
Judge, we're working on a resolution, possible resolution to this matter with the prosecutor. We're asking for a
Probable cause conference, August 7th, 2025, 9 a.m. Bond continued.
Thank you, Judge.
And you gotta give me that countdown there. Court calls case People versus Devontae Owens.
Good morning, Your Honor. Please, this honorable court, Brandon Bird on behalf of Devontae Owens. Mr. Owens, can you please state your full name for the record?
Devontae Lawan Owens.
Thank you. All right. Sir, what are you asking for?
Respectfully requesting adjournment, Your Honor. I was just appointed yesterday.
Yesterday. Probable cause count.
Sorry, I'll speak with Mr. Bird as well, but I have been speaking to the sheriff's department. I know there's been a lot of ongoing investigation that's still happening, as well as cell phone analysis. I know specifically with respect to Mr. Owen's phone, so I'll make sure that discovery is shared as fast as possible.
All right. Do you think you'd be able to get enough of that information at least to council by the 31st, or do we need to go out one more week?
If we could go one more week, that would be my preference.
Any objection, council?
No objection, Your Honor.
Probable cause conference, August 7th, 2025, 9 a.m. Continue. All right, thank you.
Thank you.
Yes, sir. Court does call the case of the People versus Theophilus Smith.
Ooh. Thank you, thank you, thank you. Judge Simpson, I can speak,
This is your case.
yes, I can tell you what happened. I've been in jail for 100.
Hold on. Theophilus.
We're ready in this matter, Your Honor. Lauren Brown, Deputy Chief Defender, appearing with and on behalf of Mr. Smith, who appears by Zoom. Mr. Smith, could you state your name for the record?
Theophilus D'Angelo Smith.
All right, you're requesting a forensic evaluation?
Yes, I think this matter is still,
No,
there's
I
one
can speak for my, Lauren Brown, please don't say that. Please don't say that. That's insulting my intelligence. That's insulting my intelligence. No. You ain't even advocate with me. I will speak on my own behalf. And then you can
I
tell
believe
me.
there's one that's pending already here.
Your Honor, the last update I have from May is that he was found incompetent but restorable, and
Right.
today was it had been scheduled on the 31st to check in.
No, come on, like,
And
come
we,
on.
so
Can I
has the court,
please? Can I speak, please?
one moment, one moment, please.
I can easily, I don't want to have to do it, but just let
It's
me
already been
speak,
sent
please.
out for one.
You get a chance, but wait on just a minute so that we can make sure that what you say has meaning.
No.
Has the court received an
Every
updated?
word I speak, that mean I
I
say
am
something.
not. All right, Mr. Smith, I'm not gonna try to talk over you.
Okay, go ahead.
I am not gonna try to talk over you. So if you wanna keep doing that, then I'll just mute you. Have a seat. Let me. Okay. Or dance.
Please, no, I need to speak. I don't got time to be, I speak for myself.
Okay, Mr. Smith. You need to have a seat and don't interrupt me.
So, Your Honor, has the court received an updated report with respect to Mr. Smith?
I have not. We
have nothing further to present at this time. Would you request that this matter be adjourned so that we can get an updated report?
And on a new case, requesting a forensic.
Yes.
All right. So on both of these matters, the one is set for a competency review.
Right, exactly right. The other is just tagging along with it.
So the new one, I'll set a competency we don't have a new report, but one is coming in soon. So why don't you give me 45 days? Well, let's just give me the 90 and then
October 23rd.
I'll adjourn this to October 23rd, 2025, 9 a.m. Mr. Smith, you're muted.
My life.
All right. Mr. Smith, what do you want to tell me? I'm going to give you 2 minutes to tell me what you want to tell me.
Me sleeping in the worst cell and radiation. Me can't lay down without men feasting over me when I wake up. I gotta pray hard. I gotta sing, and the Holy Ghost be in me. And they praying over me. They beat me. I'm just saying, an ends to a means. Like everything's been recorded. Everybody know everything. Simpson, please, Simpson, do America a great justice. Injustice anywhere is a threat to justice everywhere. Please,
Okay.
I can tell you more. I can tell you names. I'm tired. I'm scared to tell everything while I'm in here. My family is scared for me life. No, just do the right thing. I just ask you. I believe you are a judge that speaks justice. I believe you will just come on, just do the right thing. And my Lord, I trust. Amen.
I've done the right thing. We'll see you at the next hearing date, okay? Thank you, Mr. Smith. You can mute it now. Bond continued. Court recalls the case of the People versus Michael Ware.
Stephanie Cannon on behalf of Mr. Ware as it relates to case number ending in 5134.
On behalf of Michael Ware.
Here?
He said he was in the parking lot here.
He said he's in the parking lot?
And so I'm looking.
Told me 10 minutes before.
I know.
We needed 13.
What?
We needed 13
13 what?
minutes. Right.
I have a progress report. I don't have a bond violation.
Yes, Your Honor, I have a progress report. I don't have a bond violation.
You guys are gonna try to stall. Bench warrant with issue for defendant's failure to appear, bond 10,000, cash surety, that warrant will issue immediately. They need to be here.
I understand, Your Honor. Your Honor, what was the bench warrant? Again, 10,000 cash shorty?
Yes, ma'am.
Thank you.
Okay. Court calls case People versus Haruska Dennis.
On behalf of the people.
Good morning, Your Honor. Christina Costantino appearing on behalf of Mr. Haruska Dennis, and I'm appearing in case number ending in 1150.
And this is the public defender's not appearing. Your Honor, on the other matter, representative Diane.
All right, what are we doing?
Your Honor, this is a date and time set for a PCC in this matter. We did receive a mitigation report, I believe, just a couple days ago that was just very recently submitted to the prosecution. Given that, we would ask for an additional PCC to have time to complete those negotiations.
And that's our request on our matter as well, Your Honor.
On 31st of the 7th.
Judge, I would ask for the 31st, given he's in custody.
Yes. Probable cause conference will be adjourned July 31st, 2025, 9 a.m. Bonds will continue.
Thank you, Judge.
Court calls case for the People versus Tanya Hall.
Morning, Jacob on behalf of Ms. Hall. Tanya, are you here? Judge, as you know, Ms. Hall is homeless. She's been staying at the Delana Center. I went there, they would not tell me, they could not confirm she's there, but I know she's there. I left a note. I never did speak with her. Would the court be gracious enough to give me one more adjournment to find her? Apparently I left a note, apparently she
I have a
came.
cocaine test, a test positive for cocaine, and then she missed. So I might under the circumstances, but I'm not going to at this point. I'm going to issue a bench warrant for failure to appear. Bond is set in amount of $25,000 cash surety. That warrant will issue immediately.
Thank you, Judge.
Thank you. Court does call the case People versus Mario Crawford.
Good morning, Your Honor. Assistant Public Defender Alexis Zerp speaking on behalf of Mr. Crawford. Can you please state your name for the record?
Mario Crawford, Your Honor. Thank you.
Your Honor, we'd respectfully requesting an adjournment. We believe we are close to a deal with the people and we would just need a little bit more time.
Probable cause conference, July 31st, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls case People versus, is it Chantel Bray Page?
For the people.
And greetings, Your Honor. Emmett Greenwood on behalf of the defendant. My client is in person.
Your name, sir?
Chantel Burpage.
All right.
Yes, Your Honor. Prosecution has graciously provided me all the discovery, so we're respectfully asking that we have an in-person exam.
Later, we have it.
Yes.
Discovery being complete. Would people have their witnesses available? That would be the day. August 5th.
The Charvettes.
Preliminary examination, August 5th, 2025, 9 a.m. That is in person before Judge Fresh Hour.
Okay, and that's what date was that again, Your Honor?
August 5th.
Yeah, that's no problem. And Your Honor, may I address Bond very briefly?
Very briefly.
Yes. My client has requested that he either stop having a drop or at least reduce the amount of drops. He hasn't tested positive or anything, but it's creating such a financial drain on him and his family that he doesn't know how he'll be able to complete all that.
What is his current schedule?
Every week, at random.
Every week?
I just got a call every day and
well, given what appears to be the drug in here and his drug of choice, weekly testing is an appropriate testing.
Would you consider bi-weekly? Would you consider bi-weekly?
I will not. You can bring it up before Judge Fresh Hour after the exam.
and I got a court date on the 5th too, in Canton. I think it's at
So
9
you can't
o'clock.
do the 5th?
I would have to adjust it with them. This is more serious than the other stuff, so.
Pardon?
I said this court date is more serious than the other court date, so.
Well, Your Honor, if he has a conflict, maybe we can do another date. Because we're ready to go.
Would the people be ready on the 29th, a week from today?
I doubt it, Your Honor.
And the next date I have would be the 12th.
That's fine for defense.
August 12th, 2025, 9 a.m. It is also before Judge Fresh Hour.
All right, in person. Thank you so much. You
All
all take
right.
care.
Thank you. Court does call the cases of the people versus Matthew Fonseca.
And Alex Warren Green on behalf of Mr. Fonseca. Mr. Fonseca, could you state your name for the court?
Matthew Lewis Fonseca.
Your Honor, today's date and time for probable cause conference. At this time, we're asking the court to adjourn these matters so that I can continue my negotiations with you.
Probable cause conference, without objection, July 31st, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Court does call the case People versus Deja Moore.
Christina Costantino appearing on behalf of Ms. Moore, who appears via Zoom. Ms. Moore, can you unmute, turn your camera on, and state your name for the court?
Deja Moore.
Thank you.
Judge, this is the date and time set for PCC. I believe discovery is complete, so we would be asking to have this matter set for an in-person preliminary examination.
People have their witnesses available the 5th.
Judge, I apologize. I have.
No, you don't.
I have.
No, you do, but you don't mean it.
I do, but.
The 12th or the 29th?
The 12th would work wonderfully. Thank you, Judge.
Not a problem. Preliminary examination will be in person, August 12th, 2025, 9 a.m. That is before Judge Valwell. Bond will continue.
Thank you, Judge.
Thank you. Court calls case People versus Jonathan Hughes.
Public Defender Hannah Apple appearing on behalf of Mr. Hughes, sitting in for Attorney Ms. White. Your Honor, we're asking for an adjournment. Mr. Hughes has some other cases that are pending.
Your name, sir? Mr. Hughes.
This other matter is on August 7th.
Before whom?
Before Your Honor, for another PCC.
So he has another
PCC, yes, Your Honor.
I'll adjourn the probable cause conference August 7th, 2025, 9 a.m. Bond will continue.
Thank you.
Court calls case People versus Tyrone Smith, the 4th.
Alexander on behalf of the people, Your Honor.
Yes, Your Honor. Brandon Bird on behalf of Tyrone Smith, also known as Tyre Smith.
Tyrone Smith, the
Thank
fourth.
you.
Respectfully, we'd like to set this matter for exam, Your Honor.
Discovery is complete.
As far as I know, Your Honor.
People have their witnesses available the 5th. Preliminary examination in person, August 5th, 2025, 9 a.m. That's before Judge Fresh Hour. Bond will continue.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Court calls case People versus Savannah Crittenden.
Have a great day, too.
You do the same.
Good morning, Your Honor. Robert Ellman with it on behalf of Ms. Crittenden. Ms. Crittenden, can you please state your name for the record?
Savannah Crittenden.
You're requesting an adjournment. You were just recently appointed.
Yes, Your Honor. I was just appointed yesterday, so I don't have discovery yet on this matter. However, when appropriate, I would like to address bond.
Adjourn the matter July 31st, 2025, 9 a.m. Yes, that's the bond briefing.
Your Honor, it's my understanding that these alleged incidents allegedly took place at an extended stay hotel while Ms. Crittenden's apartment complex was under construction. She has before staying in that extended stay hotel, had not known, and I would argue still does not know, the alleged complaining witness in this case, has no reason to have contact with them. I'm still trying to determine whether the construction at her apartment complex is complete. But Your Honor, I think that given the circumstances, I'd be asking for a release on a PR bond with a DPS tether with potentially a no-go to that extended stay hotel.
Response.
Your Honor, we would ask that the bond continue as set until the next probable cause conference date. The defendant was under investigation for criminal sexual conduct with a minor. That investigation was furthered for other information to be obtained. Ms. Crittenden was advised not to have any contact with the minor or his father, although there was no bond condition. She immediately went back to the hotel, had contact with the minor and his father. Police had to be called. The police came out, instructed her not to have contact with the minor and his father. The police left the hotel and were dispatched back again. She was in contact with the minor and the father, and making threats, hence the stalking charges. So we would ask that that bond continue.
And Your Honor, if I may,
Yes.
again, I just want to make sure it's clear. The CSC allegations, it's the same complaining witness as in the stalking charge. And again,
I'm just gonna get that.
so I just want to make sure that was clear, Your Honor. And again, I don't believe she has any reason to have contact with them. And I think a GPS tether with a no-go.
But as I understand, she was told, she was under investigation for a CSC, told not to have any contact with this specific individual as well as his father.
And she denies those allegations, Your Honor.
Understood, but the allegation is that then the police were called back twice after she was informed of that, and that there were threats, which, as Ms. Reiser's indicating, have led to the stalking charge. I'm actually, given those allegations, surprised that her bond is set so low. Motion for bond reduction is denied.
Thank you, Your Honor. One more thing, Your Honor, I apologize. I was hopeful that Ms. Crittenden would be released and then we could have an afternoon spot on the 31st. I do have a conflict in the morning.
You can talk about this, well, no, it's gonna be in the morning.
Right, no,
Put it on the 7th.
that's what I'm asking for, Your Honor.
All right, probable cause conference, August 7th, 2025, 9 a.m. Bond will continue. Motion for bond reduction having been done.
Thank you, Your Honor.
Court does call the case of the people versus Kareem Davis.
Andrew Banish.
Attorney George Long, P79687, appearing on behalf of the defendant Kareem Davis. Please state your name for the record.
Kareem Davis. Has a substitution been signed up?
Yes, Your Honor.
I haven't. I don't know. Was there a substitution?
I have not received a substitution just yet. Oh, he's got it in his hand.
Okay, what are we doing in this case?
Today's date is set for a probable cause conference today. I've just recently been retained, Your Honor. I have not had an opportunity to review the discovery, request an adjournment.
All right, I'll need a green sheet from it.
And an order for discovery, if I may.
Pardon?
An order for discovery as well.
Why would you need that?
About discovery, I think typically, it'll come from the public defender's office, but of course, I'm happy to make sure Mr. Long gets everything.
Thank you.
That's my order. He's out of custody. Do you want the 31st or the 7th, sir?
31st.
Probable cause conference, July 31st, 2025, 9 a.m. Bond continued.
Thank you.
We'll need that sheet back. That's out the green sheet. Court does call the case of the people versus Adrian Harrison.
Alexander, we have this meeting, Your Honor.
Good morning, Your Honor. Robert Elvin with and on behalf of Mr. Harrison is approaching. Mr. Harrison, when you get to the podium, can you please state your name?
Adrian Harrison.
You're requesting an adjournment.
Yes, Your Honor. I've been in discussion with the people regarding a potential resolution. You should also have in your file there an order modifying Mr. Harrison's bond so that he can be released treatment. I have been in contact with Dawn Farms about securing Mr. Harrison treatment. They've informed me that they cannot start the process of onboarding him until his bond is modified to allow him to actually be released. So that is the purpose of the order.
I don't have a problem signing the order, but I would need that, go in order to that effect. But I would need a condition that if he does not or leaves treatment, he is to report back to the Washtenaw County Jail.
I'd be happy to prepare a new order, Your Honor, or if you,
I'm not signing this one.
okay. Can we pass that and I'll write that in?
Here. I don't care how he does it. What date did we want this moved to?
Then I'll be back to you, I know.
Your Honor, can we do 3 weeks?
The 12th? Or the 14th, I'm sorry.
That would work for the people.
That works for me, Your Honor.
Probable cause conference will be adjourned August 14th, 2025, 9 a.m. Bond continued. Bond continued. I will sign the order allowing his release to inpatient.
Thank you, Your Honor.
Thank you. Court calls case People versus Stephen Wainwright.
Thank you, people. This is Public Defender Hannah Apple appearing on behalf of Mr. Wainwright. Mr. Wainwright, will you please state your name for the record?
Stephon Dallas Wainwright.
Thank you. Your Honor, I'm asking for an adjournment. We are having some conversations regarding negotiations, but additionally, we do not have the video discovery for the case, so we need an adjournment.
All right. So I'll need the green sheet.
Yes.
How much time did you need? Just one, the 31st will work for you?
Yeah, I believe so, Judge.
Probable cause conference will be adjourned July 31st, 2025, 9 a.m. Bound continue.
Thank you.
Thank you.
Mr. Can I approach?
Thank you. Case of the People versus Zdravko. Is it Kitanov?
All Brown Deputy Chief, written on behalf of Mr. Kitno. State your name for the record.
Zdravko Kitno.
Okay, so that's still working.
All right. What are we doing?
There's a mitigation report that's outstanding. We probably need a 2-week adjournment to make sure that gets completed.
Without objection. Probable cause conference will be adjourned to August 7th, 2025, 9 a.m. Bond continues.
So what was the date again? Your Honor?
August 7th.
Thank you so much.
The last court calls case People versus Sean Hardman.
Good morning, Your Honor. Christina Costantino, standing in for Attorney of Record Sydney Rushing on behalf of Sean Hardman. Unfortunately, Judge, it doesn't appear that Mr. Hardman is here. I did look for him in the galley, and I don't believe he is here. I'm sure there's a very valid explanation for his non-appearance, but we would ask the court to consider an adjournment.
Just there's a bond violation.
I do see it. Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $25,000 cash surety. That warrant will issue immediately.
Thank you very much, Judge.
Thank you. Oh, Rushing, she should be here to take her own bench warrants. Court calls the case People versus Nicole McCauley.
Madam Judge, Marshall Feaster, First Assistant Public Defender, on behalf of Ms. McCauley, who is approaching the podium.
Oh.
Good to see you, Judge. State your name for the record.
Nicole McCauley.
Thank you, Judge. I have taken the.
It's nice to see you.
Yeah, you as well. You as well. Find my. Okay.
Kind of missed you.
Well,
Where you been?
I miss being here, Judge.
There you go. Otherwise, you would be here.
I don't make my own assignments, Judge. I go where they tell me.
Oh, you've got some pull. Anyway.
It's good to see you. I've spoken to Ms. McCauley, Your Honor. I believe she's requesting an adjournment so we can review the discovery that was tendered by the people. She does want me to make a bond request, Your Honor.
Go ahead. I will. Well, first of all, I'll adjourn it to July 31st.
Okay. Sorry, Judge. Ms. McCauley has a case out of Wayne County that she has a release to a treatment facility on to Naomi's Nest.
Yes.
She is asking if Your Honor might consider a release to treatment in this case as well.
That would be, it was released to inpatient at that facility.
Yes, sir.
Okay, once again, I'm not gonna have a problem with that. So if you submit a stipulated order to me allowing that release, but unlike what Mr. Elman did, you could put on there that if she fails or leaves, we'll need to return her to Washington County Jail.
Fair enough. Will do. Thank you, Judge. Okay, so he said.
All right, so at this time, our bond will continue.
Thank you.
Court does call the case, People versus Todd Averman.
And Alex Warren Green on behalf of Mr. Ammerman. Mr. Ammerman, can you state your name for the court, please?
You'll need to unmute. There we go. State your name.
Todd Ammerman.
All right. I have before me a plea form that indicates that he's going to be pleading guilty to the charge of use of methamphetamine. Upon his successful plea to that charge, count one would be dismissed. That's the court's full understanding of the agreement.
That's our full understanding, Your Honor.
Mr. Ammerman, can you raise your right hand, please? You solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name again for the record.
Todd Ammerman.
All right, sir, it is this court's understanding that you are going to be pleading guilty to the charge of use of methamphetamine. That is a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. Do you understand that, sir?
Yes, sir.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Freshour in the 14A4 District Court. You understand that?
Yes.
Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those rights?
No.
Looking at paragraph 5, those are your rights which are part of a trial. You understand that by pleading guilty, you're giving up those rights as well as other rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes, sir.
and of your own free will.
Yep.
And because you believe that you are indeed guilty?
Yes.
Where's that comment from? On the date of October 11th, 2000. Okay. It's his device. Mr. Ammerman, however you had your device set, you changed the settings tab.
Hello?
Hello, can you hear me?
Yes, I can.
Okay. Either that or somebody came into the room. On the date of October 11th, 2023, location,
Yes, I did.
had you used it?
Earlier that night, yes.
And did you know what you were using was methamphetamine?
Yes.
Counsel, have I complied with the court rule? Well, I won't ask that at this point. Sir, you do understand that if you commit misconduct between this time, if I accept your plea between this time and the time of your sentencing, that any evaluation or sentencing recommendation, the court would no longer be bound by, and you also would not be allowed to set aside your plea in this case. Do you understand that, sir?
Yes, sir.
All right. Counsel, is counsel aware of any other promises, threats, or other inducements that have led to this plea?
None from the defense, Your Honor.
Have I complied with the court ruling? Would it be proper to accept the defendant's plea?
And the defense is satisfied. Thank you, Your Honor.
Court will accept the defendant's plea of guilty to count two. Count one is dismissed. Pre-sentence investigation and report is ordered at 1484 probation. Sentencing will be
September 30th, 2025 at 9 a.m. with Judge Freshour.
September 30th, 2025, 9 a.m. before Judge Freshour. Bond will continue.
Thank you, Your Honor.
Court calls case People versus Ahmad Metwali.
Ready in that matter, Your Honor.
Thank
Honor, Lauren Brown, Deputy Chief Public Defender with and on behalf of Mr. Metwali. Mr. Metwali, state your name for the record.
Ahmed Mitwalli.
Thank you, sir.
Your Honor, today is the date and time set for the probable cause conference. That's a little bit of history. Mr. Metwali was originally scheduled for a competency review. He has since been found competent. There's a criminal responsibility evaluation that is still outstanding. However, we have chosen to waive our right to preliminary examination and agreed to have this case bound over to circuit court where we will await the finding on the criminal responsibility.
Sir, is that correct? You're waiving your right to have a preliminary examination?
I really do not understand this part of the process. I was going.
Okay, so let me just ask you this. Right now, this is set for a probable cause conference.
Yeah.
A number of things can happen at this probable cause conference. One is that I could set this for a preliminary examination. Basically a mini trial, in essence, except typically the defense does not call witnesses. At that proceeding, the people would be required to show two things by a standard of probable cause. First, that there was a crime or crimes committed and that you committed those crimes.
Okay.
All right? You understand that?
Yes. So
what your attorney's indicating to me is that you do not wish to have that hearing and that you wish to proceed to the higher court, that being the circuit court, for further resolution of this case.
And at that point, we will be.
I was going to plead not guilty by reason of insanity.
Hold on. We talked about this. So the way to do that is like I told you. It's the way to understand the court.
Okay.
For this criminal responsibility, but you're not understanding.
Yeah. So.
Okay, yeah. So you need to stop talking and listen. We've already talked about how to proceed to do that.
Yeah.
You agree that you did it this way. Do you still agree to do it that way?
I just do not understand if there is any other option to wait for the criminal responsibility. So I want to wait for the criminal responsibility report.
You want to wait for that?
Yeah.
Okay. So that's what your attorney's trying to do. He's trying to get you to circuit court because this court would not deal with criminal responsibility.
Okay.
All right?
Okay.
So you would like to waive your right to have a preliminary examination?
Yeah.
Okay, and you understand that that's that proceeding or hearing that I talked about, where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yeah.
Okay, you understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes.
All right. People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on all four counts.
Thank you, Your Honor. We acknowledge receipt of the information. We waive its reading on the record. My client has executed the examination waiver and he will be entering a plea of not guilty.
Defendant having
Also, I want to clarify that it's confusing when my actual lawyer is not here because Jay Bellinger is my lawyer.
Okay, so Jay Bellinger is a part of an office.
Okay.
Of which the gentleman standing next to you is second in charge.
Okay, because it's confusing because I thought my lawyer would be here, and my lawyer has.
Well, they are. Mr. Bellinger has, I'm sure, spoken with Mr. Brown and given him specific instructions as to how Mr. Brown is to handle this case, which he's probably done admirable.
Thank you.
Okay.
Okay?
Okay.
All right.
Thank you.
So defendant having waived reading and pleading not guilty to all four counts, court will enter that plea. Pretrial in this matter will be set
August 7th at 1:30 for Judge Slay.
August 7th, 2025, 1:30 before Judge Slay.
Thank you, Your Honor.
Is that the circuit court?
Yes, that's in circuit court.
Okay.
Bond will continue. Thank you.
Thank you.
Thank you, Your Honor.
Court calls the case People versus Christopher Adkins.
Andrew Bannett for the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Atkins, Your Honor, but not with him. I did receive information yesterday and confirmed in Vine Link that he is in the Livingston County Jail.
In Livingston County Jail?
Yes. I'd ask for an adjournment so that a writ could be done.
So we're gonna have to go to the 7th. See, do you know if he's still gonna be there?
I have not had any contact with him. I think he just went in the last couple days.
August 7th, 2025, 9 a.m. Bond continue. Case People versus Brandon Kelly.
We're ready in this matter, Your Honor. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Kelly.
Your name, sir?
Brandon Kelly.
Thank you.
Your Honor, today's the date time set for the probable cause conference. There is a mitigation report, which we are still hoping to receive very shortly. We'd ask for 2 weeks to make sure that report has been completed.
Probable cause conference, August 7th, 2025, 9 a.m. Bond continue. Thank you. Court calls case People versus Anita Burns.
Somewhat pretty good. Portia First Assistant Public Defender on behalf of, but I do not believe with, Miss Anita Burns. Your Honor, we've called, we've texted, and we've emailed our client. We have not heard from her. I do not know why she's not present. For the record, I will request an adjournment, but I do not know where she is.
Bench warrant will issue bond 10,000 cash surety. That warrant will issue immediately.
Thank you very much, Judge.
Court does call the case of the People versus Carl Murray. 2 cases.
And Assistant Public Defender Chinaza Kiriakou, Your Honor, on behalf of Mr. Carl Murray, who is approaching. Mr. Murray, state your name for the record, please.
Carl Murray.
Thank you.
Your Honor, we respectfully request that this matter be set for preliminary examination. That's both matters, Judge.
Both matters.
Yes, please.
Discovery complete.
To our knowledge.
Would the people have their witnesses available the 5th?
See the permit.
Preliminary examination in person, August 5th, 2025. 9 a.m. That is before Judge Perry in both matters.
Thank you, Judge.
Bond continued.
Thank you.
Calls case People versus Adonis Sweat.
Andrew Childers appearing on behalf of the people.
Good morning, Your Honor. Wendy Burnwell, P42, 505, on behalf of Mr. Sweat.
Sweat, can you say your name, please?
Adonis Sweat.
Thank you. What are we doing?
Ron, I'm brand new to this case, just accepted it.
You want the 31st? You want, pardon?
Mr. Sweat is co-defendant with Monte Owens, who is set for the 7th, I believe.
The 7th. Probable cause conference will be adjourned August 7th, 2025, 9 a.m.
Thank you.
Bond will continue. Thank you. Thank you, Mr. Sweat. Court calls case People versus Timmy Abazulu.
And then on behalf of the people, Your Honor.
Stephanie Cannon on behalf of Bitimi Buzulu. Could you state your name for the record?
Bitimi Alexander Buzulu.
Buzulu.
Okay, what are we doing?
Your Honor, I have I do. I have a green sheet on him. We're requesting an adjournment for investigation.
He's in custody. The 31st will work.
Yes, Your Honor, the 31st will work.
Probable cause conference, July 31st, 2025, 9 a.m. Bond continued.
And I will. Just a second.
Court does call the case of the people versus Roderick Bates. Did I speak French again? I did. I hate that when all of a sudden I just transition into a language that I can really cannot understand.
Excuse me, Judge. Assistant
Oh,
Public.
no, we'll wait for you to finish coughing as we had to for you to get up.
Assistant Public Defender Chinazi Carey, I can really, Your Honor, on behalf of Mr. Roger Bates,
Mm-hmm.
I do have a green sheet, Judge.
But do you have a client?
He should be on Zoom. Is he not on? Oh, man.
Bates? We're moving along swimming.
We were doing so well.
I was.
Even with my last case, we were just.
What?
Even with my last case, we just right on there.
You can't have more than one video in the day, can you? There's an individual who's on iPhone 2. Could you unmute and state your name, please?
Chavez.
My name is Montez King.
Okay.
You got him? Nope. Not him. Okay. Thank you, sir. There's an individual iPhone 1. Can you unmute and state your name?
Anitha Barnes.
Got her. What? That's a bench warrant? Oh, I'll let you tell her. Okay. And an iPhone 3. There's an individual iPhone. I don't see iPhone 3. Oh, there he is. iPhone 3. What's your name, sir?
Jelani Wright.
You got him.
None of those were litigation.
Right. And there's another individual, Samsung. Could you unmute and state your name, please? Individual who signed on as Samsung. Time. Bates. They're not here. Oh, she can have the green form back. That's not gonna help.
Thank you.
Anything else you guys?
Judge, you
For
know,
the record, you're requesting an adjournment.
for the record, we are absolutely requesting an adjournment. We've been in contact with Mr. Bates, hence the approval from the court for him to log in on Zoom. I do not know why he's not there.
Oh, well.
Yeah.
Bench warrant, 10,000.
Thank you, Judge.
Cash surety. Warrant will issue immediately. Court does call the cases of the people versus Joshua Palfrey.
I present on behalf of the people, Your Honor.
We're ready in that matter, Your Honor. Lauren Brown, Deputy Chief Public Defender, appearing on behalf of Palfrey.
Your name, sir?
Joshua Pelfrey.
All right. What are we doing on this, Mr. Brown? These. It's 4 cases.
Your Honor, today's the date.
Sorry.
Your Honor, today's the date and time set for a probable cause conference. We still don't have all the discovery. We're pending discovery on adjournment. Well, we should.
And Your Honor,
I don't want
discovery
adjournment.
on all 5 of these
Well, we
will be
can't do
announced,
anything without
requested
I'm not saying adjournment. I got due process. I need my.
by the end of this week or beginning of next.
I'm gonna tell you that.
That can be a dialogue.
All right. I don't want an adjournment. I want to schedule preliminary examination.
Your Honor, we would like to be able to have the discovery. We, despite my client's misgivings, would like to have an adjournment to get that discovery. He wishes not to have an adjournment and schedule it for preliminary examination. I'm advising him that that is not the proper or appropriate way to handle.
And Your Honor, on one of the cases, they haven't even received any approval yet. It's just released this month.
It's because some of the cases are, I need a preliminary examination.
What? I can't hear you.
I don't want an adjournment. I want a preliminary examination. I don't want to keep adjourning my probable cause conference and pushing out my prelim. We got a right to due process, 14 days.
Okay, you want due process? We'll give you due process. Give me a date before me. We'll just do it. And then that way, when your counsel doesn't have discovery, you have no complaint against counsel. When it just goes south for you. Now, I need a date earlier than that.
That's not idea.
So they don't have it.
I'll set preliminary examination in person before me, August 4th. That's a Monday, 2025, 9 a.m. I will indicate that while I'm setting it over the objection of defense counsel at defendant's request, that if the discovery is not there, they haven't analyzed it, we're still going ahead. Put that in the file. He wants an exam, I'll give him an exam. Thank you. Bond continued.
For the record, I want to make it clear that this is against counsel's advice.
Yes, and I've stated that, and I've noted that Mr. Brown, this is against his attorney's advice. He wants to do that with his own law degree. Thank you. Bye.
Thank you.
You do the same, Mr. Pelfrey. Court calls the case, People versus Bradley Chavez.
Assistant Public.
Is this yours?
It is mine.
Is this gonna go well? No, is this gonna go well? Ms. Akinrulli, is this gonna go well?
It's
'Cause
gonna go
you've
great.
had 3
It's gonna go.
and you're 50% right now.
Go.
Oh,
His shirt matches.
Mr. Chavez. Can you state your name for the record, please?
Bradley Chavez. Morning, Your Honor.
Thank you, sir.
He's matching the green sheet, Judge.
Yes, he is.
Assistant Public Defender Chinazi Carey, I can really, Your Honor, on behalf of Mr. Chavez. Your Honor, we are in the midst of negotiations. I think the people and I may have come to a resolution. I just need to let Mr. Chavez know. And hopefully we can get this resolved at our next hearing. So we're asking for an adjournment.
August 7th,
Thank you.
2025, 9 a.m. Thank you, sir.
Thank you, Your Honor.
Court calls the case, People versus Abdul Scott. Whose case is this? And I know because she's not here, because that just happens with her. Can somebody find Miss Cannon?
Assistant Public Defender Chinazi Carey, I can really, Your Honor, on behalf of Mr. Abdul Scott.
You're not Miss Cannon.
I'm not. We look alike a little bit.
Oh, okay, got you. You are so wrong. Your name, sir?
Abdul Scott.
Thank you. All right, what are we doing?
We're asking for an adjournment, Your Honor. I did. I'll get the form, the court, a green sheet, right?
All right. I'll adjourn it to July 31st, my next available date, 2025, 9 a.m. Bond continue. All right. Thank you, sir.
Thank you, Your Honor.
Whenever she decides. Where'd Cannon go?
Double duty, Judge.
So she chose the other duty instead of this one?
No.
Is that what you're telling me?
She has.
She chose to be someplace else than before me.
They dragged her kicking and screaming. I said, no.
Was it kicking and screaming? Okay. Oh, apparently she survived. Hello, Miss Cannon.
Hi, John, how are you?
So just out of curiosity to see if they were telling me the truth, where were you?
next door.
Did they drag you over there kicking and screaming?
They asked if anybody was available.
And so you volunteered to leave here and go there because you'd rather be there? Is that what happened?
Never.
That's not what happened?
You didn't see them dragging me out?
You and Lauren Brown ought to stop. Court calls the case. People versus Deshaun Clifton. Just in time.
Stephanie Cannon on behalf of Mr. Clifton. Mr. Clifton, could you please state your name for the record?
Sean Clifton.
Your Honor, I did receive some information this morning regarding our plea negotiations from Mr. Banis. I have not had the opportunity to review that. I'm asking for a 2-week adjournment.
Right. I'll adjourn this case August 7th, 2025, 9 a.m. Bond will continue.
Thank you so much, Your Honor.
Thank you, Your Honor.
Thank you, sir. Thank you. Court calls case. What's that?
Case.
Oh, this is the one she missed when she was someplace else? Is that this one, this green form? That didn't get to me even though I granted the adjournment?
That is correct, Your Honor.
Because Ms. Cannon was someplace else that she preferred to be other than here before me?
I'm gonna talk to them about assault by strangulation. Based on what happened.
I'm telling you, what they told me. Court calls case, People versus Collins Spry.
Assistant Public Defender Alexis Zerps with and on behalf of Mr. Spry, who is approaching. If you can state your name for the record, please.
Colin Joshua Spry.
Your Honor, we'd respectfully requesting an adjournment. We're currently in plea negotiations with the people.
Probable cause conference July 31st, 2025, 9 a.m. Bond continues.
Thank you, Your Honor.
Thank you. Okay. Court calls case People versus Michael Frazier.
Andrew Banner for the people. Four shall face the first assistant public defender on behalf of Mr. Michael Frazier, who I am told is on Zoom, Your Honor.
Yes, I'm here, Michael Frazier.
Oh, there he is. State your name, Mr. Frazier.
Michael Frazier.
Thank you.
I'm also told that Mr. Frazier intends to do a waiver to circuit court. I had initially planned to adjourn it, but I don't know that we're gonna need that if the court will.
Okay, so he's waiving?
Yes, that's my understanding,
Yes.
Judge.
All right, is that correct, Mr. Frazier?
Yes, sir, Mr. Simpson. Sorry.
Okay, and you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution?
Yes, yes.
Yes, sir. Okay. People also waive the right.
People waive the right.
Preliminary examination having been waived, defendants bound over to circuit court on both counts. Mr. Feast.
Thank you, Judge. We waive formal reading and stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
At 1:30 with Judge Cuffey.
September 16, 2025, 1:30 before Judge Cuffey.
Thank you, Judge.
Bond continued. Thank you.
I'm done, Mr. Simpson.
That's, yeah, you're all set.
Okay, thank you. Appreciate it. Have a good day.
Thank you.
All
You
right.
too. Court calls the case, People versus John Outcall.
Andrew Banner for the
Stephanie Cannon on behalf of Mr. Holt.
John Paul Outcall.
All right, thank you.
You're welcome.
And Your Honor, this is another case. This is another case where we did receive an offer, so we're gonna ask for an adjournment so I can convey that offer to my client and see how he would like to move forward.
July 31st, 2025, 9 a.m. Bound continued.
Thank you. Your Honor, my client is asking for release on bond at this time. My client is homeless, but he can receive mail at the Delanis Center. Sometimes that mail is probably not the most reliable. So my client is asking that he be released on a PR bond to Delanis. He will be here for court and for any other appearances that the court is requesting.
Well, see, between October 24th, 2024, and the day he came back into custody,
I was homeless, Your Honor.
did he turn himself in?
No, but I didn't know I had warrants out for my arrests.
Well, originally released on a personal recognizance in October. Then that next date, he didn't show up. We issued a warrant and he didn't come in nor have contact with his attorney, apparently, who would have told him that a warrant had been issued. At this time, the motion for bond reduction is denied. Bond will continue.
And I'm sorry, what was the next date, Your Honor?
It's set for July 31st, my next available day.
Thank you so much.
Thank you, Your Honor.
Thank you, sir. Court calls case People versus Darius Grady.
Good morning, Your Honor. Amy Visor, appearing on behalf of the people.
Torshell Feaster, First Assistant Public Defender on behalf of Mr. Grady. Mr. Grady, please state your name for the record.
Darius Grady.
Thank you, Judge. My understanding is that mitigation information has been turned over to the people. I'm asking for an adjournment for 2 weeks for further negotiation and for their consideration.
Without objection, probable cause conference, August 7th, 2025, 9 a.m. Bond will continue. Thank you, sir.
Thank you very much, Judge.
Court calls case People versus Samuel Peoples. Watch behind you, please.
Stephanie Cannon on behalf of Mr. Peoples. Mr. Peoples, could you tell your name to the court?
Samuel Peoples.
Thank you.
Your Honor, the court is very aware of Mr. Peoples and some of the issues that we are having. We are asking for an adjournment. Can we put it on the same date as the last one, which I think you had did 3 weeks from last Thursday? Am I correct?
That would be August 7th.
On August 7th. So I'm going to ask that you adjourn this to August 7th so these cases can run together for hopefully a global resolution.
August 7th, 2025, 9 a.m. Bond continue.
And Your Honor, as far as bond, the court is aware that we did file a stipulated order asking for Mr. Peoples to be released. It's my understanding the court did sign it. We were just asking for the same conditions to be applied in this case.
What? Did I sign an order?
Yes, sir. You
I
signed,
did.
you did.
So what more do you want from me?
Nothing. I'm just happy to see you, as is Mr. Peoples, correct?
Yes, sir.
Yes.
Yes. If we wanted that to apply to this case as well, no objection.
Yeah, that was signed on the other case. You want, and you
Nope,
want,
nope. I want you to be happy and do great things.
it's not happening when you keep talking. Right. So what do you want me to do? You want it on you want it on both cases?
Yes, sir.
Is that all you want?
That's all I
Did
want.
you submit another stipulated order to me? No?
No, I will get it
Otherwise,
to you.
I'd be thrilled to sign it.
It'll be to you in like less than 5 minutes.
That's probably not true.
That's probably.
That's probably not true. Is it,
That's
Miss Cannon?
probably accurate.
So how much time do you need to get it to me, Miss Cannon?
I'm gonna do it at 10 minutes.
Give her 15.
Thank you, Your Honor. Thank you, Your Honor.
I get it. Yeah.
So my husband wait sometime.
Court calls case People versus Alexander Calarossi.
Ready, Your Honor. Your Honor, Joe Simon on behalf of Mr. Calarossi. Alex, state your name when you get up here.
Alex Colarosi.
Got it. So what are we doing, Simon?
I think,
Mr. Simon.
sorry. Yes, Your Honor, we're requesting an adjournment of the probable cause conference. There's I won't quite call it a companion charge, an identical charge in the county of Kent. There's a circuit court pretrial that occurs on August 4th in that matter, asking to adjourn our probable cause conference to a date after that date, where we're going to try to have a coordinated resolution to the extent we can. I also want to make a statement. I understand the complainant's present in court. I've given my commitment to the people. That is not our intention to ever have a preliminary exam in this case. We are seeking resolution.
Do you want the 7th or the 14th?
Probably be smarter to do the 14th, Your Honor.
I think you had your other stuff set for the 14th. I don't know why I keep track of your schedule, probably.
Because you really enjoy seeing me.
No, it's probably so I can see the fewest amount of times that would be my guess. The 14th.
Thank you, Your Honor.
You're welcome, sir. Probable cause conference in this matter will be during August 14th, 2025, 9 a.m. Bond will continue.
Thank you.
Thank you.
Go home.
Okay. Court does call the case of People versus Derek Stewart.
Maybe I recommend that for the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Stewart. Please report to you now. Mr. Stewart, will you state your name for the court?
Mr. Derek Stewart.
Thank you.
So we're still waiting a review.
Correct.
A report on the review.
Yes, we'd ask for an adjournment for that purpose.
Why don't you give me, let me just, myself. Does anybody contact anybody regarding when a report might be here?
Your Honor, I'm standing in for Miss White. I don't know if she reached out to the forensic center. I can leave a note for her and ask that she do that.
All right, why don't I do this then, just so because I can set it out and then move it up, but why don't we set it for September 11th? We get a report before then we can move the date up. September 11th, 2025, 9 a.m. Bond continue.
Thank you.
Yeah. Court calls the case People versus Norwin Rouse.
Ready, Your Honor.
Allison, on behalf of the people, Your Honor.
Your Honor, Joe Simon on behalf of Mr. Rouse, state your name wrong.
Norwin Rouse.
And before me, a plea form indicates defendant will be pleading no contest to the charge of domestic violence. That being a misdemeanor punishable by up to 93 days. Upon his successful plea to that charge, count 1 would be dismissed. He agrees to complete a full 18-month probation term. There is also a sentence agreement or a recommendation to the judge of no upfront jail. That's the court's full understanding.
And that's correct, Your Honor.
That's correct, Your Honor.
May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Norwin Robert Rouse.
Is there an advice right form?
Fill one out today, Your Honor. Should be there for you.
Oh, I got it. Holding on to the police report. All right. Sir, it is this court's understanding that you are going to be pleading no contest to the charge of domestic violence. Is that correct?
Yes, Your Honor.
All right. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand that?
Yes, Your Honor.
Do you understand what a no contest plea is?
Yes, Your Honor.
All right. 2 things about it I have to make sure that you understand. First of all, it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
The other thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
You also understand that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Freshour in the 14A4 District Court. You understand that?
Yes, Your Honor.
Basis for a no contest plea.
Potential civil liability, Your Honor.
Sir, to that charge, how do you plead?
Guilty.
No contest.
No contest.
Do you understand that by pleading no contest, you will not have a trial of any kind?
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Look at paragraph 5, you see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading no contest, you're giving up those rights as well as all the rights of that.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce
No, Your Honor.
you? Doing this voluntarily
Yes, Your Honor.
of your own free will?
Yes, Your Honor.
Court has been provided and has reviewed Michigan Department of State Police report for their case number 3831-25. Any objections to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
All right. Based upon that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, you understand that if I accept your plea and you commit misconduct as defined by the Michigan court rules prior to your sentencing date, that the court would no longer be bound by any evaluation or recommendation?
Yes, Your Honor.
You also understand that you would also be prohibited from withdrawing your plea?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
Has the court complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A4 probation. Sentencing in this matter will be
July 31st at 10:30 with Judge Freshour.
July 31st, 2025, 10:30 before Judge Freshour. Bond will continue.
Thank you, Your Honor.
Thank you, Your Honor. It'll be, yeah, here.
Wherever 4 is.
It's here.
It's not here.
Well,
Mythical.
hey.
They're here
B.
temporarily. Soon they will be there.
The court is generous, the court is
I
kind.
know, I allowed to. Court calls the case of the people versus Bryce Valero.
Both cases?
There are, there are, Your Honor. Alex Warren Green on behalf of Mr. Valerio. Mr. Valerio, can you state your name for the court?
Bryce Valerio, Your Honor.
Thank you.
Your Honor, at this time, we are asking the court to set both matters for preliminary examination.
Discovery is all complete.
So, Your Honor.
People have their witnesses available August 5th.
People will do their best. Your Honor. Thank you.
Preliminary examination in these matters will be set August 5th, 2025. 9 a.m. That will be before Judge Freshour. And in each of these matters will continue.
I'll talk to you before that.
Thank you, Your Honor. Thank you, sir. That's called the case of the people versus Derek Stevenson.
Ready in that matter. On Brown, Deputy Chief Public Defender appearing with and on behalf of Mr. Stevenson, who is appearing by Zoom. Mr. Stevenson, could you please state your name for the record?
Stevenson.
Thank you, sir.
Your Honor, there is still video discovery, which is outstanding. We think that, a week should be sufficient?
Yes, Your Honor. There was a executive order that was just signed by the Governor this morning, I believe. We'll send it over.
Probable cause conference then will be adjourned July 31st, 2025, 9 a.m. On continue.
Thank you very much.
Thank you. Court does call the case People versus Fred Willis.
People.
And Alex Warren Green on behalf of Mr. Willis. Mr. Willis, can you state your name for the court?
Fred Willis. Thank you.
Your Honor, we are still working on completing discovery in the discharge at a building case. I have completed a green form for the court. We're asking for
Both then?
both, please, Your Honor.
Okay. How much more time did you need to try to get discovery done?
Your Honor, I believe we could complete it by the 31st. I would defer to the people, though.
What is it you need?
Media.
Probable cause conference in this case will be adjourned July 31st, 2025, 9 a.m. On continue.
Thank you, Your Honor.
Thank you. Case of the People versus Myron Barnes.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Barnes. He's appearing on Zoom from Don Farms treatment.
Mr. Barnes, can you state your name, please, sir? Myron Barnes. I'm asking for an adjournment on this.
Yes, Your Honor.
Probable cause conference in this case will be adjourned August 7th, 2025, 9 a.m. Bond continue.
Appreciate it, Your Honor. Thank you.
Thank you.
Be in touch, Mr. Barnes.
All right. Court does call the case People versus James Herring.
Andrew Daniels for the people.
Warren Brown, Deputy Chief Public Defender, appearing on behalf of Mr. Harris. Now today's date and time set for the probable cause conference. My client is in prescription glasses, and of course, that's why.
Why are you telling me that? I didn't ask. I didn't ask. I was just looking.
They're nice.
It happens when you look and people feel guilty. They just start confessing things. Go ahead.
They're nice. They're nice.
No, that's okay. No.
So we do have a plea offer. My client is willing to accept it, but we need a week to be able to get the form to the court.
So probable cause conference July 31st, 2025, 9 a.m. Bond continue.
Thank you.
Thank you. Just luck. Did he give me a green sheet? No.
I didn't do a green sheet.
Got blinded by the light. The client could see. I need a green sheet on it. Court does call the case People of the State of Michigan versus Stephen Johnson.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Johnson, who should be appearing via Zoom. Oh, good. Your Honor, we're asking for an adjournment for some continued plea negotiations and to track progress of Mr. Johnson. Indictment. Mr. Johnson, can you state? Sorry, Mr. Johnson, can you state your name for the record?
Steve. You're muted now. Okay.
My name is
Go ahead.
Stephen Michael Johnston.
Thank you. All right. Will the 7th be enough time for you or?
Yes, Judge, I
We're
think so.
tracking it.
Yes.
All right. Probable cause conference August 7th, 2025, 9 a.m. Bond continue.
Thank you.
Thank you. Thank you, Mr. Johnson. Court calls the case of the People versus Marcus Jones. Oh, boy. Here we go. Gonna take a minute.
Good morning, Your Honor. Student Attorney Andra Sabri requesting permission to practice pursuant to MCR 8.120 under the supervision of Assistant Public Defender Chinaza Ikiri Akinruli.
Really? Have you always been with her?
Yes.
Really?
Yeah.
No. I didn't notice. She must be a good leader. Permission to not really. Don't nod your head when you gotta. It's not, if I say that, you don't like sign on yourself. You let other people. Permission to practice is granted.
Thank you, Your Honor. Mr. Jones, state your name for the record.
Marcus Jones.
Your Honor, at this time, we are requesting an adjournment to continue negotiations with the people.
Probable cause conference, I'll adjourn this August 7th, 2025, 9 a.m. Bond continued.
Your Honor.
All right, thank you. This is, the other one. Court does call the case People versus Montez King.
Read in this matter on the Lauren Brown, Deputy Chief Public Defender, appearing on behalf of Mr. Montez King.
Mr. King, state your name, please.
Montez King.
Thank you.
Your Honor, today's date and time set for the probable cause conference. We are respectfully requesting this matter be set for preliminary examination at the earliest possible date. We believe that all discovery has been to us.
People have their witnesses available the 4th. Preliminary examination will be set August 4th, 2025, 9 a.m. in person before Judge Perry.
Be in person for that, Mr. King, okay?
Okay,
All right. Bond continued. Thank you.
thank you.
Court calls case People versus Alexander Cronin.
Stephanie Cannon on behalf of Mr.
Good morning, Your Honor.
Good
This
morning.
is Alexander Cronin. How are you, sir?
That's the wrong one, Your Honor. That's on me. Stephanie
Oh, I
Cannon.
knew it when you made that poor guy get up.
He's
No,
great
you
guy.
made him get up.
I made him get up.
Afraid to do anything else.
I'm
It is all
intimidating.
your fault because I saw Mr. Cronin on Zoom.
I'm so.
Why did you apologize to that man? All right, thank you.
Your
What are
Honor,
you doing now, Miss Cannon?
we are just asking for an adjournment in this matter for continued negotiation.
That objection, I'll adjourn this to the 7th.
Seven.
Okay.
Thank you so much, Your Honor.
Thank you. August 7th,
What time is it?
2025, 9 a.m.
August 7th at 9 a.m.
Thank you. Enjoy your day.
Continue. Thank you. Sir, what's your name? Pardon? Since Miss Cannon yelled at him and made him do all of that, I'm gonna call his case. Yes, you did. Yes. Court calls the case, People versus John Michael Nowak.
Alexander, on behalf of the people, Your Honor.
Stephanie Cannon on behalf of Mr. Nowak. He just looks like an Alexander.
What?
Looks
like what?
An Alexander.
Oh, is that how you figure out who your client is? Is that what you do?
In that moment,
I call the case, he goes,
Like, it's not
he looks like an Alexander, come on up. Is that what you did?
Yeah, it's like, what? We literally talked this morning. Like, what?
Oh, we did talk.
Yes. We took it.
You made an impression. Wow. Cannon.
well, good news, Your Honor, it's for a plea.
No, I do see that. But this plea form's for Alexander.
No,
I'm
okay.
kidding.
Oh,
All right.
I was like, oh
You
my
just,
God.
you absolutely froze.
I did.
You had no. Sir, did you state your name?
No, I didn't. I'm sorry.
Could you state your name so she knows it now?
John Nowak.
John Nowak.
I have before me a form that indicates that the defendant will be pleading guilty to count 2, which is malicious destruction of property, 200 to 1,000 to 1-year offense. Upon a successful plea to that charge, and count 1, right, would be dismissed. Defendant also in this is agreeing to pay restitution in the amount of $1,635, and that he would be sentenced under a prosecutor's, there's a sentence agreement of sentencing under a prosecutor's preferred.
That's correct, Your Honor.
That is my complete and full understanding of the agreement.
May I have him sworn?
Raise your right hand. You solemnly swear to affirm the testimony you're about to give, the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
John Nowak.
Did you say your last name?
Nowak.
Yeah. Okay, thank you. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of malicious destruction of personal property, 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. The fine could be increased if 3 times the value of the property destroyed or otherwise injured. If that's greater than $2,000, that could become the maximum fine. You understand that, sir?
Yes.
Okay. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court. Do you understand that, sir?
Yes.
All right. Understanding all of that, do you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Look at paragraph 5. Those are your rights, which you should take a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right. Are you on probation or parole?
Not yet.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes, sir.
and of your own free will?
Yes, sir.
And because you believe that you are indeed guilty of this offense?
Very much.
On the date of June 4th, 2025, at the location of 1235 Astor Avenue in the city of Ann Arbor, Washtenaw County, state of Michigan, what did you do involving a Honda Civic belonging to Olivia, is it Holsing? That makes you think that you're guilty?
I drove there. I mean, I could give the whole sob story.
Just tell them what you did.
But what I did was that I drove there. I spray painted cheater on the left side of the car, liar on the right, and FU across the hood.
Because, yeah, that would be a long story, probably.
Yeah.
To tell.
Yeah.
Okay.
All that matters.
You were angry about something. You went up and damaged your car.
All that matters is that I'm here to take accountability for what I did. Chelsea advised me against bringing it. I do have these here to show that they're statements from friends that know me.
That'd be, if we do, it'd be for the sentencing judge, not for him. He just
Sorry.
needs the facts and he's
Okay.
gonna.
But
act
okay, I'm
accordingly.
sorry. I'm getting ahead of myself. But yes. That I did that.
Do you agree the amount of the damage was at least $1,635?
At least yes.
Pardon?
At least yes.
Yes. All right.
Sorry.
Okay, so I do have to advise you. Sir, that if you commit misconduct after I accept your plea and before sentencing, that any type of evaluation or sentencing agreement, the court would no longer be bound by. You understand that?
Yes.
And you would also not be entitled to withdraw your plea. You understand that?
Yes.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
None, Your Honor.
Have I complied with the court rule, and would it be proper to accept this?
Yes, Your Honor.
The court has.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
August 15th at 8:30 with Judge Perry.
August 15th, 2025, 8:30 before Judge Perry. Bond will continue.
Thank you so much, Your Honor.
All right, thank you.
Copy of that.
Court calls case People versus Michael Laster.
Andrew Banish for the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Laster, who's approaching now. Mr. Laster, will you state your name for the court?
Michael Laster.
Thank you.
Your Honor, we're asking for an adjournment for continued plea negotiations.
Probable cause conference, August 7th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Thank you, sir. Court calls case People versus Patrick McGee.
Andrew Banish for the people.
I am ready in this matter, Your Honor. Warren Brown, Deputy Chief Public Defender, appearing on behalf of Patrick McGee.
They're not here.
No, Your Honor. I have attempted to reach Mr. McGee. We had wonderful things in place for him. He chose other options. However, having said that, I will be happy to ask for an adjournment of 3 weeks so that we can get Mr. McGee in here and move forward with this.
And I will be equally as pleased to deny your request and issue a bench warrant on 10,000 cash surety.
I had to give it a shot.
I know. That warrant will issue immediately. Watch this.
Cannon, do you know the name of the person you're talking to?
And Alexander?
Okay. Court calls the case People versus Melvin Morrow.
Assistant Public Defender Alexis Zerbst, on behalf of Mr. Morrow, who I don't believe is present, Your Honor.
Pardon?
Who I don't believe is present, Your Honor. We made all our efforts to get in contact with him, had no luck. I have no other explanation for his failure to appear. We'd be requesting an adjournment for the record.
Bench warrant will issue for defendant's failure to appear. Bond 10,000 cash surety. That warrant will issue immediately.
Thank you, Your Honor.
Thank you. Court calls case of the People versus Alexis Naveen.
Andrew Banish for the people.
Oh.
And Alex Warren Green on behalf of Ms. Naveen. Ms. Naveen, can you state your name for the court, please?
Alexis Naveen.
How are you?
I'm doing much, much, much better. Thank you, Your Honor. Thank you for your patience.
My patient?
Yes.
You need to thank me for anything. I think I told you before, I had to thank you because you served and allowed me to do this every day. So if I have to wait for you, I wait for you.
Thank you, Your Honor.
But we've had a long journey, right?
Yes, sir.
Okay. And so it's just fantastic to see you here.
Thank you. Thank you.
What are we doing? You didn't adjourn on us.
We are requesting an adjournment, Your Honor. We are trying to alternatively resolve this case. Our hope is that Ms. Naveen can enter the Veterans Court. She's set to be sentenced on August 4th, I believe.
On what day?
August 4th.
Okay.
And we're hoping that if she can get into the Veterans Treatment Court, begin making satisfactory progress in that program, that we can resolve this case and have a little more mitigation available from her progress in the Veterans Court.
So it's another case that she would be sentenced into the Veterans Court.
That's correct. She has a misdemeanor case that has been accepted, and she'll be sentenced on August 4th, is my understanding.
Okay. And that's before Judge Valvo. It's in front of me?
Yeah.
Oh, that's right, because we have.
I believe
I'm sorry.
we'll have to do the memorandum of understanding and transfer it over, but I think it'll eventually end up in the 15th district.
Great. Okay. So, and that's on the 4th before me. So what, you think the 7th? Oh, I'm on the 7th right now, certainly.
Your Honor, if we could go to the week after that, or
14th. If you want, I'll do whatever.
I think by the 14th, we'll have a good idea of what we're gonna do in this case, Your Honor.
All right. Probable cause conference will be adjourned then to August 14th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Okay.
Take care of yourself.
Thank you, Your Honor, as well.
Court does call the case, People versus Ryan Patterson.
Andrew Childers appearing on behalf of the people.
And Alex Warren Green on behalf of Mr. Patterson. State your name.
Ryan Patterson.
Thank you, sir.
Your Honor, in speaking to my client, Mr. Patterson has indicated to me he wishes to retain private counsel. He does qualify for the public defender, but I'm asking for an adjournment for that purpose.
How long is it going to take him to do that?
Your Honor, I would ask for 2 weeks.
Are you going to be able to get it done by then?
Would you be able to do like 30 days?
No. I will grant an adjournment for you to get counsel, but I'm not going 30 days.
Your Honor, if the court could accommodate 21 days.
The only time I'll grant an adjournment for this purpose, probable cause conference will be adjourned August 14th, 2025. 9 a.m. Bond continue.
Thank you, Your Honor.
Court calls case People versus Brent Person.
Ready in that matter, Lauren Brown, Deputy Public Defender, appearing on behalf of Mr. Brent Person.
Like 2 in a row.
Yeah, that never,
I know it never happened.
I think the bus must have broken down.
If we go through that whole bus, like, but you got underlings that you could have sent up here to let them take the hit.
Yeah, I know.
But a true leader doesn't do that.
There you go.
All right. You're not here. Bench warrant will issue for defendant's failure to appear. Bond 10,000. Cashier.
Thank you.
Warrant will issue immediately. Court does call the case of the People versus John Riggs.
Andrew Banish of the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Riggs, who's approaching now. Your Honor, today's the date and time set for adjourned probable cause conference for Mr. Riggs as well as bond violation. We're asking for an adjournment for some mitigation that we are working on, and additionally, I guess an adjournment of the bond violation. I know that the court previously allowed it to be adjourned based on the number being so low, and Mr. Riggs was placed on a scram tether. My understanding is that there's been no issues since the scram tether. I know that the prosecutor's office did have some communication with the tether SoberLink agents regarding that, and I forwarded, that was with Mr. Ward, and I forwarded those to Mr. Banis. So I don't think at this time the state is wishing to proceed on the bond violation. Did you have a chance to review those, Mr.
Yeah,
Banis?
we approach on that. Please. Thank you.
He has an interview scheduled with our social worker this week. I think actually tomorrow. So a couple weeks so we could get a status check-in at least.
August 14th, 2025, 9 a.m. Bond continued. That way you can get the information, get it to them, and hopefully have an answer.
Sure.
All right.
Thank you, Judge.
Thank you. Bond will continue.
14. Right.
Court does call the case People versus DeAndre Cersei.
If you ever do that for the people.
Morning, Your Honor. Assistant Public Defender Alexis Zerbson on behalf of Mr. Searcy. Can you please state your name for the record?
Doing great. Thank you.
Your Honor, we'd be respectfully requesting an adjournment. The people have extended an offer and we need some time to go over that with Mr. Searcy.
Probable cause conference, I'll turn it out August 14th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Thank you, sir.
Thank you. Case People versus Tyrell. Is it Bollocks? Kisara?
And Assistant Public Defender Chinazza K. Really on behalf of my client. Tyrell, state your name for the record, please.
Ariel Vox Chisera.
All right. What are we doing?
We have some discussions about revising the language that was an issue for the court the last time. As of last evening, I believe that we have a version of it that should work. However, I have not been able to actually generate that revised plea form. And at this point, I think it would probably be best if we could send it to the court ahead of time anyway, so that if there are any other concerns, we'll know about them and be able to address time next year. So I think that Ms. Perry needs a green sheet for next month.
During this matter, July 31st, 2025, 9 a.m. Bond continued.
Thank you, Judge.
You. Thank you, sir. Thank you, sir. Court does call the case People versus Emarion Williams.
Thank you, for the people.
Good morning, Your Honor. Student Audra Sabri on behalf of Mr. Williams. Mr. Williams, say your name for the record.
Emarion Williams, Your Honor.
Thank you.
Your Honor, at this time, we are requesting an adjournment to continue negotiations.
Probable cause conference will be adjourned August 7th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Thank you.
Court does call the case of the People versus Jelani Wright.
Andrew Banish for the people.
Delani, right?
Assistant Public Defender Chinazza K. Really on behalf.
What happened to Ken?
I thought I heard.
We're just trying to cover her.
And I respect that so much. Right. Stephanie Cannon on behalf of Mr. Wright. Your
He's
Honor,
already stated his name. You weren't here, but he did.
Your Honor, I'm asking for an adjournment of this matter. I attempted to speak with Mr. Wright yesterday. I'm not sure if the phone number I had was incorrect, but I was not able to get through. So if he could call our office so we could discuss this matter, I would greatly appreciate it.
Got that, Mr. Wright?
Yes.
Call the PD's office, give them a valid phone number and an email for yourself, okay?
Okay.
All right.
Thank you, Your Honor.
So probable cause conference, I'll adjourn on August 7th, 2025, 9 a.m. Don't wait till the last minute to call. In fact, call today.
Okay. Thank you.
All right? Thank you. Bond continued. He's still here. Recalls case People versus Ware.
Thank you, Richard McGuffey for the people.
Good morning, Your Honor. Edward Drukas on the Michael Ware. Stephanie Cannon will be approaching too. I am on 863. My client has executed a waiver form.
Why are we? Why did we call this back?
I'm aware that he was late to court, and he's also aware that he was late to court, but Mr. Ware is here right now. We're asking that the court recall the bench warrant.
Please.
What are we doing on the cases?
He is waiving an 863 up to circuit court.
Your Honor, we are adjourning ours so I can have a meaningful conversation with my client. We're just asking for 1 week. I suspect we're going to waive as well. But I'm asking for a 1 week adjournment.
Cancel the bench warrants in these. I'm gonna need new. Arrows. Mr. Gurgis's case. Sir, you're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and you committed it.
Yes, sir.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution.
Yes, sir.
In that matter, 863, people also waive their right. Preliminary examination having been waived, defendants bound over to circuit court on.
Your Honor, we acknowledge receipt of the information.
He's currently occupied.
Okay, if he's occupied, then I'll let that happen.
Okay.
I mean, I was just trying to get some stuff out of the way.
Yes.
Yeah. That's that one, okay, okay. Then. You guys have Miles? Okay. Court does call the case of the people versus Jonathan Miles.
We're ready in that matter, Your Honor.
Sarah Brenner,
One-
Assistant Attorney General for the people, Your Honor.
Thank you.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Jonathan Miles. Mr. Miles, please state your name for the record.
Jonathan Dion Miles.
Your Honor, today is the date and time set for preliminary examination. Mr. Miles wishes to waive his right to preliminary examination and agrees to have this matter bound over to circuit court. There, we will attempt to resolve the matter through the offer from the Attorney General.
Sir, is that correct? You want to waive your right to a preliminary examination? Yes, sir. You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed?
Yes, sir.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution?
Yes, sir.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count. Mr. Brown.
Your Honor, we acknowledge receipt of information and waive its reading on the record. My client will stand mute at this time.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pre-trial in this matter will be set for
August 7th at 1:30.
August 7, 2025, 1:30 before Judge Slay.
Thank you, Your Honor. Hello, Sarah. Long time no see.
What'd
Good
you
to see
say?
you, dude.
Bond will continue. Thank you.
Judge.
Recalls the case of the people versus Jose Perez Abadia.
Ellie says on behalf of the people, Your Honor.
Afternoon again, Your Honor. Dan Garrett on behalf of Mr. Bertolale.
And Your Honor, at this time, people are unable to proceed.
The motion to dismiss, my client understands that would be without prejudice, Your Honor.
Case is dismissed, people being unable to proceed at this time. That is without prejudice. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Three minutes, all I have. Why are all these people here then? Franklin, but they're over at the detective.
Yes.
I'm not-
Done now.
They are done?
Yes, once I needs to go grab.
Got it, but
But I don't see Mr. Children.
I'll have the people. All right. Okay, what else?
My understanding is, PM is. Mr. Kennedy wants to get Mr. Children's from.
Okay, but I'm gonna step off. That one's over at the DV.
Yes.
Okay, and who's doing that? Childers? And then Childers also has, Mr. Jolly.
Yes.
Okay.
I don't know what we're doing on King, that's Miss Lobby and Mr. Durkis. So that's. So I see.
Are they going to? On Jolly, it's best to, I mean, we're gonna proceed on that, obviously, yeah. He's refusing to come up, but what I'm considering doing is at least getting a tablet outside of his cell. All right, so we'll have to arrange that. And then your other witness on what's Franklin and Mr. He's here. I think I saw it, yeah. Okay, and then you got who else?
I said, I don't know what's happening on King, Miss Lobby and Mr. Durkis.
Not for what it's worth with respect to the Franklin case, that we may, I don't know if that witness will be ready. He was over in the sheriff's department, but they had to transport him down to come up, if that makes sense.
Oh,
We
okay.
just left over there because he has an attorney here. That was maybe 10 minutes ago, so it may be another 10 minutes or so before he would even be available for what that's worth.
Got it. Yeah. That's all I'm gonna say to you. No, that's, you know, who's on the other side of your case?
Hi.
Of course, that's, you look like you want to talk to me.
No, I didn't know you needed something from me. That's what I said.
Not what I got.
Respond.
I'll talk to you soon.
Okay.
You, Miss Tan, I'm in recess.
All right.
I was doing fine in first.
Maybe see. Now back in session, y'all, the day set extension for not.
You may be seated. Where's your phone? Okay, all right. In there one. 12:30.
Did you say so?
We had to wait.
Yeah.
All right. Court does call the case of the people versus Benson.
Judge,
Good afternoon, Your Honor. Katie Rismer, speaker for the people.
Portia Feaster, First Assistant Public Defender on behalf of Ms. Benson, who is approaching the podium. Ms. Benson, when you arrive, please state your name for the record.
My name is Shalon Truth Benson.
Thank
Your
you, Judge.
motion, sir.
Yes, this is our motion, Your Honor. We filed a motion to withdraw on this case. I have had the opportunity to speak to Ms. Benson on this matter several times and to discuss the nature of this case. At this time, it has come to the point where there is an attorney-client breakdown of communication. I do not feel that I'm able to effectively communicate with Ms. Benson to help her with this case. This being a capital case and her fighting for her life in this matter, I believe she'd be better served with another attorney who she feels more comfortable with. And based on that, Your Honor, I ask that you allow our office to withdraw.
All right. Do the people have a position on the withdrawal?
No, Your Honor, leave that matter to the discretion of the court. Thank you.
All right. Ms. Benson, is this what you desire also?
Yes, I do. I need my own private attorney for this matter pertaining what's going on about my child. And I definitely stand tall for my baby. So I need for him to withdraw, I need to have my own attorney.
Well, when you say your own
Well,
attorney,
a different attorney.
you need a different attorney than the public defender's office.
Correct.
You would agree that communication between you and the public defender's office is broken down?
Yes.
All right. Given that, the court would indicate that the public defender is permitted to withdraw his counsel of record, I will sign the order. Discharge from any further obligation under the case.
I got to
Sure not.
stand tall for my daughter. Sorry.
The court, in anticipation that this might be the court's ruling, although not having decided it previously, the manager assigned counsel's office has appointed Kareem Johnson to represent Ms. Benson.
Thank you very much, Judge. I believe he's here. Good luck to you.
Good afternoon, Mayor. Please, Honorable Court, Kareem Johnson, on behalf of Ms. Benson.
And so, and the record should reflect there was a in-chambers conference, basically trying to anticipate, go this direction where the public defender was to withdraw, anticipation to make sure that you'd be ready to proceed to preliminary examination. Without getting into the details of that, I think that all the evidence and other things will get to you rather promptly. And so I'd like to set this to adjourn the preliminary examination to August 5th, that Tuesday in the afternoon. And Ms. Vincent, you understand that having allowed the public defender to withdraw, that your matter would be adjourned?
Yes, I do.
All right. Will that work for counsel?
Yes, Your Honor, the afternoon of August 5th, I believe will work for counsel.
All right. Will that work?
We'll be ready, Your Honor. Thank you.
All right. Then I will adjourn preliminary examination in this matter to August 5th, 2025. What I'm going to do is I'm going to set it at noon. As council's aware, there are preliminary examinations that are going on during that time. And so because I would need a courtroom with a lockup, I have to wait for those to clear, and then we would proceed immediately thereafter. So I'll set it at 12, but it may be a little bit after that.
Yes, sir, Your Honor.
All right. Anything additional?
Yeah, I just,
Nothing further, Your Honor.
All right, bond will continue as denied. Thank you.
Thank you.
And I give all of that. Okay, before they break down, is Mr., give me Mr. Burgess. Have them bring Lee. Gotta get that one. Did you get his? Please. And my copy is, do you have my copy? Okay. Is it there?
I don't know.
So this is different than what was sent to you. That was JIS indicate that they have some. They're gonna have to wait. They're gonna have to wait because the rules require you gotta wait for me to tell you you can break down. I gotta call another case. Then I'll give you an opportunity to break down and get yourselves moving.
I don't think that that's time stamped,
Which is,
the one that you just got. Yeah,
that's the one.
so I believe that's the one that is attachments.
Hey, can you communicate with them, see if we can get Burgess over here? I don't know if he's in it.
If Kennedy just checked, he wasn't next door, so if Kennedy is not calling, super.
Who else do I have back there that they can? Is that a withdrawal? Waivers on Miracle. Okay, let's switch it up. Get Miracle out here because I don't know where he. Huh? Okay. That's called the case of the people versus David Miracle.
Good afternoon, Your Honor. Petitioner is requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Prosecuting Attorney Judge Simpsons.
Permission to practice is granted.
And good afternoon, Your Honor. Alex Warren Green on behalf of Mr. Mariquin. Your Honor, currently in both matters.
Yeah, covered over here in matter 25 F5
Well, I don't think I've signed the order, Mr. Riddell, but.
Correct, Your Honor. Mr. Mariquin, can you state your name for the court?
David Mariquin.
What is happening on this?
Your Honor, our office did discover a conflict, and I apologize for any inconvenience that causes. I apologize for the late notice, but we are requesting to withdraw. We believe we have a material conflict in.
That's in the case ending in 5622.
Your Honor, I'm getting that case number. It is the 5622 case, Your Honor.
All right. Mr. Mariquin, you understand that?
Yes.
All right. You have any objection to the withdrawal of the public defender?
No.
All right. So in that case, that being 5622, the public defender is permitted to withdraw. Signed counsel assigns Mr. Riddell to represent him in this case.
Covered on behalf of David Mariquin.
All right.
Your Honor, with respect to the matter ending 5132, at this time, Mr. Mariquin does wish to waive his right to a preliminary examination, and I believe Mr. Riddell is doing the same thing.
He does as well, Your Honor. I just need him to, I just need to have you execute this form. You can sign it.
So he's waiving on both cases?
Yes.
Correct. Mr. Mariquin, is that correct?
That's correct.
All right. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you'll not have a hearing on either one of these matters and that you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right? Yes, sir. Preliminary examination have been waived. Defendant is bound over on the single count in each case.
Your Honor, we acknowledge receipt of the information, waive its reading, and stand mute.
Acknowledge receipt of information, waive its reading, and stand mute.
Defendant having waived formal reading, standing mute in both cases. Court will enter a not guilty plea. Pretrial in these matters will be set forth
August 7th at 1:30 with Judge Slay.
August 7th, 2025, 1:30 before Judge Slay.
Thank you, Your Honor. May I very briefly address bond?
Very briefly.
Thank you, Your Honor. At this time, we are asking the court to consider either a personal bond or a release to treatment. In the event Mr. Mariquin were released, he would reside with his parents in Ann Arbor. They're both responsible members of the community. I understand he came into custody after cutting his tether. He did turn himself in after that. He acknowledges that he did that. He tells me he was going through what he describes as a mental health crisis at that time. So, Your Honor, we'd ask the court to consider either personal bond in, I think Mr. Bedell's joining my argument, or a release to treatment. He has expressed interest in mental health and substance abuse treatment.
Judge, I would ask to join that motion as well.
Response.
People, this time people would object to any change in bond. Your Honor, it's important to note that on the malicious destruction of personal property case, the defendant was actually on probation for a different malicious destruction of personal property case with the same victim when this event occurred. Furthermore, he was found with 2.2 grams of crack cocaine. That is the possession case. So I'm concerned with his ability to remain law-abiding. I understand the court may want him released to treatment. I respect that decision, but with him being on probation for an event of picking up 2 felonies, I'm inclined to agree with the defense's request.
Anything else you want to comment?
Nothing further, Your Honor.
Motion for bond reduction, given all of the circumstances, and I address some of these issues before. The motion for bond reduction is denied. Bond will continue as is.
Thank you, Your Honor.
Thank you. They're gonna bring me. Let's try to get that. They're ready. Court does call the case of the People versus Larry Lee.
Good afternoon, Your Honor. Mary Townhouse, Assistant Special Attorney, the people.
Good afternoon, Your Honor. Please, Honorable Court, David Burgess, currently representing Larry Lee.
Your name, sir? Larry. All right. Mr. Burgess.
Your Honor, based on representations or communications I received from the court, Your Honor, I filed a motion to withdraw. I also received a letter today from Mr. Lee that the court made me a copy of, indicating he wants to represent himself. So based on the motion I submitted as well as this letter, I'm asking the court to allow me to withdraw as counsel.
And just so that the record's clear, the court received from Mr. Lee what were, in this court's opinion, I did not read them fully and only had a staff member relay them to me, were, I would say, privileged communication to the extent the privilege would still exist between Mr. Burgess and Mr. Lee. That is what I, based upon looking at them, what I presumed that they were. That is what I presumed that they were. At that juncture, I informed counsel that I had received them. Because I had viewed them as privileged, I had indicated that I would not let the people see them, but that Mr. Burgess could come by our office and look at what had been received. Shortly thereafter, I received Mr. Burgess' motion to withdraw, and basically that was going to be heard today. Almost immediately thereafter receiving that, I then received in, I guess, in our office mail or however it got to me, a letter from the defendant saying all kinds of different things, but indicating that he did wish to represent himself. That letter that he sent was shared with both sides. Today, I provided a copy to the people and also to Mr. Burgess in this case. All right. Is anything from the people?
Your Honor, just that I've spoken to Mr. Burgess about this matter. I don't have an objection to this motion. That's of course discretion. So as I've been concerned, we've had communications about this case. He has fought diligently for his client.
All right. Mr. Lee, do you not wish Mr. Burgess to represent you in this case?
That is correct, Your Honor.
All right. And the other thing, you wish to represent yourself, or do you wish the court to sign an order that permits the Office of Manager Assigned Counsel to appoint counsel to represent you?
I would like the latter.
So you want new counsel?
Yes.
So you want at this time and I think it's on page 2 of your communication indicating that you wanted to represent yourself. You want the court to disregard that at this time?
Yes, sir.
You understand that because I'd be appointing new counsel, that's going to require that this matter be adjourned to allow counsel to get up to speed on your case.
Okay. I was unaware of that. Are we talking about 1 month or a 2-week adjournment? Just curious.
Well, it's wherever the court, I've got a very tight schedule, but we will, what day?
August 19th.
It would go on approximately a month.
Okay, I have some upcoming surgeries, and so I will then like to just represent myself because I don't, they're very serious surgeries, and so I don't have the
Okay, but
time to
right,
wait.
I understand that, but when do you think, if you represent yourself, when do you think your examination would be?
I would object to any further delays, and I would like as soon as possible, convenient with the court and everyone else. I'm prepared.
You're prepared to what?
I'm prepared to take the first available date for the examination as soon as possible.
Well, I don't know what you're asking me to do, Mr. Lee. Have you reviewed all of your discovery and everything?
As far as I know, the discovery was just 2 pages of the interview with the detective and the victim. I have reviewed
I'm
that.
going to probably believe that there's more than just 2 pages.
I just provided copies too, Judge. He was at my office on May 8th.
So I would need copies of that.
I mean, Mr. Lee, you're not, would I be correct that you are not prepared to go forth today to preliminary examination yourself? I mean, because you keep going back and forth, you want counsel, then you want that.
So I am prepared to go today. Absolutely.
If you represent yourself, you're prepared to go forth today?
Yes.
So what do you want me to do, Mr. Lee?
I would like to proceed today.
Okay, you understand that it cannot finish today?
Sure. I agree. That's fine.
Would the people have a witness they can start with?
You want to have a witness we can start with? I will say for the record, I do have concerns that eventually he's going to be representing himself. He's doing so without having all the discovery. And he, of course, will be held to the same standards as any attorney would be held. So a lot of concerns for the people, but we do have a witness available if that's what the court thinks to do.
Is that really what you want to do, Mr. Lee?
Yes.
I think I'm going to be honest with you. I think you're just telling me yes, thinking that you're going to get a quicker date. And I am not clear that you're ready to go because you only talked about 2 pieces of paper and counsel's telling me there's a whole lot more in this file.
I understand. I'm willing and ready to go
Do you
today.
have a copy of the discovery?
My attorney hasn't provided me with a copy.
Sure, Judge. I gave it to him on May 8th. He was at my office. He got it.
Well, the 2 pages, yes, that's what I have.
No.
The other stuff I don't have.
Your Honor, for the record, not only is there a full police report, but there's also body camera footage that, again, it might be best to review before.
Have you seen the videos, Mr. Lee?
Well, I was there. I'm assuming they're referring to the body cam footage.
Well, I don't know. You're making assumptions about what exists, and I don't know. Have you seen the body cam footage, Mr. Lee?
No. If you're, no.
Do you still? This way. Would the people be available? It is going to be a mess on the afternoon of the 8th. It's a Friday.
Your Honor, I should be available. And I August 8th, Your Honor.
Yes, ma'am.
Yes, Your Honor.
All right. Are you going to be able to? So if I set it on the 8th, sir, and I'm sort of pigeonhole you in on a Friday that I normally wouldn't hold them, but if I do the 8th, are you still wishing to represent yourself or do you wish an attorney?
I'll represent myself.
Your Honor, the one thing I would like to add, because as I stated, we're ready to proceed today. The victim is here on administrative basis this morning. Victim has also been here previously. I would just ask that we have no further delays on the 8th.
if I'm gonna be done, if you're saying, Mr. Lee, that you're representing yourself and I set this on a special date, I'm not going to at that time. If you wish an attorney, then I'll have to deal with that, but I'm not going to let a delay happen again. We're gonna go on the 8th.
Yes, Your Honor.
Is that what you want to do?
Yes.
All right, I'm just, pardon? All right. So that's what I would set. I will advise you at this time, Mr. Lee, you understand that you are charged with the offense of criminal sexual conduct in the 4th degree involving force or coercion. Do you understand that, sir?
Yes, sir.
And that involves a Stephen Kwanzi. You understand that, sir?
Yes, sir.
You also understand that this is a high court misdemeanor punishable by up to 2 years incarceration, a $500 fine plus court costs, mandatory HIV and STD counseling, and DNA was taken or should have been taken upon your arrest. Do you understand that, sir?
Yes, sir.
You understand also that this, under the SORA statute or sex offender statute, is a tier 1 offense and would require registration if the victims are 18 years or older. You understand that, sir?
Yes.
All right. And also other requirements, but I'm presuming that the victim, that's the only one that would be applicable in this test, in this case.
Yes, sir.
You understand all of that. You understand that if you proceed to represent yourself, you do so at great peril. And usually doesn't not necessarily work well for people when they represent themselves, but you are constitutionally entitled to represent yourself. You understand that?
Yes, sir.
You understand also that the court is going to make the assumption or presumption that you understand the Michigan court rules and the procedures used in a courtroom. You understand that, sir?
Yes.
You understand that the court would not be there to assist you in any way regarding this case. You understand that, sir? And you understand that you will not be, the court is not going to treat you worse. I'm not going to treat you better than any attorney or the prosecutor in the case. You will be held to that same standard in conducting this.
Yes.
All right. Understanding all of that, you still wish to proceed representing yourself, sir?
Yes, Your Honor.
All right.
Your Honor, just for clarification, does the defendant want to stand by counsel?
He has not asked for it. I'm not offering it.
I'll take one if it's available. Thank you.
Well, there's going to be a funding issue regarding that. I'll make that determination as to whether or not there be standby counsel, because that can be done elsewise other than this. I will adjourn the preliminary examination in this matter to August 8th, 2025 at 12 noon. That's before me.
Bond violation follow?
Yes, it was that and bond violation. Yes.
The defense is requesting, you to, examine the information between myself and my attorney, because I am alleging that I did not violate the, bond, the condition of the no contact order of my bond, and the, witness tampering, that the prosecution says that I'm guilty of, and the text messages prove.
You're asking me to look at information that would be relevant to the bond hearing?
The text messaging between myself and my attorney, and then the Google AI searches that prove my motive and intent for making the phone call between myself.
Sir, and you're asking me to look at it in reference to the bond violation?
Yes, because I think it should be reinstated.
I will address that on the 8th.
Okay, thank you.
And not making a guarantee I'll look at it or not. I don't know whether or not it's relevant, but I will deal with that on the 8th. At this point, his bond will continue. Thank you. What I'm going to do, and I realize I have 3 short matters, I'm going to take a break, allow the press to break down, get themselves out, and then I'll come back out. Court is standing recess. All right.
14A District Court of County, Washington, State of Michigan is not accepted the applicant.
You may be seated. Stop your animation in front of a thing, because the court's in.
I'm getting out of here.
Thank you. You will.
I know my place.
No, yes, no, apparently you don't, because you keep talking. Court calls the case of the people versus Anjanae Yancey.
Andrew Tilly, defendant on behalf of the people.
Good afternoon, Your Honor. Here, Lacey, on behalf of Ms. Yancey, who's to my right.
Your name?
Your Honor, Anjanae Yancey.
You take your hands out of your pockets, please.
I believe you're very much aware of what's going on in this case. I spoke with Ms. Lacey. It's my understanding that she has provided some information to Ms. Burton Harris. So we're kind of waiting on disposition from Ms. Burton Harris, we don't have that yet. We have no objections. It's not a few weeks. They're already in front of the court. They have a resolution.
That is correct, Your Honor.
So you're winding further up the ladder.
I am.
I'm just,
Gotta do what I gotta do for my client, Your Honor.
the 19th. Yeah.
That's fine. What, 12 o'clock? Ish. We'll find out.
Preliminary examination will be adjourned August 19th, 2025. That is at 12 noon, correct?
Thank you, Your Honor.
That is at 12 before me. Because I'm lucky. And continue.
Thank you. Thank you.
Let's call the case of the people versus Mark Hubbard.
And on behalf of the people, Your Honor.
And good afternoon, Your Honor. Assistant Public Defender Chinaza Carey, on behalf of Mr. Mark Hubbard, who is approaching. Mr. Hubbard,
Left.
I'm still here, Judge. State your name for the record, Mr. Hubbard.
Mark Hubbard.
So I'm gonna have you sign here.
And what are we doing?
Your Honor, this will be a waiver. He is
Oh.
signing the waiver form.
Counsel's aware. I don't have any information on this one. So we're probably gonna need one printed. Yes, okay. Was there an amended complaint file?
No, believe so, Your Honor. We only have the one in our file.
Okay. That may be why I don't have an information. We can correct it in a moment. Sir, you're waiving your right to preliminary examination? Yes. Yes, sir. Yes. You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them. You understand that? You understand you'll not have that hearing today and you'll proceed to circuit court. All right. People also waive their right?
Yes, Your Honor.
All right. I'm gonna do it this way because as I understand the counts, defendant or preliminary examination having been waived, defendant is being bound over to circuit court on count 1, carjacking, count 2, unarmed robbery, count 3, assault with intent to do great bodily harm less than murder by strangulation. And then, got it. There was no probable cause found on the requested count 4. And I think that's our right. So he's being bound over to circuit court on counts 1, 2, and 3 with the DV count 4 found. Second ruling.
Yes, Your Honor, we do acknowledge receipt of the information. We waive formal reading, standing mute, asking the court to enter a not guilty plea on this behalf.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea as to all 4 counts. Pretrial in this matter will be set for
August 6th at 1:30 for Judge Conlon.
August 6, 2025, 1:30 before Judge Conlon.
Thank you very much, Your Honor.
Thank you, Your Honor.
Thank you. Oh, shoot. I said on the wrong one. Bond continued.
Thank you, Judge.
That earlier.
On that case, I'm going to need an information for you to sign off on.
Will do, Your Honor.
Bless you. Court does call the case of the people versus Valerie Robinson.
Good afternoon, Your Honor. Ashley Lodge, people. I don't know what he is. Bedroom is. Thank you, Your Honor.
Chief, can you ask if he's next door? Because they had a number.
Judge, Mr. Jervis is on the record in front of Judge Kunke at the moment. If the court would mind asking.
In front of Judge Kunke?
Yes.
Oh, he's here,
He is.
but he's
Yes, he's
zooming into their
yes.
court, not looking to zoom here.
Correct.
Okay. Ma'am?
Yes.
What I'm gonna do is I'm gonna pass your matter, well, hold on. Is that him making? No.
No.
All right, what I'm gonna do is I'm gonna pass your matter And as soon as your attorney is available, we'll get you back up, okay? Thank you. That was a short matter that we, what were we gonna do on that?
It's gonna be a dismissal.
Pardon?
That'll be a dismissal.
Oh, it's gonna be a dismissal?
Yeah, you proceed.
Oh, ma'am, come back up. I'm not gonna hold you up. Mr. Drukas is in another courtroom. Do you have any objection to Ms. Akinruli right there, standing in for him so we can get this matter done?
No.
All right.
Matter of valid protection, people that send people are able to proceed.
And Your Honor, Assistant Public Defender Tanazi Carey Akinruli, on behalf of Ms. Robinson, standing in for Mr. Drukas, Your Honor, we do move to dismiss this matter.
No objection.
All right. This case is dismissed. That is without prejudice, people being unable to proceed.
Thank you.
All right. Thank you, Ms. Robinson.
Thank you.
All right. Well, I think when it says the person- All right. Are we ready to start holding? Is there anything else in here?
Yeah, he is.
All right, court does call the case, People State of Michigan versus Gamma.
I'm sorry, if you could just step outside one moment and I was gonna text her mom who would come back inside.
Outside of the building?
Yes. just-
Okay, that's gonna take a minute. Give me another one. Court does call the case of the People versus DeAndre Weems.
Alex, on behalf of people, Your Honor.
And Alex Warren Green on behalf of Mr. Weems. Mr. Weems is sitting on the bench right outside the courtroom. I will go retrieve him. We'll be right back. We're ready to proceed.
Why am I still staring at you? Go get him.
Your Honor, I need court permission.
You did? Huh? He did. He did wait. He was waiting for my permission? Yeah, I know. Hey, but we're, all right.
Mr. Weems, can you state your name for the court?
DeAndre Weems.
The defense is ready to proceed to examine, Your Honor.
We've already proceeded, Your Honor.
All right, have a seat. Let's go.
Your Honor, the people would first call Adrian Jennings to stand.
All right. All right, if you please come forward to be sworn.
Before you take a seat, raise your right hand. Solemnly swear to the truth, the whole truth, and nothing but the truth, so help you God. Have a seat. State, spell your first and last name for the record, please.
May inquire.
Thank you, Your Honor. Good afternoon, Ms. Jennings. I'm just gonna ask you a few questions, and if you need a break, feel free to let us know, okay? Ms. Jennings, do you know what DeAndre Weems? How do you know him? For about how long? Okay. And if you saw DeAndre Weems in the courtroom today, would you recognize him? Is he in the courtroom today?
All right, ma'am, I'm gonna have to ask you to speak up if you can for me, okay? All right, thank you. Go ahead.
Okay. And can you briefly identify something he's wearing and where he's sitting in the courtroom? Your Honor, please let the record reflect that this witness has made an in-court identification of the defendant.
No objection. Record shall so reflect without objection.
All right, Ms. Jennings, I'm going to first direct your attention to June 1st of 2025. On that date, were you at 1474 West Liberty, Apartment 2? And is that in the County of Washtenaw, State of Michigan? And on that date, at that location, did the defendant do anything to you that made you contact police?
I was assaulted and I contacted, I went to the hospital in a second. That was on the way to work.
Okay, so let's kind of go through what happened when you say he assaulted you. So let's kind of start at the beginning. So what happened on the first that started everything?
So on the first, he came over, we came home from work around 3 o'clock. And the neighbor came over, that was going to start cutting his hair. And so they started hanging out and talking. And his neighbor brought over some tequila, they were drinking. And I was, thought it would be a good idea to have a cookout.
Okay.
So I went to the store and got some steaks and whatnot, and we fired up the grill. Destiny, his daughter, was there, and the neighbor had a few kids there. The kids were playing, bubble machine and chalk and stuff outside. So after I returned, I began to grill the food and prep for dinner.
And then after we didn't eat, the adults, we did not eat, the children all ate. And I started cleaning up all the kitchen and stuff and having the food that I had made. And
That's okay. If you need a moment, take a moment.
I started cleaning the dishes and after, and he would not allow me to go outside, he pushed me back inside.
And when you say he, are you referring to Mr. Weems? Okay, so he wouldn't allow you to go back outside. Okay, and what happened next?
He pushed me inside and pushed the door.
And when you say he pushed you, how did he push you?
He pushed me with his body. And so I go back inside, I just set the trash down, I finished, Dusty came in, his daughter, and I got her ready for, in her pajamas, to get her ready for bed. And I could just tell that it was like a good night.
And what made you think that?
When he gestures and the way he talks, I know that I feel like I'm walking on eggshells. I don't know what to expect, what kind of personality I'm going to get. So after I got Destiny in her pajamas, I then went in and sat on the couch. I set her up in her room watching a little TV. And I went and sat on the couch and I waited for the neighbor to leave and for DeAndre to come inside.
Okay, so at this time you're in the house and DeAndre's outside the house? Okay, and then what happened next?
I turned on the news just to grab my mind because I was just almost just waiting for something, whatever was going to happen. He came in and sat down next to me. And was asking me and making me feel like I made him act a certain way. And I went to go get up and he told me to go get in the shower and to meet him in the bed naked. So I went in and I got in the shower. And after I got out of the shower, he came in and he pulled the towel off of me.
In the bathroom?
Yes.
Okay.
And told me to get into the room. I went into the room. And he went in bed to sleep next to Destiny. And he yelled for me and told me that her diaper needed changed. So I went to put up my nightgown to look here for her. And I went into the room and he yelled at me and told me that I wasn't wearing clothes and to go put some clothes on, so to go put on pants. And he followed me at this point, switching conversations, saying that I needed to go clean the patio.
So this occurred from, sorry to interrupt, he followed you, you were in Destiny's room and then went back to your room to change. Okay, and then what happened?
And throughout, he then shoved me into the room and closed the bedroom door.
And when you say shoved, how did he shove you?
With his body. He pushed and shoved me in, and then he closed the door.
And then what happened?
And he grabbed my nightgown, pulled it, and it tore it off of me. And I fell on my knee at this point, and I thought I was so bad, she didn't go up to my hip.
Okay.
Then he pulled me up and he laid me on the bed on my back, and he slept 5 times in my face.
And was that with an open hand?
Yeah.
Okay. If you need a moment, take a moment.
And he pushed me over, and I was exposed. And he was trying to take his pants off, and I asked him if he's gonna rape me. He said, no, at that point I didn't push him away, and I got up on the bed trying to cover myself up. He then grabbed his tablet, Destiny's tablet that she uses to play games on, and started taking unsolicited pictures of me, unwanted pictures. And then he grabbed his phone and started taking pictures and saying I'm too fatty to even want to have sex with me anyway. Then I tried to crawl away and I scooted to the edge of the bed. And that's when he hit me, punched me in the face and something my lip open.
And was
I tried to cover up my head and he hit me 3 or 4 more times.
and did he hit you with a closed fist that time?
Yeah.
And then what happened next?
And then I started trying to strangle, but then he turned the lights off by this point, and I couldn't see what my clothes were. I was trying to close, and he kept saying, I'm just gonna call the police because you did this to me, you did this to me. And I said, call the police, I need help, I called the police, I don't.
So at this point, you're still in the bedroom?
Okay. I scrambled to my clothes, I found a t-shirt and a pair of jeans, and I put them on. I did not even know bra on or any shoes. And I got up, and by this point, he had walked out into the hallway, and Dusty was standing there.
In the hallway?
In the hallway. crying. So I go down the hallway and he leads me to it and grabs my keys off of the kitchen table. And he wouldn't let me have the keys. And at that point, I went outside, I grabbed my work bag, because I needed my work bag. And then issues on and I'm telling him, I'm gonna call the police if you don't give me my keys, because I wanna go home.
Okay. And he wouldn't let you have the keys?
He gave them to me after I attempted to call 911.
Okay. Your Honor, may I have one moment? Thank you. And Your Honor, nothing further from the people for this witness at this time.
Cross-examination.
Thank you, Your Honor. Good afternoon, Ms. Jennings, and same goes for my questions. If you need a minute, please let me know and I'll give you a minute, okay? My name's Alex Warren Green. I represent Mr. Weems in this matter. Ms. Jennings, on June 2nd of this year, you talked to an Ann Arbor police officer, right? Okay. When you talked to the Ann Arbor police officer, that was at your place of employment, right? And you talked to that police officer about an assault you said took place on June 1st, is that right? Going back to this was at your place of employment, how are you employed?
I am a paramedic for University of Toledo, or I also work there too. I have University of Michigan Hospital.
So this was at the University of Michigan Hospital. Okay. And when you were interviewed, there was a person with you, right?
My mother is phone.
So the person who was sitting next to you during that interview, that was your mother?
I did have my mother and I also had a coworker.
Okay.
And I believe the social worker.
Okay. Are you having trouble remembering who was with you when you were interviewed?
I know that a coworker had come in. I do know my mother had arrived a little later.
Ms. Jennings, would it refresh your recollection if I showed you a picture of the interview? Okay. Your Honor, may I approach witness? You may. Thank you. Ms. Jennings, can you just tell me if that refreshes your
That's my mother. Yeah.
So that refreshed your recollection?
Yeah.
Do you mind stating and spelling her name for the court?
Tina Zeyer, Tina, Zeyer, Zei, T-E-R.
Thank you. Okay. So during that interview, you showed the police officer a number of pictures you had on your phone, right? And I'm sorry, just to remind you to keep your voice up a little bit. Thank you. The police officer, he didn't take any pictures himself, did he?
No, he had a body cam on it. And the doctors also took pictures.
Okay. And the photos you showed the officer, you had visible injuries in those pictures, right? Injuries to your mouth, your hands, and your chest are visible in those pictures, right? When you talk to the police officer, like you said, he didn't take any pictures, and that's because you couldn't see any of those injuries. Isn't that right? So when you talk to the police officer, there were injuries on your hands. Is that right?
Yeah, I have some.
And there was injury to your mouth, your lip area. And there were injuries on your chest right here, right? Okay. So going back to June 1st, the day before, you, on direct examination, you told us there was a dispute about the car keys, right?
He was not going to give me my car keys for me.
You never told the police that he took your car keys, did you?
Give all the information.
And on direct examination, Ms. Jennings, you told us that he took some illicit or explicit, I can't remember your words, but he took some pictures of you without your permission. You said that, right? And those pictures, you never provided those pictures to the police. You never. Okay. Destiny is, and they're on her tab. Okay. At this time, you were living with Mr. Weems and Destiny?
I have to stay there, probably on occasions, they work at, University of Michigan.
And as far as you're aware, the police never looked at Destiny's tablet, never looked at his phone, right? Okay. So being employed in healthcare and being interviewed at your place of work, you were wearing like scrubs, right?
That I did not work that day. I did not walk. Put weight on my left leg. I was afraid that my knee was broken.
Did you put makeup on to cover the injuries?
Previous times that he has injured me.
Do you remember this day telling the police that you put makeup on to?
I'm pretending I'm going to work, but I cannot walk.
Okay. As a healthcare worker, you wash your hands a lot, right? Your Honor, I have nothing further for this witness. Thank you.
Pardon?
I have nothing further at this time. Thank you.
Thank you. Redirect.
Just briefly, Your Honor. Ms. Jennings, on cross, you mentioned you had injuries. What injuries did you have?
I have still a scar from him hitting me in the face. And I had injuries to my chest, bruising from when he tore off my nightgown. I had injuries to my inner arm from when he grabbed me. I had injuries to my hands. I fell down. I had scraped them on the carpeting. My knee was badly injured with a rubber.
And you took photos of these injuries? And did you provide those photos to police? Your Honor, may I approach the witness people's proposed exhibits 1 through 7?
Yes, you may.
Thank you, Your Honor. And Ms. Jennings, what did I just hand you?
And the injuries.
And are these fair and accurate representations of the injuries you received from this assault from Mr. Weems?
Yes.
And Your Honor, the people would move to admit people's proposed exhibits 1 through 7.
No objection.
Exhibits 1 through 7 are admitted.
And Your Honor, may be published to the court.
Yes.
And nothing further for this witness from the people, Your Honor.
What name I may have. Just a question. Where were you when you took these pictures?
The one initially was in my car, and then when I got home, I didn't know how bad I was hurt when I got home. I was in my bathroom.
In Toledo?
Yeah.
Okay. All right. So the one where you have blood running down your face, that one was in your car?
Yeah.
Okay. And then the others were taken down in Toledo.
Mhm.
All right. Thank you. Any questions based upon the court's question?
None from the people, Your Honor.
And none from the defense.
All right. You may step down, ma'am. Thank you.
Your Honor, the people have no further witnesses.
Any witnesses for the defense?
Your Honor, at this time, the defense would call Officer Coles. I believe he is present in the courtroom.
All right. Okay. Sir, please come forward and be sworn.
Take a seat, raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? See, state spell your first and last name for the record, please.
First name is Matthew, Matthew, last name is Coles, Kohls.
You may inquire.
Thank you, Your Honor. And at this time, Officer Coles is a witness identified with the prosecution. I would ask the court leave to ask leading questions on direct examination.
When I hear objection, then I'll rule on that. You may inquire.
Thank you, Your Honor. Officer Coles, my name is Alex Warren Green. I represent Mr. Weems in this matter. Officer Coles, on June 2nd of this year, you were investigating allegations from an alleged domestic assault that occurred on June 1st, right? And you interviewed Ms. Jennings on that date, right? You've investigated domestic violence cases before? And when you're investigating a domestic violence case, you follow a standard protocol, right? Separate the parties and you perform interviews, right? And here, Ms. Jennings, she was with another person when you talked to her, right?
Objection, Your Honor, this leading.
I'll overrule it. I don't know what to. Go ahead.
Through your investigation, did you identify that person as the person who called 911? not Miss Jennings, the person with her. Was it your understanding that was the person who called 911? Do you have any reason to dispute that she was the person who called 911? No. Did you ever consider that person an eyewitness in your investigation? No. And to your knowledge, who was that person? So kind of moving forward with the protocol you follow in domestic violence cases, one of the things you want to do is you want to take photographs of the alleged victim, right? Yeah. And that helps you document and memorialize the presence or absence of injuries, right? And you want to do that as close to the alleged incident as possible because injuries fade over time, right? And you didn't do that here. You didn't take any photographs as part of your investigation here, did you?
Can I get something clear? I guess. Did this officer show up on the scene?
Your Honor, Officer Coles, my understanding is he interviewed the complainant the following day.
Okay. All right, go ahead with your question.
Thank you, Your Honor. So you didn't take photographs of Miss Jennings at that time, but she provided you photographs that were saved on her phone, right? Yeah. Okay. That was an iPhone. And you're aware that one feature on the iPhone is that it creates a date and timestamp on the picture, right? Automatically. And that date and timestamp is absent from the photographs you provided to the prosecution and to the defense here, right? Okay.
Were the photos that were presented to you, did they have a date and timestamp on them?
The photos that were provided to me, the way that they were provided, so she gave me her phone. I looked at them, they had date timestamps on them, but I sent them over to me. That did not bring the timestamp over.
Got it. Okay.
You were on your body worn camera, right? And she handed you her phone, right?
Sure.
And when you looked at those pictures, you could see the date and timestamp on them, right?
Sure.
Okay. When you're following your domestic violence investigation protocol, another thing you do is you want to create a supplemental report, right? Create a supplemental report, right? And that includes a lethality assessment, right? Okay. And you did that in this case, right? You didn't observe any visible injuries when you interviewed Miss Jennings. Isn't that's correct, right?
That's not in the report.
Did you observe any visible injuries when you interviewed Miss Jennings?
This was almost last refreshing.
Would it refresh your recollection to review your domestic violence supplemental report? Yes?
Yeah. Okay.
Your Honor, may I approach the witness? Thank you. May I approach, Your Honor?
You may.
Thank you. Officer, do you recognize that as a domestic violence supplemental report completed in this case? Will you let me know if that refreshes your recollection as to whether you observed visible injuries at the time you interviewed Ms. Jennings?
And Your Honor, I would ask that he be allowed to review his entire report and not just the lethality assessment that's attached at the end of the report.
I have no objection, Your Honor.
Somebody gonna give him,
He has it before him.
the whole report?
Yes. Is your recollection refreshed? Your recollection, that did not refresh your recollection. Officer, when you completed your domestic violence supplemental report and lethality assessment in this case, there are a number of boxes, each of which describes a particular injury, correct? When you complete any lethality assessment in any investigation, there are a number of check boxes that describe a particular injury, right?
Yes.
Okay. In this case, you didn't check any of those boxes, did you? Okay. Officer Coles, when you interviewed Ms. Jennings in this case, you were wearing your body worn camera, right? And it was recording, right? Your Honor, may I approach the witness with what has been pre-marked as defendant 1?
What is that?
It's a still frame from the officer's body worn camera.
Any objection? I mean, I don't, it's defense 1, but I don't know where it came from.
Your Honor, at this point, I have no objection to the still of the body camera. but-
No objection?
No, Your Honor.
No.
Thank you. Officer Coles, what are you looking at?
Still image of the mother.
Does it have a date and time stamp on it? What is that date and time?
June 7th.
Has it been altered or modified in any way?
My recollection, or that was my knowledge.
It's a true and accurate depiction of your body worn camera on June 2nd, 2025 at 21:11 hours and 26 seconds.
I don't know how he's gonna be able to say that without some indication as to where the still came from. I mean, there has to be more foundation than that. You're asking him to authenticate what effectively would be a slide within a reel.
Sure. Officer, do you recognize anyone in that picture?
I recognize the victim and the mother.
Is that your recollection of your observations on June 2nd, 2025?
Yes.
Does it appear to have been altered or modified in any way?
It would have had to have been. If it's taken from a video, it has to be altered. So the question that you've asked the officer is unfair.
Is that a true and accurate depiction of a still frame from your body worn camera?
Is there an objection?
Your Honor, at this point, I'm going to object. I don't think he can properly say that this is a still, as he's not the one who took the still. It would rather have come from his actual body worn footage that he provided in our discovery, Your Honor. So at this point, I'll be objecting due to lack of foundation.
Your Honor, may I retrieve my proposed exhibit?
Did you have a response to the objection?
Your Honor, I believe he can authenticate this.
How can he authenticate it? You took something from something else. He would first of all have had to have seen that. I don't know how he authenticates it. You haven't asked enough questions for him to be able to authenticate it. So yes, you may approach and get your exhibit.
Thank you, Your Honor. Your Honor, if I may. Officer, you acknowledge you were wearing the body camera. It was recording on June 2nd when you interviewed Ms. Jennings, right? Yes. Okay. Have you reviewed that before your testimony today?
Only reviewed it once when I was speaking.
That was when? Back in June? So you didn't review it before today? Right before testimony? All right. That's probably why you can't authenticate your picture. But go ahead with your next question.
Your Honor, may I approach with the body worn camera footage? This would be defendant's 1. Thank you, Your Honor.
Any objection?
Not this way, Your Honor. I believe.
Go ahead.
Officer, I'm going to show you the beginning of this. You can skip around anywhere you want, okay? Your Honor, for the record, I've shown this to the prosecution, was provided a discovery. I'm going to skip to 9 minutes and 32 seconds unless there's an objection.
Your Honor, at this point, I'm going to object at this point, as I don't believe the proper foundation that this is a fair and accurate representation of this body camera has been met. What is being shown?
I'm trying to lay a foundation here.
I wish you'd hurry up. Go ahead. Try to lay your foundation.
Officer, I was skipping around in the body worn camera video, right? Yes, you're skipping around. At random? Yes. Did it appear to have been altered or modified in any way? Skipping around. Did you recognize that as your body worn camera footage from June 2nd, 2025, when you interviewed Ms. Jennings? Okay. Your Honor, at this point, I would move to admit.
I can't, go ahead. Yeah, respond.
No objection, Your Honor.
I just don't know why we went through all of that. The body cam that came over in discovery was attached to this officer, right?
It was, Your Honor.
Then why wasn't there just a stipulation that that's his body cam? I don't understand why I just went through the last 10 minutes that I went through.
Your Honor, I'm offering it for a very limited purpose.
I don't care why you're offering it. I just spent all this time trying to authenticate. It makes no sense. You're moving it to admission?
I am.
Which we could have done 10 minutes ago. No objection? It's admitted.
Your Honor, may I publish to the court?
Yes, you may.
If I plug into this.
Am I going to watch the whole thing?
No, you are not, Your Honor.
Better watch your mouth.
I'm not going to, Your Honor. I apologize.
Go ahead, Kingsley.
Yes.
If there's no objection, Your Honor, I would ask to move to the 2-minute and 20-second mark.
Any objection? All right.
And I'm pausing at the 2-minute and 36-second mark. Officer, that's Miss Jennings, right? Okay. Miss Jennings appears to have a blanket or a towel of some sort around her shoulders, right? You can see her left hand, right?
Yeah.
There are no injuries on her left hand. I'm continuing playing at the 2-minute and 36-second mark. And I'm pausing at the 2-minute and 42-second mark. Officer, you can see Miss Jennings' right hand, right? Are there any visible injuries? Officer, you wear the body worn camera in the center of your chest because it kind of sees what you see, right? Sure. But what you look at, the body worn camera kind of looks at too, right? Sure. When you were interviewing Miss Jennings, you were looking at Miss Jennings, right? Your view was unobstructed, right? Sure. But your view, your eyes were never obstructed by anything, were they? Okay. And you didn't observe any injuries, did you?
I was mainly trying to listen to what Jennings said. She's gonna be safe.
Your Honor, if there's no objection, I'd ask to move forward a little bit.
No objection.
Go ahead.
Officer, I'm pausing at the 8-minute and 44-second mark. You can see her arms, right?
Yeah.
She's holding them up by her head. Are there any injuries to the back of her arms?
Okay.
I'm resuming at the 8-minute and 45-second mark. I'm pausing at the 9-minute and 1-second mark. Officer, you can see her full face, right? Let me move forward.
You know, we get me really good right here. Over here.
At the 9-minute and 8-second mark, you can see her full face, right? Can you see any injuries to her face?
Hard to see from this angle in this video.
Or you don't see any, right? Officer, you interviewed Mr. Weems, right? You weren't wearing your body worn camera when you did that, were you? It wasn't activated though?
To our policy, you would have a bond in the back of the security room.
So your policy as an officer of the Ann Arbor Police Department is not to record interviews with suspects.
Objection, Your Honor, that's not what he said.
Yes, I agree.
As a matter of policy, in this case, you didn't activate your body worn camera to record your interview with Mr. Weems.
Objection, I don't believe that's what he said.
That isn't what he said. Try again.
You interviewed Mr. Weems in this case, right? It was not recorded in any way, was it? We need a verbal answer. Officer Coles, to your knowledge, is there any recording of any interview with any person other than Ms. Jennings in this case?
I did an interview with Mr. Weems.
Okay, was it recorded?
I would have to look at my accent to see.
Thank you, Officer. Your Honor, I have no further questions.
Any, direct or cross?
Just briefly. Your Honor.
Officer Coles, isn't it true that in your report you did say that Ms. Jennings had obtained bruises and abrasions in the body of your report? Would it refresh your recollection to review your report? Your Honor, may I approach this witness?
You may.
And did that refresh your recollection?
That refresh my recollection from when she told me and from that dated the pictures.
So it is true you put that she obtained bruises and abrasions?
Yes.
Nothing further, Your Honor.
Sir, thank you. You may step down.
Thank you.
Any additional witnesses for the defense?
None from the defense, Your Honor.
Any rebuttal from the people?
No, Your Honor.
Do I have a motion?
At this time, Your Honor, people would ask that the defendant be bound over as charged. I apologize, Your Honor. You heard from Ms. Jennings about the assault that occurred at 147 West Liberty, in which the defendant had been drinking, became agitated, and through the course of the night began to get aggressive with Ms. Jennings. You heard her say that he had slapped her in the face with an open hand, punched her in the head with closed fists. You also heard that she had been almost pinned inside the bedroom due to him blocking the doorway and not letting her leave. You also heard from her how he took photos of her while she was vulnerable and exposed, and that their daughter was present. You also saw the injuries that she received from the assault from Mr. Weems, and I believe that you met our probable cause burden for domestic violence offense and ask that he be bound over as charged, Your Honor.
Response.
Your Honor, I don't have much to add to the record at this time. In making the probable cause determination, I would just ask the court to pass judgment on the credibility of witnesses, the weight and the competency of the evidence. I'm citing People v. King 412-145. Your Honor, for the record, we would object. I appreciate the opportunity to be heard.
The court has listened to the testimony in this case. Listen to Ms. Jennings. She was she was absolutely precise about what had transpired to her, down to the point of saying that at some point she's in the dark trying to figure out her clothes or where her clothes are, trying to get herself out. When looking at people's exhibits 1 through 7, what is clear is that on that date that she took these photographs, that she had significant injuries to her lip, as she had testified to the front part of what would be the sort of left side of her chest. You can see scratch marks, and you can see that to the left side and to the middle of her chest. There are her arms, and there are indeed marks on her hands, and then the falling to the ground that she described, which also prevented her from going to work, certainly can be seen in, I believe it would be People's Exhibit 6 in terms of the injury to her knee. And looking at all of that, and the court having evidence of the defendant's prior convictions, court does believe that the people have indeed sustained their burden, and the defendant is bound over to stand trial on domestic violence third.
Your Honor, we acknowledge receipt of the information, waive its reading and stand mute.
And in having waived former reading, standing mute, the court will enter a not guilty plea. Pretrial in this matter will be set for
September 11th at 1:30, Judge Slay.
September 11, 2025, 1:30 before Judge Slay. Are there any issues regarding bond?
Your Honor, given the testimony from Ms. Jennings, I believe in this case, the defendant's bond was set at a PR. At this time, the people would be re-requesting our original amount of 50,000 cash surety. Just given the facts of this case and the defendant's previous history of the 2004 DD conviction, 2008 FAA DD second, a dismissed DD third case from 2012, 2022 case of an RNO, and then a dismissed 22 case for possession of a weapon by felon, ammo possession by felon, firearm. I have concerns, given especially the fact that Ms. Jennings did come here today and testify for her safety, given the facts of this case and what happened in this history. So at this point, we would be re-requesting our original amount of 50,000 cash surety, Your Honor.
Response.
Your Honor, Mr. Weems has been out of custody since the time of arraignment. He has had no violations of bond. He's employed. He's not violating any laws or anything like that. He's come to all of his court dates. The information that was presented at this preliminary examination was known to the magistrate at the time bond was set. I don't believe anything outside of what is contained in the discovery was brought up during this preliminary examination. So, Your Honor, we would ask that this court continue bond. I don't believe Mr. Weems is a flight risk, and I don't believe he presents a danger to the community.
Well, I don't necessarily view or have any evidence that the defendant may be a flight risk. I do have some concern about the defendant being a significant danger to the community and posing a danger to the community. One of the things, and it was rather interesting but subtle in terms of what Ms. Jennings said, is that she understood what was going to be coming at her. She actually put it very succinctly that she understood all of the signs that were going to happen before, quite frankly, the beating was going to take place. I think the defendant's likelihood of conviction case is significantly high, which is something the magistrate couldn't take into account. I also, to the extent that the magistrate heard all of this and saw all of this, then I think the bond set at arraignment was an abuse of discretion. But I don't think the magistrate saw all of that in what the court saw and heard today. So the court, believing the defendant to be a significant risk to the community, defendant's bond is hereby ordered changed. This bond will be set in the amount of $35,000 cash surety. Defendant's remand.
Thank you, Your Honor.
Thank you.
He needs a different date since he's in custody. He needs the in custody date before Judge Slay.
The exam was held.
No, his date is the same. Okay. September 11th. Yes. You need to. I'm gonna take a quick, Mr. Johnson's back. Where are they down or are they still?
I just have to let Flint know.
Okay, do they need to be brought? I think they're gonna bring him that way. Okay, let me take a brief recess then and we'll.
Do you want me to start that?
Start that process. Where's Mr. Of course, we'll say in brief recess. Where's Mr. Jones?
I think he just was using the restroom.
Oh, okay. All right.
14A District Court for County.
May be seated. You get yourself downtown.
Yes, sir. Thank you very much.
That's way out.
Yes.
So, some of that.
He's sitting there like he wants to be on trial.
It's just a matter of time.
Court does call the case of the people versus Daniel Franklin.
Andrew Childers, great on behalf of the
Good afternoon, may it please the Honorable Court, Kareem Johnson, on behalf of Mr. Franklin, who is now seated to my right.
Clerk, state your name. Thank you. All right, take time for.
It is, Your Honor, and I believe everyone's on the same page, just the record's clear. Our intention today is to call one witness, Mr. Mario Tubbs Smith, and then I believe we'll coordinate with the court for a date to complete the examination, where I expect we may call about 3 remaining witnesses. It shouldn't be too lengthy, but we'll be able to finish that all today.
All right, that's the court's understanding of what we're doing. All right, you may call your first witness.
Thank you, Your Honor. People are called Mario Tubbs Smith. Your Honor, may counsel and I approach very briefly?
Then we have a seat. Yes, you may.
It's good.
Truth help you got. See, state, spell your first and last name for the record, please.
Mario Tubbs Smith.
Thank you. You may inquire.
Sir, can you please spell that? Your first and last name, please.
We gave him a
Thank you. Sir, I guess I'll start with, you are currently, you have pled guilty and have been sentenced in a federal case. Is that correct? Okay. And you pled guilty to what I believe involved, possession with intent to distribute fentanyl as well as a weapons related charge. And that was through the U.S. Attorney's Office at the Eastern District of Michigan. Okay. And you have also entered into agreement with my office, the Washtenaw County Prosecutor's Office. Is that correct? Yeah. And part of that agreement is you cooperating and testifying in these proceedings against Mr. Franklin. Is that correct?
Yeah.
Okay. And the prosecutor's office has agreed that we would give you immunity and not charge you with anything that you may have done after these crimes took place, including accessory after the fact or anything of that. Is that correct? Yeah. And in return to your testifying, the agreement is that the Washtenaw County Prosecutor's Office will convey the nature and extent of your cooperation to federal prosecutors, and there may be a modification of your sentence after the fact. Is that correct? Would it be fair to say that there is no explicit promise from my office, the Washtenaw County Prosecutor's Office, that may be 5 years off, 10 years off, or any specific amount of time that'll be up to the sentencing judge to decide? Is that all correct? And you are testifying here today under that, all of those agreements. Okay. Do you know someone by the name of Daniel Franklin? Is he present in the courtroom here today? Can you tell me what he's wearing? And Your Honor, may the record reflect in court identification of Mr. Franklin?
Without objection, record shall so reflect.
How do you know Mr. Franklin? Okay. And how old are you, sir? 36 years old. And how have you known Mr. Franklin his whole life? He's younger than you? Okay. I'm going to direct your attention to June of 2022. Were you released from prison on, I think it was June 14th of 2022? Okay. At some point after you were released from prison in June of 2022, did you have occasion to be with the defendant, Mr. Franklin? Okay. About how long after you got out of prison was that? Okay. When you, and what was your intention when you go to meet with the defendant, Mr. Franklin, after you got out of prison? Okay. What, if anything, happened when you first saw him after you got out of prison?
In the sugar area, and he tells me, I go raise hands off. Pull up on him. He said we had a girlfriend at that time, so he's like, I got my girl with me. I'm like, all right, that's cool. You know, so I'm like, kid, you know, they like 12, 13.
And so when you went to prison, he was like 12 or 13?
Like 12, 11 or 12.
Okay.
So I pulled up on him. I'm like, you know, I'm gonna take him out to get some keys. So I just pulled up and talked. And he said, basically, like, man, just give me one.
I'm sorry, what was that?
He told me he had just killed somebody.
He told you that he had just killed somebody? Did he, what was your reaction to that?
I mean, honestly, like, I'm from not English, but, you know, but, he just told me, like, he's like, man, I called him, you know. I'm like, all right. So we probably get ready to leave. I look left the bag on the driveway. I look over, he got ski mask on the gun. I'm like, oh, bro, put that down. So yeah, I talked back and forth about it, like, I can't be back.
He said, I can't be what?
Back, I can't be out without it. So he did stuff, so he's like, I can't get out good. I can't go with you. I'm like, man, I can do this and put it in the house and when it got to food.
When were you able, either at this point or some point after, to talk to Mr. Franklin at all in any sort of detail about this murder that he told you he committed?
Yeah.
Okay, tell me about that.
So basically, he said he was on a bike, he was in the village green area, he said he saw the group, recognized me, he went on ski or something like that. He never said his name, he was like, he saw him, so he shot at him one time. I don't think one shot, so that's what he told me at that time.
Okay. He didn't tell you the name when you had that conversation with him?
Like months later or something like that, and saw it was like Sean Longoria or something.
Okay. Did that name Sean Longoria mean anything to you? Did the defendant give you a reason as to why he killed this individual?
We can check his name.
Right.
That person had Sean on his good dog with the show.
So, and what did that mean to you? Like, why would he do that?
I think they some kind of like
Objection, speculation.
well, yes.
Sustained. That's fine. Did he later tell you any more details surrounding that murder?
Yeah, he said, throwing coke in the dumpster, worried about because the detectives had told him they had found coke.
Okay. So he acknowledged you, the detectives had spoken to him at some point? Okay. And it was about a coat that they found? I'm going to jump ahead. And was there a point in time after, and I'm bumping up to 2024, that you had interaction with the defendant again regarding a different homicide?
Yes.
And what can you tell me about that?
He called me, I guess, after, well, he called me after the alleged murder, I think. He said, I think I was working. He decided to do that and referring to like, they did something. And I'm like, oh, what? Tell me, my girl's house in the country meadow. So I'm like, oh, send somebody to come get you. So I send somebody to come get you. And they bring it to me. And tell the story like what happened.
And was this in March of 2024? Okay. When you spoke to him about that murder, what did he tell you?
Like everybody else. But I'm cute. So when he said that name shot. When he said what name said turn. Shot.
Daniel told you that Zoe turned and then Daniel shot her. Okay. And what is your reaction to this at that point?
At that point, the Daniel also told me that who had done on the practice day before they saw the gun, so he didn't know he had done it. He said, just go get him. He shot him and then tell me, I'm like, I said, I'm grew up in the neighborhood full of crime. I've seen murders, I've stepped over, so it's like I'm kind of numb to it, like, man, I'm just afraid to be in that situation. So I'm like, sorry, I'm not guilty. Like, okay. So,
You agreed to help him? Okay. And when you say help him, what did you do?
Vegas, I think, right on tickets.
Okay. So at the time you were on the run related to the offenses which you have now been convicted of, or something along that. Yeah. So you paid for Daniel Franklin to take a Greyhound out to Vegas? Okay. And what else did you do?
I ended up following him up to Vegas, like probably a month later, and I just make sure everything was, take care of vehicles that were ready.
Okay. Do you know if anything happened to the gun that Daniel Franklin used in the homicide of Alonzo Jones Holly, someone you called Zoe?
I believe that, no, I don't. It's picked up when we got it.
Okay. And then we're going to jump, we'll get to that point, but after the murder takes place in March of 2024, what happens to that gun?
I'll take the gun from
Where did you put it? Okay. So you took the gun, stashed it in a place in Toledo, and then at some point sent Daniel Franklin to Las Vegas. Okay. And then you said that you also went to Las Vegas. Okay. At some point, I think in May of 2024, did you and the defendant leave Las Vegas to come back to Michigan? And tell me about that.
I stopped at the apartment in Toledo. And this is firearm back. So come back to Michigan.
Okay. And what, if anything, happened when you guys got back to Michigan?
We pulled up on Harmon, and that was the end of that.
What, that was the end of that? What do you mean? The marshals picked you guys up? Okay. And you were driving that vehicle? Do you know what, if anything, happened to the firearm that Daniel Franklin used in the Sean Longoria homicide, the one in 2022?
Yes. So he would have.
Do you know if he did?
Yeah,
Okay. Do you know what kind of gun that was? Ghost gun? What does that mean to you, ghost gun? Okay. Oh, when you said polymer? Okay, I thought you said polymer. Okay, polymer. Okay, thank you. May I have one moment, Your Honor?
You may.
Just one more quick, well, two more things. Mr. Tubb-Smith, you said that the defendant told you with respect to the Longoria homicide that he fired one shot. Is that a yes? Thank you. Is that because did he tell you any more details about why he only fired one shot? Okay, and this is the polymer ghost gun we're talking about. Okay, and then just so the record's clear, you have an attorney present in the courtroom here today that has worked with the attorney that represented you in your federal case. Is that correct? And you had an opportunity to speak with them before you came out to testify today. Thank you. I have nothing further, Judge. Thank you.
All right, cross-examination.
So, Mr. Todd Smith, you are cooperating with the government to get yourself out of trouble, correct? And in the course of your adult life, you've gotten yourself to a lot of trouble. As a matter of fact, when you caught this current case, federal court, you were what's commonly referred to as an armed career criminal. And you were looking at 3 different mandatory minimum sentences, correct? Well, you were looking at a 5-year mandatory minimum for being in possession of a firearm, correct?
No. 25.
But that was for the cocaine.
Firearm and the drug.
And then a 15-year mandatory minimum. And what was that for? And then a separate 5-year mandatory minimum. And the judge could have ran all those things consecutively or concurrently. Okay. Now, on this particular incident in which you got in trouble, you were driving a car and you got pulled over by Michigan State Police, correct?
Yeah.
And during that traffic stop, after you gave the police your license, you took off and tried to evade the police, correct? You had in your possession 190 grams of cocaine, close to 8 grams of fentanyl, and 33 methamphetamine pills.
Yeah.
And that was on you in the car, correct? You weren't charged federally for the cocaine, right? You weren't charged in state court for the cocaine. You also crashed your car into an elementary school playground while school was in session, forcing the school to go into lockdown. You weren't charged for that in federal court. You were charged for that on the state level. And also, there was a search warrant executed in your home in which police found another 772 grams of cocaine, 165 grams of fentanyl, and then a car registered to your wife, but that you were known to drive, was another 455 grams of methamphetamine. Correct?
Right to the cocaine and fentanyl. They tested what they allegedly thought was methamphetamine, but it wasn't.
Okay. Was the car forfeited by the United States government? Yep. Was the house forfeited by the United States government? Was also $40,000 in cash found in that location, correct? Was the cash forfeited by the United States government? You also had an office in Romulus, Michigan, correct? There was another 10 grams of cocaine, a half gram of fentanyl in that office?
Yeah.
And another pistol, a 9mm Kel-Tec Sub 2000. And this isn't your first federal case, correct? There was another federal case that you had, correct? And a state drug case of 50 to 449 grams of a controlled substance. And these were all the things that the federal court were looking at, and the U.S. Attorney's Office was looking at when they charged you with being an armed career criminal. Now, you entered into a Rule 11 plea agreement, correct? And you looked at it and you signed it. Another one of the things that were found in the home was a press, correct? A drug press. You used that drug press to press up cocaine? Okay. Were you going to use the press to press up cocaine? And the purpose of pressing up the cocaine is to make it look like it came fresh off the brick. And if you make it look like it's fresh off the brick, you can sell it to people in the street as if it's fresh off the brick. Correct? Charge them more money, potentially. Correct? Now, the unique thing about the plea agreement that your attorneys negotiated with the U.S. Attorney's Office and that you signed is that nowhere in this plea agreement does it indicate that you are testifying against your cousin, Daniel Franklin. Correct? So, and you've been to prison before, right? I know they used to call them paperwork parties. They still have those paperwork parties in prison? Yes. And you have to show your paperwork and they check to see if you cooperated against anybody, right? If you cooperated, you guys have to check in or lock up, right?
Not in my experience.
Not in your experience? Okay, and by check in, that means go to protective custody? And by lockup, it means you're not allowed to walk the yard. But the way your paperwork is referenced, if people read your paperwork, they would be able to see that you cooperated in a state case for the government, right? Where would they see that?
It's an easy, once the process is done, it's an easy, type your name in and they can see the paperwork.
But that requires them to check PACER. But the paperwork that you would have, and you're in federal custody now, right? The paperwork that you have right now in federal custody does not indicate that you are currently a cooperating witness for the state.
It will say, you know, basically, because the conversation sheet, what you got sentenced to, not on my judge. So
Right.
sure, don't say it, like you know.
It will if other inmates check. Correct? And in order to get this benefit that you are trying to get, you have to testify to the satisfaction of the Washington County Prosecutor's Office, correct? In order to get the benefit that you want for testifying, you have to testify to the satisfaction of the Washington County Prosecutor's Office. Okay. But it's the Washington County Prosecutor's Office is going to, based on your understanding, call the U.S. Attorney's Office and tell them how well you did or how bad you did. Correct? Okay. Now, you indicated when you last saw Mr. Franklin before you went to prison that he was 13 years old. Right? Okay. How old is he now? Okay. Now, are there any Facebook pictures of you and Mr. Franklin together? Any videos from any family reunions or anything like that? You and Mr. Franklin together? As a matter of fact, you are what we call a major drug trafficker, correct? You was the plug, man, right? I mean, come on. You were the plug. You had an office in Romulus. You had stuff going on in Ypsilanti. You had an apartment and stuff going on in Toledo, Ohio. You were a drug plug, right? Is it some Fifth Amendment reason you don't want to answer that question? I mean, I guess that would be fair, Jan, if he does not want to answer that question. Yeah, it was. Yeah, I'm not asking you to incriminate yourself. And if you don't feel comfortable asking that question, that's fine. Okay. Did you ever supply Mr. Franklin with drugs to sell? So it's fair to say that y'all wouldn't do drug business together, but it's your testimony that he confessed committing 2 murders to you. And it's fair to say on this September 22nd day, you weren't present. June 22nd, 2022, you weren't present when that occurred. And when this incident happened over the vape, you weren't present when that occurred. Okay. And it's your testimony that he told you that somebody that he knew had a gun on him at least a couple days prior, threatened to kill him, and then turns toward him in a car. Did you see anything about any of these 2 alleged killings on social media? You weren't aware that they were talking about this on social media, or you just didn't see it? Oh, yeah, no further questions.
You redirect. Just 2 brief questions. Mr. Tubb-Smith, when the police raided your home, was anyone present with you when they came in when you had the drugs and guns that Mr. Johnson mentioned?
Yeah, they wouldn't give me the time, you know. My wife was actually, she had to, she really wanted to, that.
Okay. But the defendant, Daniel Franklin, was living with you when they executed that search warrant?
Yeah.
Okay. And the gun that was used in the Zoe or the Alonzo Jones Holly homicide, was there anything unique or specific about that gun?
Yeah. 1.5 caliber Glock, converted over, a clear clip in it, a lot of those bands.
Okay. Converted over? Is that like a switch? Okay. So it had a Glock switch on it? I have nothing further, Judge.
Let's put him. All right, this witness may step down.
Yes.
Having completed the one witness, you might have to deal with Mr. Johnson's. Does the 11th work for you, counsel? You got your book down, so.
We're not making it any easier on him because you gave him another case.
I didn't give him anything. He took it.
It does not, but does the fourth, well, would that be an afternoon?
The 11th. This afternoon. Yeah, I can put it. The afternoon works better for you.
Yes, sir.
Yeah. That's a Tuesday, right?
Monday.
That's a Monday. Okay, so we'll put it at, how soon can you, if I put it at 1 or noon?
But at 1, I'll be here at 1.
At 1, okay.
But I may be a little late.
All right, then here's what I'm gonna do, 12:30. No. All right. So we'll continue the preliminary examination, August 11, 2025, and I'll just put 1 o'clock. All right.
Thank you, Your Honor. Thank you for accommodating the scheduling.
Not a problem. Bond will continue as to now. Thank you. Just gonna go. 4. I'm all right. 1. I'm okay. Court does call the case of People State of Michigan versus Renee Dummel.
Good afternoon, Your Honor. We're representing people.
Good afternoon, Judge Patrick 9 P 7633. And Mr. Thomas is present. Please answer.
All right. We ready to conduct a preliminary examination?
Yes, Judge.
Yes, Your Honor. People are ready to proceed. May I call my first witness?
You may.
People call 9 Montford.
And please come forward and be sworn.
Raise your right hand. You solemnly swear to affirm the testimony you're about to give the truth, the whole truth, and nothing but the truth, so help you God. Spell your first and last name for the record, please.
May I inquire?
Good afternoon, Ms. Montford. How are you? Okay. My name is Lauren. We spoke earlier today, right? You are going to see a red light in front of you. That's a microphone, but it's not going to make your voice louder, but it is recording. So I'm going to need an audible answer. Yes, no, try to avoid shaking your head. Okay. Ms. Montford, how old are you?
I'm 20 as of March 26th of this year.
Okay. Are you familiar with the defendant, Ranid Gamel?
Yes, I am.
Okay. And do you see him present in the courtroom today? Can you tell me where he is sitting and an article of clothing he is wearing?
He's sitting right there and he's wearing a lightly padded button down.
Judge will stipulate to that application.
Record shows so reflect
Thank you.
application.
How did you first meet the defendant?
So my grandparents had been getting their internet service from Radio Shack, which is the shop that we was installing for a couple of years. And my grandma called me because I was in search of a job and she was up at his shop getting something fixed or whatever, and she called me and said I had a job. And she said that I could come in that day for him. And came to Radio Shack for extremely professional. But that was my first time.
Okay. And do you remember what that date was?
It was September 23rd, 2024.
Okay. And you said that that Radio Shack was in Saline?
Yes.
And is that in Washtenaw County? Okay. And so you went up to the Radio Shack on the 23rd?
Yes.
Okay, what happened when you got there?
So I got there and he sat me down at a little desk that's in the main area.
Sorry, when you say he, are you talking about the defendant?
Yes.
Okay,
I don't remember like the specific interview questions. I just remember that it like seemed fake because there was no documentation or anything for me to sign and nothing. He just asked me a few questions and it's like, okay, make the job. I basically just got the documents in my.
okay. And so what happened after that?
After that, we did a quick walk around the shop so that I could just get like a really quick feel of like what was there and kind of what I would be doing there. He showed me the back office. He showed me like where the bathroom was in the back office, and then we were coming out, and he complimented my outfit, and then he grabbed my hand and asked me to do a spin for him to show him my outfit.
Okay. That was after the interview took place?
Yes.
Okay. Did he say anything else to you?
No.
Okay. What did you do next? Okay. And did you start work at Radio Shack?
Yeah, the very next day.
Okay. So tell me about what happened that day.
I got there on time. He was like an hour late, so I got in there. I don't remember what time it was. Really long. I already told him that I was there. We decided, my mom and we decided to go back home, and then he called and was like, okay, I'm here now, sorry, you can come now. So I went back there, and he started showing me things around the store again, just getting even more feel of what I would be doing. He said that I would be an assistant manager there. And so
When this was happening tonight, was anyone else present in the store? Okay. Was it open?
Yes.
Okay. Okay, so what happened after that?
He was showing me things on the computer for like what I would be doing. He was helping me set up my account for. I had to make a new Google account for whatever I would be doing. He was showing me what to do on the computer and stuff. And then I can't remember if this was before or after, but he was like, he needed me to go get change. And there wasn't enough change in the register. And before after I got the change in customer, I came and I checked him out, and that's when he was like, "Oh, we need more coins." And then gave me I think a $50 bill, and I went to the gas station nearby to get change, and he said I could put like a chip and a drink. So I did that too, and I came back. And
What happened when you got back?
when I got back, he was showing me another thing to do on the computer, and or I'm sorry, before that happened, he asked me if I wanted to hit his cart, which is a weed pen, and I said yes, which I shouldn't have, and I did it, and I called it. That was actually before I went to the gas station. That was before I had walked to the gas station and did that, and then I came back and he showed me the things on the computer and how to do it and whatever, and he was like, "Okay, like, do you understand?" And I was like, "Yes," and then that was when he reached behind me and put his hand on my hip and butt and was rubbing it while saying, "You're such a good girl. Like, thank you for being so good."
Okay. I'm gonna follow up with a couple more details about that, okay? Where were you in the store when this happened?
So when you first walk into the store, there's a little like triangle table right here. I was standing, sorry, he was sitting, and I was standing right next to him, watching him do whatever. And that was when we reached over.
Okay.
Right in front.
Okay. And do you remember what side of him you were standing on? Okay. Okay. And you said that after you said you understood, he reached his hand, and where did he touch you first?
He touched my right butt cheek and hip.
Okay. And you said, what did you say that he said to you?
He said, "You're being such a good girl. Thank you for being such a good girl."
What did you do at that point?
I kind of just froze and like nervous laughed it off because I wasn't expecting it. And I was uncomfortable and I didn't really know how to react because he was my boss.
What do you remember happened next?
If I'm being completely honest, like I don't really remember. I think I just went back.
Judge, I'm objecting to speculation. She doesn't remember. She just thinks.
I'm gonna let her finish your answer.
Thank you.
Objections noted. Go ahead.
What do you remember next happening?
The next thing that I remember is just going back to the little desk where I was at. There's the triangle desk when you first walk in, and then adjacent to that is another desk with another computer and a register. I went back over there to do things. I was learning on the computer. I was learning like the different things that I would be trying to sell to people and stuff.
Okay. And what happened after that?
I don't remember.
Did he say anything else to you that day?
He said he had to leave to go to, I think it was one of his other businesses, because he had other businesses. He said, do you think you're okay to wash your store because I have to go like handle something? And then I was like, yeah, and probably like 30 minutes later, he left. And then I was by myself until I closed the store.
What did you do after you closed the store?
Before I closed the store was about to close. My friend came to let me know that he was there because he was picking me up from work that day. I set the alarm.
When the defendant touched your butt cheek and your hip, was that the only time he touched your body?
Other than when he like grabbed my hand to like have me do a little spin for him to say yes.
Okay. So after you locked up, did you go home?
Yes.
Okay. Did you tell anyone what happened?
Yeah, I told my mom, but I didn't tell her right away. I told her like a few hours afterwards because I was not if I should tell anyone.
Okay. So what did you do after you told your mom?
After I told my mom, I went to sleep, and then the next morning, we went to the police station to tell the police officer that we needed to escort to his shop to get him his key back because we didn't want to.
Okay. At that point, did you tell a police officer what happened?
Yeah, after we dropped the key off at his shop, we went back to the police station, called the police officer, and filed a report.
No further questions, Your Honor. Thank you.
Yeah, Judge.
Cross-examination.
It's Miss Monford? Thank you. So the first time you met Mr. Gamo was the 23rd. You have to say yes or no. Okay, thank you very much, Ms. Monford. So after you met him on the 23rd at a job interview type thing, and he showed you around the Radio Shack. And at that time, he had you spin around or something?
Yes.
Okay. And did he say you were dressed too professionally or anything like that? Was there any other?
He said that I looked good.
Okay. So he didn't tell you you were dressed too nice or anything like that? Okay. And so then after that, everything seems, you end up leaving. How do you get home that day?
Which day?
The 23rd, I'm sorry.
The 23rd, I left perfectly normal.
Right, but I'm just saying, did your mom come pick you up or was it your friend again? Okay. You tell her that you had to spin around? Okay.
I didn't register as it.
Okay. No, I get it. I'm just asking questions. So, and then so the next day you go there in the morning.
Yes.
Thank you. You're gonna be great at this. And you call Mr. Gamo.
Yes.
And he informs you he's running late. And then don't you have to drop your sister or somebody off at school?
No.
Okay, so you just went home. Okay, and you chilled at home until I guess Mr. Gamo called you. Okay. Do you remember how long that was?
No.
Okay. Don't tell me where you live, but how long does it take you to get from the Radio Shack to your house? Okay, so you're at home, and then at some point, Mr. Gamo calls you
Yes.
and says, "I'm here. You can come back."
Yes.
And do you remember what time you got back there?
No.
Your mom took you again?
Yes.
Okay, thank you. And you get there, and you learn that he's basically hired you to be the assistant manager.
Yes.
Okay. And you said earlier you probably got the job because he knew your grandparents really well.
Yes.
Okay. And then he was showing you things on the computer, but you also said something about how you had to make a new Google account. Did Mr. Gamo instruct you to make a new Google account, or is that for your own personal use? Okay. And what was that for, if you know or remember?
It was for my assistant manager position. So
with that position, he wanted me to also make social media for it because his.
Okay. No, it was like for a work related thing.
Yes.
And like to get like work related emails and connect to social networking sites. Okay, thank you. And then at some point you said he asked if you wanted to hit his vape or cart. Okay, and can you just describe that vape or cart to me so I can understand what it is?
It's a weed.
Okay, so what color was it? Blue. What brand was it? Okay, and you're sure that was a THC and not like a CBD or something like that? Okay, what makes you so sure it was a THC one? Okay. Thank you. And so at that time, so after you do that, you feel a little, would you say high? Okay. And then he asked you to go take $50 to get change from the gas station.
$50 exactly to take out, but that was the amount that he gave me. But that wasn't the amount that I used.
Okay, so how much did you use?
Sure.
Okay, but you ended up going to the gas station, getting some chips and a drink and some change.
Yes.
Like small bills?
No. Quarters and dimes.
Okay, so you got a bunch of quarters, nickels, and dimes, and you brought some change back as well?
That was quarters and dimes was the change that I brought back for the cash.
Right. I'm just trying to understand. So, okay, so you got change, but I thought you got one like smaller bills. That's why I was asking. Thank you. I started working in a restaurant, so we had to break $100 bill. So I just want to make sure. And that's after he starts showing you more things on the computer.
Yes.
What was he showing you on the computer?
He was showing me how to, it was a licensing called Laura. He was showing me how to basically make somebody, sorry, it's hard to explain.
Just try it. If you can't explain it, just say I can't.
It's hard to put this into words. Basically, how he was doing it is he was showing me how to make someone a business owner so that their Wi-Fi was, you get a better deal on your Wi-Fi if you're considered business.
Oh, okay. Okay, so you know how to help people make their own businesses and put their Wi-Fi or whatever under their business's name. Thank you. I explained it great. And he's showing you things on the computer, and you're standing next to him, right? And he is. So you're standing next to him on his right.
Yes.
And what is he doing stuff on the computer at that time?
Yeah.
Is he using a mouse?
Yes.
Okay, where's the mouse on the? Okay, was he using his right hand for the mouse, left hand for the mouse? Okay, and at some point you just said he put his hand around you and put it on your hip and butt and started rubbing.
He wasn't at some point.
But when was it?
After he had finished showing me how to do everything, he turned to me and asked me if I understood. I said yes. Then he reached over and put his hands on me.
Okay, so how did he? I'm just asking. Was he sitting on a chair that swivels? Did he swivel the chair? So he swiveled the chair and started facing you.
Yes.
And you're facing him.
Yes.
And he put his right hand out.
Yes.
And reached around you and put it on your left hip and butt cheek.
No, right.
Okay. So like just like he stuck his hand out from where he was sitting and could touch you. No, that would be your left side. Okay.
You're being such a good girl. Thank you for being such a good girl.
Okay. And for the record, you put her arm out, her right arm out around and was moving up and down. Is that accurate?
I'm giving a representation.
Yeah. Okay, thank you. I'm just trying to make sure I describe it well. And at that time, that's the only time he touched your butt and hip.
Yes.
Okay. And then your friend showed up to drive you home. Did you talk to your friend about this at all?
Not until a few days later.
Okay. So I guess, can you give me your friend's name who picked you up? Because I want to know what he said, what you told him. So can you tell me what you told him? What his name is?
Do you need to have that information?
Yes. Can you tell me what his name is?
Can you tell me why?
No. What's his name?
So it's okay. It's all right. I understand why you don't want to do it, but if you would, please.
And does David have a last name? Heart? Okay.
All right. You all right?
Yeah.
If you're not, we can take a break. I'll let you. You all right? Okay.
Okay. So you told, I'm not saying this anymore. You told your friend a couple days later.
Yes.
But that's after you told your mom,
Yes.
after you dropped off the key,
Yes.
and after you talked to the police.
Yes.
Okay. Nothing further, Judge. Thank you very much.
Can you redirect?
Just a few questions. Just a few questions. We're almost done. Okay. So the way that you demonstrated, was he moving his hand on your body? Okay.
Not so far up, but like he's moving his wrist to like caress.
Okay. Caress what part of your body? How long do you think that lasted?
A few seconds, like no more than 10 seconds.
Okay. And while he was doing that, was he making the comment about the good girl comments?
Yes.
No further questions, Your Honor. Thank you.
No follow-ups, Judge. I said no follow-ups.
Okay, well, I just have a couple. I just want to, you all right? All right.
I'm just.
Okay, listen.
Okay.
All right, I know you are. Okay. I do it every day and sometimes it overwhelms me. So you're in good shape and you did a good job. Okay. I just want, on the day that this happened, was it September 24th?
Yes.
Okay. How old were you at that time?
I was 19.
And were you still in school at that time? Or?
No.
I'm sorry.
I went to beauty school.
Okay, so you had graduated already. Okay. And just also so I'm clear about one other thing. You meet with him on the 23rd. This happened on the 24th. You get a ride home, and at some point you tell your mother. Okay. Now, and again, I just want to make sure I'm clear on this. You said what you testified to was not right away, and that's always relative, right? So do you remember what time you got home? No? Okay. Was it more toward the evening time?
Yes.
Okay.
The shop closed at 7.
Okay, great. So the shop closed at 7. Ultimately, you get home, say around 7:38? 8? Okay, you get home. And then what you said is you didn't tell your mom right away, but a few hours later. No, go ahead.
I told her probably like an hour after. I didn't mean to say I meant when I said a few hours later, as in like a few hours after.
Got it. Okay, that's what I was trying to clear up. So you get home, and so you get home about 8. You probably told your mom by 9. That's what I wanted to know. Come the next day, you don't go right to the shop. You go to the police station. And because you didn't want to, you and your mom had decided that go ahead. No, you tell me. I'm sorry.
And I was like, I was in and just keep working with her because everyone wanted a job at the time, and she told me I was allowed to. So she made that decision that I wasn't allowed to work there, and then we were going to the police to have them escort us to return the key and revive it.
Got it. Okay. So all of that transpires after you have your conversation with your mom, right? And suffice it to say, you're 19, you think you know what you want to do, but mama kind of overruled some stuff. Yeah. Okay, that's okay. That's why they're there sometimes for us, right? Okay. And so then you do that. So I guess my point to this whole thing is, after you left the date on the 24th when this happened, you never went back to work there again.
No.
All right. Thank you. Any questions based on the court's questions?
Not from the questions, thank you.
All right, young lady, you did a great job, and I'm never wrong, so you did good. All right. Okay, you may step down. Any additional witnesses for the people?
Nothing for the people, Your Honor.
Any witnesses for the defense?
No, Judge, thank you.
You have a motion.
I do, Your Honor. I am moving for bind over on count 1, criminal sexual conduct in the 4th degree. Mrs. Monford very clearly testified that she went in for some kind of job interview with the defendant, and at some point he grabbed her hand and twirled her around and complimented her outfit. The next day, when he was showing her around the shop, he had an opportunity to get close to her. He put his arm around her, touched her hip, and she very clearly stated that he grabbed her and rubbed her right butt cheek. She was, certainly in a position where she was alone in a store with someone who was her boss. She eventually went home, told her mom, and then the next day, they went to the police station to return the key, and she reported at that point. I believe that I have shown by probable cause that CSE in the 4th degree and will provide over.
I'll object to that argument.
All right. Court, after hearing the testimony in the case and looking at all of the elements of the offense, I'm going to say this. I hear a lot of witnesses. And I'm going to say Ms. Mountford was one of the most credible witnesses I have ever heard. What she knew, she said. What she didn't know, she didn't say it. She didn't try to exaggerate. She didn't try to guess about something. She said exactly what had happened. And also the court believes that she is exceedingly credible because while mom had to intervene, I guess, to have her make the right decision, one of the things is this occurs, she tells her mom an hour after she gets home. And then whatever that discussion may have been, she never goes back. And I think that, well, doesn't go back, but then goes to the police station, reports it, gets a key return, and then files the report. I just find her testimony very credible and would find that the people have indeed sustained their burden and would find the defendant over to stand trial on this count.
Thank you, Judge.
As to the arraignment on
Judge,
the
waive the formal reading of arraignment and ask the owner to plead not guilty on Mr. Gomez's behalf.
defendant having waived formal reading, pleading not guilty, court will enter that plea. Pre-trial in this matter will be set for
October 1st at 1:30 with Judge Conlon.
October 1st, 2025, 1:30 before Judge Conlon. Counsel approach, please.
Yeah.
All right, we're back on the record in the Gammo matter. The court, in talking with counsel, what I'm going to do is I'll continue defendant's bond as it is. However, defendant will report to community corrections within the next 24 hours for placement on a tether. There'll be an exclusion zone. The people will provide the address of the exclusion zone, but it will also be location tracking.
Thank you, Judge.
Thank you. Yeah, but how many witnesses? How many witnesses are you expecting? We're all set.
Okay.
Which witnesses are on the white matter?
I'm sorry?
On white? Is that yours?
It is.
Okay, how many witnesses are you expecting?
Just one.
Just one? Okay. Folks, give me about 10 minutes. Take a little break, come back. I will get everybody in home in time for like a late movie or something.
All rise.
That wasn't. That's okay. That's okay. No.
14A District Court for County of Washington, State of Michigan. I'd like to session the Honorable Judge Jason.
You may be seated. That's called the case of the people versus Mark White.
David Knopf, on behalf of the defendant.
All right. Reach that preliminary examination. Are we ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
All right, go ahead.
People call Mariah Hamill.
All right. And please come forward and be sworn.
Solemnly swear in front of the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. See, say, spell your first and last name for the record, please.
Mariah Hamill, MORIYAHHAMELL.
Good afternoon, Ms. Hamill. How are you? Could be better. Okay. My name is Laura and we spoke earlier today, right? I understand that you are pregnant. Okay. And when are you due?
5 days.
5 days from now?
Excuse me?
Okay.
5 days? Okay, so listen, if you need a break, all right, you don't even have to ask. You just wave your hand up. We'll take care of it. Go ahead.
Okay. I'm sure that you heard me previously say this, but there is a red light in front of you. That's a microphone. It's not going to amplify your voice, but we are recording. So just try to, I don't think you're gonna have a problem keeping your voice up, but we do need an audible answer. So no head shaking or things like that. Okay. Ms. Hamill, how old are you?
I'm 23.
23. Okay. Are you familiar with the defendant, Mark White?
Yes.
Okay. And do you see him present in the courtroom?
Yes.
Okay. Can you tell me an article of clothing he is wearing and where he is sitting?
He's wearing a suit.
Okay. Your Honor, may the record reflect that the witness has identified the defendant.
Record shall so reflect.
When did you first meet the defendant?
I met my 10th grade year, my sophomore year of high school. I was women's basketball, and he was the men's coach. And I kind of always wanted to. I see myself in basketball. So I did as much training as I could to get there, and I knew that he had a record of being a good basketball coach. So I kind of, like, bumped into him and asked him if I was able to work out with him and be a part of that community. So I was able to play at a level that we did.
Okay. What high school was this?
River Rouge High School.
Okay. What city is that in?
River Rouge, Michigan.
Okay. And you said that you played on the women's team. This was your sophomore year.
Yes.
Okay. How old were you?
16 at the time.
16. Okay. And he was the coach of the men's basketball team?
The head coach.
Okay. So when you asked him, if you could train with him, what happened next?
I can't remember too much about the conversation that we had, but I know that it was us just kind of introducing ourselves to each other and letting us know what we were both expecting. And ever since then, like, it's been allowed to work out with him and the guys.
Okay. How often would that happen? Would you work out with them?
I can't count how many times, but it was a good amount of times for me to get to where I wanted to be.
Okay. And how would you describe your relationship with the defendant?
Honestly, at first, I don't have let me backtrack. I don't have the best relationship with my dad. And he was basically like a second father figure for me. So
The defendant?
yeah.
Okay. And did that happen over time? Like, you became closer?
Yeah, we gradually, the more we started working together, the more the better our relationship was.
Okay. Would you spend time with the defendant outside of playing basketball?
Yes.
Okay.
It's been times we go to college basketball games. He has a son that also went to the high school that we went to. Went to go see him play, went to go see another few players play, maybe went out to eat or something. I was pretty close with him and his family.
Okay. And who was part of his family? You said he had a son?
His wife, his sons, and he had a daughter too.
Okay. How many sons do you have?
4 that I know of.
Okay. Ms. Hamel, what brings you to court today to testify?
I've been sexually assaulted by him, and I'm just here to get justice for myself and possibly.
Okay. Now, can you tell me about when this happened?
This happened my sophomore year. I was 16 years old. Again, you want me to tell you like the specific?
Yeah. What was the situation? What were you doing that day?
Well, it was a weekend. I believe it was a weekend that it happened over. So that situation. We have gone out and I went back to his house with them. We basically had a family dinner, family time. We were, talking, watching TV, sports and stuff. And I remember that particular weekend we went to go see one of his previous players play at a college that the player was playing at, and we ended up coming back to the house.
And were you, you say went back to the house, do you mean defendant's house?
Yes, my house.
Okay. And do you remember what city that's in?
It's Atlanta.
Okay. Is that in Washtenaw County?
Yes.
Okay. And were you staying over at the house?
Yes.
Okay. So what happened after you went to the game, came back?
Came back with whatever family activities, watched TV, ate, and we prepared for that.
Okay. And what kind of house was this? Was it 1-story, 2-story?
It was 2.
Okay. And where were you staying?
I was staying upstairs in the upstairs.
Okay. And by yourself in that room?
Yes.
Okay. What do you remember next?
As we were preparing for bed, I remember me gathering my things and taking it upstairs to the guest bedroom. And I was kind of, setting myself out to get comfortable, to get ready for bed and everything. And then I remember him coming in and checking in on me to make sure that I was okay. And after that, like it was he going to sleep. I don't know what he did after that, but I recall leaving the sleep.
What do you remember next?
That following morning, I just remember him being in a room and I kind of like was squinting with one eye open because I felt him with his mouth on my chest. And I didn't want him to notice that I was up and aware of what he was doing up until I could get out of the position that I was in. But I was stunned by what he was doing. And he, at that point, noticed that I was up and aware of what he was doing. He proceeded to ask me if I felt uncomfortable and if he could possibly touch and taste my vagina.
Okay, I'm gonna ask you a couple clarifying questions, okay? You said you woke up and his mouth was on your chest?
Yes.
Okay, where was his mouth?
On my right boob.
Okay. And had you gone to sleep with clothes on?
Yes.
Okay. Okay, what were you wearing on top? Do you remember?
I can't remember the specifics.
Okay.
But I have an household.
And when his mouth was on your right boob, you said was that on your clothes or your skin or something else?
It was he had pulled my full boob out.
Okay.
Proceeded to. But yes.
And you said that after he noticed that you were awake, what did he ask you?
He asked me if I was uncomfortable and was okay with him doing what he was doing. I told him no, but then he proceeded to ask me if he could touch my vagina and taste it.
Okay. What did you say to him?
I told him that I was uncomfortable.
When you woke up and his mouth was on your breast, where was he? Where was his body? Was he sitting, lying down, something else?
So I was laying on the right side of the bed and he was kind of like staying over me in a way. He was hovered over me.
Okay. So was his was he on the bed?
No, I want to say he was kneeled down to like my level, but he was hovered over.
Okay. After you said no and that you were uncomfortable, what happened next?
I kind of don't remember too much after that, but I do want to say that after that happened and we exchanged that I was uncomfortable, we acknowledged that I was uncomfortable. I proceeded to gather my things. I was heading home.
How did you get home that day?
I want to say him and his family job.
After this happened, did you tell anyone?
No, because by that time I was capable of talking about the situation. There was a rumor going around the school saying that he had sex.
Okay. So when was the first time that you disclosed or you told someone what happened?
I never told anyone until I was going away from the environment. So I was already in college by the time I was.
Okay. Did you eventually report what happened to you to police?
I didn't report it until last year.
Last year, okay. And Ms. Hamill, when is your birthday?
August 22nd,
And what year?
2001.
2000. Okay. So you were 16 years old. So you would estimate that this happened in 2017?
Yes.
Okay. Do you know what time of year it was?
It was the beginning of basketball season, so possibly fall.
Okay. What made you decide to tell the police what happened?
There was
Without saying what someone else might have told you.
There was an article that I seen of them possibly having other victims and possibly those victims coming to testify against them. Kind of did my own research and found out that the victim who was going to testify against them took back her allegations. And I kind of just, took it upon myself to tell my story, like, get it out there, get justice.
Thank you. No further questions.
Cross-examine.
Hi. We haven't met before. I'm David Knox, and I represent the defendant. This is your third child? Second child? Well, congratulations. You told the police this happened at 8272 Blue Jay, correct? And under oath today, you're sure it happened at 8272 Blue Jay, correct? There is zero doubt in your mind about that. You are as confident that this occurred at 8272 Blue Jay as you are that it occurred, right? And we know it was 2017 because you were coming back from the Lewiston-Wayne State game in Illinois, correct? And in 2018, the Lewiston-Wayne State game was in Detroit. In 2017, it was in Illinois. And that comports with your memory, right? So you don't need me to show you the schedule to prove that the Lewiston-Wayne State game in Illinois was in 2017 because that's your memory, right? And so it was 2017 and it was on Blue Jay, and those facts are as solid in your mind and in your testimony as the fact that he put his mouth on your breast, correct? Okay. You knew his son, that he went to high school with you. And you had friends in common, right?
Teammate. We were boys, basketball team, girls basketball team, but I wouldn't consider friends.
Okay. Acquaintances. Isn't it the case that you first met Mark through his son? Through the other basketball players rather than through some sort of him being a coach? You sure? Okay. And how many TikTok followers do you have? Please answer the question.
You'll need to answer the question, ma'am.
$4,000.
Okay. And you have put your discussion about these allegations on TikTok, right? And before you did that, you brought a lawsuit in Wayne County Circuit Court against my client. But you sued in Wayne County Circuit Court, right? You say you attempted to, but the suit was filed.
Not under my reconciliation.
I don't know what that word means in this context. So you're saying that Renata, your lawyer, just filed suit without telling you?
We talked, but she never discussed that. She filed it.
You know for a fact it was filed, right?
No.
And that it then was removed to federal court?
No, I don't.
So you're saying that you haven't read what's in the complaint?
No, she went completely AWOL on me, so I didn't get any clarification of what was happening with that suit.
And you talked about her on TikTok, right?
I didn't name her, but I basically said that, yeah, she went AWOL.
Okay. So the civil suit has been dismissed, right?
I have no idea.
Okay. And you said at one point that you told some sort of teacher at River Rouge or Summit somewhere about what happened?
No.
And that person told Mr. White, not Mark White, but another White, the principal? You never said that? Okay. Did you ever say that the reason why you didn't go to the police was because you had transportation issues? Okay. And you have said that after he assaulted you, you never went back to that house again, correct? And you're confident of that, right?
Yeah.
And you certainly had nothing to do with him after he assaulted you, right?
After that, I think the only time that I communicated with him was when I was signing my national letter of intent. He asked me to include him in my commitment statement.
You didn't ask him for money for high school graduation? He didn't send you any money on Cash App?
He sent me money because he was trying to make me feel better about what happened.
So you did take money from him on Cash App?
Yes.
Hadn't he helped you before this alleged incident?
That doesn't make what he did okay.
I'm just asking a question. Had he helped you before the alleged incident?
Yeah.
And his whole family helped you, right?
No.
Just Mark?
Yes.
Okay. But his family was, you knew them. You didn't just know him.
Right.
You knew his wife.
Correct.
Okay. And I don't mean to be repetitive, but just one final time. You're as confident that it occurred at the Blue Jay address and that it occurred in 2017, that it occurred at all, correct?
Sustained.
Fine. Can you explain? Is it possible you're wrong about that? The Blue Jay address?
I know that they had just moved into a house.
Okay. And you're confident it was 2017?
Yes.
Okay. Public records are self-authenticating. May I approach the witness?
You may.
Can you explain how you could have been at Blue Jay if you didn't buy the house in 2017, if you didn't buy the house on Blue Jay till 2018?
My recollection of that incident is was a lot. All I knew is that the house that happened at was so for you to infer that it was 2018, then that's when it happened because it was a new house. I know that for a fact.
Nothing further. Thank you.
You may adjourn.
Just have a moment, Your Honor.
You may. You have no further? Okay.
For the record, this was not admitted though. This,
Correct.
I'd like to move its submission.
Your Honor, there's been,
It's self-authenticated. Rule 901. MRE 901.
Go ahead and finish your statement.
I guess it's self-authenticating, but this is like unclear what this is, like where would it come from? It's like not a hard copy. I've never seen it before, just right now.
I'm trying to admit the bill of sale, which is not a public record, which is dated September 19th, 2018. We'll save that for trial or for a motion to quash.
I don't know what that means. I mean, what are you trying to tell me? There's the bill of sale. I don't really care about, but all this is.
To register the deed.
Mr. Knott, would you quit talking?
Sorry.
Where is the bill of sale?
I have a bill of sale separately, but it was not a public record, so I didn't try to get it in through this witness.
Regardless of if it's self-authenticating or not, there's been absolutely zero foundation laid for this as far as, I mean, literally zero. It certainly can't come in through this witness. And
Well, I'm trying to figure out, all this tells me, I guess the parties would agree that, accept this, all this tells me is that the purchase of the property occurred, or the conveyance occurred September 19, 2018. That's all it tells me. Am I right?
Agreed.
Yes, Your Honor.
It doesn't tell me who occupied the premises prior to this conveyance.
It says it won't. It does not. I agree.
No,
I
listen
agree
to
with
what
Your
I'm,
Honor.
listen to what I'm saying. The conveyance of the property happens in 2018. But it doesn't tell me who occupied the premises in 2017 or prior to that 2018 date. Right?
I don't disagree.
So, to the extent regarding her testimony, what relevance then does this have for this case, I guess?
The relevance. Should I go to the
Go ahead,
podium?
wherever you want.
Your Honor, the witness was crystal clear. It happened at the Blue Jay address in 2017. I drove you crazy asking him multiple times precisely to establish the point. And we also know the basketball game that she was coming back from Illinois to the basketball game and staying at his house as compared to her own house in Ecorse, where she was living with family, because she was coming from Illinois. So it's consistent with her testimony as compared to in 2018, when the Wayne State Lewiston game was in Detroit. She wouldn't have come out to the home in Ypsilanti. So she claims this event occurred in 2017. I think there's no evidence, none, that my client was present in 2017 at that property, other than her kind of hope.
No, the only testimony, Mr. Knott, that I currently have is her indicating that he's at that address. What you're trying to establish is that the purchase of that property, the conveyance of that property occurred in 2018. Ergo, what I'm to conclude from that is that her testimony could not be true. But what I'm saying is, it seems to me that both could be true.
I hear you. I'm not denying what you're saying, Your Honor. I just think that it's not likely, it's not probable. There is no probable cause that a sexual assault occurred in 2017 at Blue Jay, because it is not probable that my client was there.
Hold on a second. Her testimony would be, or is that this occurred in 2017 there. Now, if I accept this document and what you're trying to draw from it, that he did not, that the property was not conveyed until 2018, then it seems to me at best what I come up with is a question of fact that I can't resolve, not with this.
It would be a question of fact as to whether it was 2017 or 2018.
Well, that could be, or, but I mean, her testimony is 2017, right? But it could be a question of fact as to whether or not he was present at that address.
And my point is that that question of fact, well, conceivable, it's not plausible, it's certainly not probable. It is certainly not sufficient.
What if, hold on a second. What if I'm renting the property and then in 2018 I purchase? Then theoretically, it could be true.
I don't disagree.
What if there was a land contract? So there would be questions that I can't answer at this stage. You're looking for me to resolve that in favor of your client. I'm listening to her testimony. You may not believe it and say that it's all wrong, or that she has the wrong date, or she has the wrong location. You're trying to show me something like that. Okay. It seems to me that I have a question of fact as to where it occurred, because I have a witness saying that it occurred at this address. I have something that you're saying says that he did not, that property was not conveyed to him and his wife until 2008. It does not necessarily show what you're intending or what you're arguing it shows. And that is that he could not have been present at that address. For precisely what I said, he could have rented it. For all I know, there's a land contract that underlies this. I have no way of knowing. I have the piece, a piece of a real estate transaction. And I don't know that that's for me to decide that ultimate question here at this stage of a criminal proceeding. Go ahead.
I don't disagree with your point that it's possible. I'm not claiming it's based on what I've provided you. I'm not claiming that I have proven conclusively that it's impossible. I'm not saying that. I'm just saying that under the burdens of credibility and probable cause, that even though it absolutely weighs in favor of if someone says something which could be true, then you don't resolve reasonable doubt. You don't resolve that at this stage. You let it go forward. But it has to be probable. And it must be the probable cause.
Where's your case law on that?
The probable cause standard, the Cleveland standard has adopted the probable cause standard. I have no further
questions. Yes, you may be excused. You can step down.
So, it goes way back to people. It starts with People versus Asta, 337 Mich 590, 1953. The matter of probable cause, as the expression is used in the statute, has reference to the connection of the defendants with the alleged offense, rather than to the corpus delicti, that is the fact that the crime has been committed by the same persons. The basic query, according to People v. King, 412-145, pin site pages 156-57 from 1981, turning to an assessment of whether the crime charge has been committed. The basic query is whether competent evidence has been presented on which to base a finding that the crime charged or some included offense has been committed. More recently, there's lots of sort of discussion about this. It's kind of interesting about credibility in particular. People versus Polly, which then was cited by King. The court has held that during a preliminary examination, this is page 627 of People versus PAILLE, the magistrate not only has the right, but also the duty to pass judgment not only on the weight and competency of the evidence, but also on the credibility of the witnesses. The prosecutor argued in Yost, 468 Mich at 128, to adopt the standard from Lennon, 456 Mich 625, limiting a judge's authority to assess witnesses' credibility for a motion of a new trial in the context of preliminary exams. Specifically, the prosecutor argues that a magistrate must accept the veracity of testimony offered at a preliminary exam unless the testimony was so far impeached that it was deprived of all probative value, or that the jury could not believe it, or the testimony contradicted indisputable physical facts or defied physical realities. We respectfully decline the prosecutor's invitation to incorporate the Lemon Standard into preliminary examinations. The Supreme Court has rejected that incredibly tough standard. The Supreme Court in Yost, 468 Mich 128, 129, says you have to evaluate credibility. And in light of what I've shown you, they're not there. This did not probably occur. This is 8 years ago.
Keep changing words. If I'm looking at her credibility, I believe her. Now what do you do with that?
I put it to the side and I say, and I suggest that that would be an incorrect assessment based upon the fact that there are surrounding circumstances, such as the civil suits and the TikTok, and the fact that she knew.
I don't have any of that before me.
Well, she admitted to those
What she says is that she had an attorney that went rogue. I have nothing other than that. She has given an explanation of that.
So
there are attorneys that do go rogue.
So if we put credibility aside, because I hear Your Honor, and I won't continue to belabor the point, then we just have the basic question of whether this is probable.
Then if you want me to decide that, give me the entirety of the real estate transaction.
I can do that. I have the bill.
No, I don't want just the bill of sale.
Okay.
I want to know who occupied the premises in 2017. I'm going to want to know everything. That would be the witness that would have to come forth and say, well, if she's saying it occurred here, we resided in the premises at that point.
Can we keep
that
it open?
Would be something.
Can we keep it open instead of
open.
The preliminary exam, instead of ending it today, so that I can come forward with such a witness?
I just do not see how this lends itself to the probable cause finding. Michigan criminal jury instructions 3.10A, time and place venue for criminal sexual conduct place cases. Prosecutor must prove beyond a reasonable has occurred within Washtenaw County. Time, however, is not an element of the crime of criminal sexual conduct. Prosecutor does not have to prove the date or time of the offense beyond a reasonable doubt. So yes, Ms. Hamill was pretty certain she was 16, 17. Well, the charge is between 16 and 18, so we're still there. It was in Washtenaw County, whether that was when she was 16 or 17. That's for the finder of fact, but not probable cause that this happened. Maybe she doesn't know or remember her exact age, but she certainly remembers the details of the defendant sexually assaulting her at his home in Washtenaw County. So I think I have met the burden of probable cause, and we are talking about things that are frankly irrelevant to the finding of probable cause.
Your Honor, the charging document does have a place, the Blue Jay address, which she reiterated, and the quote we just heard didn't mention place. And the place, this was a charge that something happened in a place, in a particular time. And even if we can grant some sort of leeway about time, if it didn't happen in that place, because I can present evidence for the court that my client didn't live in that place in the year when she swore it happened.
Well, okay.
I'm arguing that that's actually incorrect. I did say place. I said the prosecutor was proved beyond a reasonable doubt that the crime occurred within Washtenaw County. And as part of my motion, I'll amend the date range. I'll amend the location and say Washtenaw County. And then that clarifies the record and the charging document.
I acknowledge she can amend. I don't think the witness's testimony can be amended. I understand you find her credible. I think I've said all I need to say, and I think the court's going to.
But where, you've also asked me for a continuance.
Yes.
To provide what may be proof that somebody else resided in the premises. So if that's the case, and let's say somebody comes in and says, in 2017, we resided at these premises, Mr. White is nowhere around those premises or not. She is still saying that. I'm not here to resolve that issue. Am I? I would have to believe one as opposed to the other. I would have to be sort of that ultimate fact finder on that, and I don't think that I can. If that's an issue, it has to go to the ultimate fact finder, which would be a jury.
My response is that it's possible. It's just not plausible. It's not probable. And as such, it shouldn't constitute probable cause. The whole point of this proceeding is to protect defendants from sitting through a trial when it's not probable or plausible that they committed a felony. And I think I've done enough to raise enough questions that at this stage, they don't have it.
And I say you haven't. The only thing that you've done is put into question one piece of her testimony in terms of the exact location. But if you think you nailed that shot, I've said you haven't, because I don't have the entirety of the transaction. I don't know who was at that house in 2017. I have one witness that tells me there were two people at least in that premises in 2017.
Are you resting? Yes. I have said in my piece, Your Honor, in response to your questions, and I'm not putting forward a witness at this time. I would ask for continuance to establish who was living in the house in 2017 at Blue Jay. But if the court finds that ultimately that doesn't matter.
I didn't say that it wouldn't matter. I haven't seen everything. The only thing you showed me is a conveyance that that could mean a gazillion different things regarding that real estate transaction. That's all I have. So, I mean, I'll be fair to both sides. If the people were to ask for additional time to provide something, fine. And the people can amend or do what they need to do in furtherance of their case. If you want more time to bring, how much time do you need to get me something in terms of what you're claiming is his real estate transaction? I'm just going to tell you, it may not in the end matter, but I'll give you the time to put it before me.
Thank you, Your Honor. We're coming up to August. Do you want 30 days? What do you want?
What does she want? What do you mean? What does she want?
No, I mean, I thought we could just do this cooperatively. I don't know. I don't know what witness I'm going to.
I don't know if I'm gonna also need to recall the victim to clarify information and like she testified to.
I hear you. And all I can say is this. She has testified to what she's testified to. If something needs to be clarified, I certainly would give the people the opportunity to do that. But what I don't, so certainly there's that. But I have, like I said, this one piece of a real estate transaction that I'm supposed to draw some conclusion to, which I'm going to decline because I have an issue even admitting this. I mean, I'll admit it. Well, I'll admit defendant's exhibit A, and I'll admit it, but it's only to show the court the conveyance, the date of the conveyance. Specifically, it does not show me who resided on those premises on any date. This doesn't tell me that.
We could do a 30-day adjournment, but I understood the people as being concerned that they may need the complaining witness, and the complaining witness is about to have a child, and we of course would understand.
I guess I just don't understand what the defense is going to provide that is going to overcome the jury instruction. That I don't have to prove the time.
I know. I hear you. And all I am saying is it may get there where I have this entire real estate transaction and it means nothing. in terms of it may not mean anything, but I haven't seen it. I mean, all I know is that this conveyance occurred sometime in September 2018. But probably one of the examples I can give is he's renting the premises for 2 years prior to buying. I mean, there's a lot of things that could happen.
Also a possibility though that he lived in and that it happened at another location in Washtenaw County. Haven't I still met the burden then?
Oh, absolutely. You would still have the burden if it occurred someplace else in Washtenaw County. But
I understand what you're saying, Your Honor. I mean, I'm going to object to a continuance based on, I believe I have presented probable cause and.
objection so noted, but I'm going to adjourn it anyway. I'm going to do what I think is right and let everybody put forth what they need. All right. Well, I'm going to go to the August 19th date, I think, is where we'll put this. Another day like today. Oh, joy. And if you need to call back the alleged victim, and I am hoping everything goes swimmingly and smoothly with regard to the birth of her child, but for whatever reason there's an issue, get in touch with Ann and we'll work around whatever we need to work around.
And we'll be agreeable, of course.
Yeah, on this one, why don't okay. I'm going to set it at 3 p.m. on that day.
I have the jury trial starting on the 18th.
Yeah.
Sorry.
No, it's okay. What?
Our next date is September 9th.
That baby will have graduated by then. Okay. All right.
That works for us, Your Honor.
September 9th?
Yes.
Ms. Willingbrink?
That's fine, Your Honor. Thank you.
September 9th, and that's a morning start.
Yeah.
But I'm going to set it at 11. So preliminary examination will continue to, let's say, September 9th.
Yes, sir.
September 9th, 2025, 11 a.m. for continuation before me. Thank you.
If we desire to recall the victim or the complaining witness, are we allowed to do that, or are we only allowed to continue this for the purpose of this particular a witness who could prove that he wasn't living at that particular address?
What would be your purpose in recalling?
Well, the people have today suggested for the first time that they would like to prove their case, even if it's not on Blue Jay. However, the witness.
They don't, but for these purposes, Mr. Knock, they don't have to show the specific address.
No,
they just have to give me even a time. I mean,
let me finish, Your Honor, please.
They're not doing something different.
I know that, Your Honor, in the recordings that when she was interviewed by Detective Morrison and the other officer, she was crystal clear about the guest room being across from the master bedroom. She described the layout of the Blue Jay house. It does not fit a layout of any other house he's lived in. She was very precise.
Okay, you tell me all of that. I don't know that.
But
you're just telling me things that are self-serving for the defense. I don't know that.
No, I know that, Your Honor. You just asked me why would I want to call her back. And if I'm now learning today for the first time, they're going to say, well, it doesn't matter if it's Blue Jay. It could have been somewhere else. I want to say her testimony, which I didn't get into, because she said it's absolutely Blue Jay every time. So I didn't want to keep her up longer than I had to. But I have to get into that now that I understand.
Have her available September 9th so I can end this conversation. Just have her available, and then he can call her if he needs to call her. Let's just do that.
Okay, thank you.
Am I finally done with this one?
Thank you, Your Honor.
I'll take it as a yes.
May bond continue, Your Honor?
You keep talking, no, but yes, bond will continue. How many more do I have? Two. Who's up next? No. I know. That's why. Yeah, I know. Who's?
It's Blondie and Mr. Drupas on King and Mr.
It's Blondie and Drupas?
Yeah.
I'll take Jolly.
I have a
You got what?
It's 1 o'clock.
Okay, give me a couple minutes. My head hurts right this second. I'll come back out and we'll do that one because Miss Lundy will whine. Because where's, yeah, okay, you call it that. Where's Jervis?
Oh, my gosh.
Oh, hey, you're quiet. Okay, I'll be back. We'll do that eventually. Kids in recess.